Good morning and welcome back to the Law News Network. I'm your host, Jesse Weber, and thank you for joining us. So I want to do a rundown of what we have planned for today. So at 2 o'clock today, we are actually going to be having the sentencing in the Michelle Carter case. I'm sure many of you are familiar with this case. This is the case out of Massachusetts of 20-year-old Michelle Carter, who was convicted of involuntary manslaughter, for pressuring her then 18-year-old boyfriend, Conrad Roy III, to commit suicide through a series of texts and phone communications. Now, this is a novel case. This is a case we've never seen anything like it before. We've never seen a case, really, where there's been a conviction for involuntary manslaughter through text messages and phone calls. So, what we have today is the sentencing of 20-year-old Michelle Carter. She could face up to 20 years in prison. However, many people are saying that because she is out on bail currently and because she was a youthful offender, she might not receive that much jail time, if jail time at all, and we might see more of a punishment in the form of rehabilitation. So we're not going to want to miss that. That's around 2 p.m. We're going to be covering that, and we'll have a lot of analysis maybe beforehand, but definitely after we hear the judge's sentence in that case. And again, this is a case of first impression. We've never seen anything like it, and it will determine later on in the future of the legal profession about what it means to be found guilty of involuntary manslaughter and what activities constitute that act. Another case that I want to bring to your attention, it's a new case that we have here on the Law News Network. It's going to be starting about any minute now. This is out of Florida. This is a quadruple homicide case out of Florida. It's the case of Henry Segura. Segura is actually on trial for the murder of his girlfriend, Brandy Peters, and her 3 children, Tamia Peters, 6 years old, Tania Peters, another 6-year-old, and Javante Segura, 3 years old, who was actually Henry Segura's own son with Brandy. It's a horrible case, terrible to even talk about. But this case is actually 6 years old, and it's going to go to trial after this 6-year delay. There was actually 9 delays in this case due to procedural and evidentiary issues. So we're finally going to be having a trial of this man, Henry Segura. And actually, it was only a few months ago that his lead attorney, Chuck Hobbs, had to actually step away because of a conflict of interest. So this case kept getting put on hold, but we're going to be finally having a trial now. There was jury selection. We're going to be having opening statements any minute now. It's supposed to start at 8:30 Eastern Standard Time, so we're going to be turning to it the minute we have it. But just to give you a little background about this case, the neighbors had actually found blood on the front door of Peter's home on the morning of November 20th, 2010, and they had called police, who discovered the 27-year-old mother beaten and shot to death 7 times, and the children's bodies were actually found stacked in the bathtub, and one of the girls had been shot, and the siblings were drowned. Now, the investigators spent a year investigating this crime, trying to figure out who might have done this, and they eventually arrested Segura at his lake house in Minnesota, where he lived as a certified welder. Now, the day before this, a Leon County grand jury indicted him on murder charges, and the theory here is that Segura killed Peters and these 3 children over $20,000 in back child support he was ordered to pay. Now, you might think that this is the end of the story. Well, the defense isn't going to say that at all. What we actually have here is the defense putting on a case that it might not be Segura who's the culpable party here. Because, in fact, it might be that Peters, and the theory is, was involved in a drug cartel, and it was a drug cartel gone bad. The idea was that his involvement in the murders had been questioned because there was a partial DNA match found at the scene of the crime, and it's been linked to a Colombian national named Angel Avila Quijones, who's now living in Italy, and he worked for Los Zetas, the same Mexican cartel that Peters allegedly worked for. Now, the DNA evidence here was revealed in 2015 after state forensic investigators sat on it for 2 years. Now, during a pretrial hearing this last week, James Carlos Santos, who's a Vice Lords gang member, he claimed that he, from prison, ordered Peters and the children to be killed because she was skimming cash while working for a drug-running cartel. Now, this is the theory that the defense is going to put forward, and the judge actually ruled in this case that Santos's testimony, part of it, because some of it's a lot of hearsay and we can't be admitting that, but some of it, the idea of why he claimed that he ordered this murder, will be allowed into testimony. So the defense is going to present this theory to the jury that in fact this might have not been Segura's doing, but because of a drug deal gone bad or because of a Mexican cartel, that's what this crime is all about. Now, whether or not we actually believe this DNA is linked to a Colombian national, that might not be the issue here, because the idea that there was other DNA in that crime scene might be enough to show that there's reasonable doubt that Segura is the responsible party. So there's a lot of factors here in this case. Again, we're going to be turning to it any minute, and as soon as we have something, we will turn to it. Finally, we are also going to be continuing our coverage of the Joshua Gaspar case out of Ohio. Now, just to reiterate this case, I know we've been following it here on Law News Network. Gaspar is charged with aggravated vehicular homicide for allegedly striking and killing Ohio State Trooper Kenneth Velez on September 15, 2016, while driving under the influence. Now, he's not accused of being drunk. Rather, the DUI charge stems from him having methadone in his system due to treatment he had received just minutes before the accident. So in addition to charges related to driving under the influence, he's actually also facing additional homicide charges for allegedly driving recklessly, because immediately prior to the accident, Gaspar was allegedly driving 65 to 70 miles per hour on a road with a speed limit of 60 miles per hour. And he actually had to swerve when the car in front of him stopped short. He's also charged with driving with a suspended license. Now, we're going to be continuing that coverage. I believe it's going to be covering back at 9 a.m. But as soon as we do have the Segura case, we are going to be turning to it. But in the meantime, in anticipation of Michelle Carter's sentencing later on today, I want to actually play for you the judge's decision in this case. It took the nation by storm. Everybody was watching. Twitter blew up. Our whole system blew up because everybody was watching this case. And the judge did find Michelle Carter guilty of involuntary manslaughter. But in order to understand the sentencing later today, we have to first start with the ruling. So let's take a look at that ruling from the judge, and as soon as we have activity in the Henry Segura courtroom, we'll make sure to turn right back to it.
Should there be any breach of that decorum, you can expect that there will be a harsh response from this judge. The law does not require that any explanation as to a verdict be given when the judge is the fact finder, unless a request for rulings has been made, and that has not been done in this case. Nonetheless, I am of the opinion that some explanation of my verdict is warranted. My comments that follow should not be construed as a complete explanation of my findings as to the facts, my deliberative process, or all of the law that has been analyzed and applied by me to the facts as I have found them to be. Rather, they are provided to you to provide some context for the decisions that have been made. I have essentially divided the evidence in this case into three components. The first component comprises roughly the period of June 29, 2014 through the ending of the text messages between Ms. Carter and Mr. Roy on or about July 12, 2014. The second period commences immediately thereafter and encompasses primarily the phone conversations and activity occurring until occurring from the ending of the text messages through July 13th, 2014. But that area of evidentiary consideration is strongly informed by all of the other evidence in this case. The third period is all of the evidence not encompassed in those two areas that I have just described. This court first finds that the Commonwealth has proven beyond a reasonable doubt that the actions taken by Ms. Carter as to the period from June 30th to July 12th constituted wanton and reckless conduct by her in disregard and serious disregard of the well-being of Mr. Roy. The Commonwealth has not proven as to that time period that said reckless or wanton behavior caused the death of Mr. Roy. It is apparent to this court in reviewing the evidence that Mr. Roy was struggling with his issues and seeing a way to address them, and took significant actions of his own toward that end. His research was extensive. He spoke of it continually. He secured the generator. He secured the water pump. He researched how to fix the generator. He located his vehicle in an unnoticeable area and commenced his attempt by starting the pump. However, he breaks that chain of self-causation by exiting the vehicle. He takes himself out of the toxic environment that it has become. This is completely consistent with his earlier attempts at suicide. In October of 2012, when he attempted to drown himself, he literally sought air. When he exited the truck, he literally sought fresh air. And he told a parent of that attempt. Several weeks later, in October of 2012, again, he attempts, through the use of pills, to take his life, but calls a friend and assistance is sought and treatment secured. That Mr. Roy may have tried and maybe succeeded another time after July 12th or 13th of 2014 is of no consequence to this court's deliberations. Although some have suggested for this case that the legal principles involved are novel, that is not accurate. Approximately 200 years ago, a man in Hampshire County in the Commonwealth of Massachusetts, an inmate at the Hampshire jail, was charged with causing the murder of the man in the next cell. The case is Commonwealth versus Bowen. The law was different in those days, but some of the similarities existed. The person who ended up taking his life in the Bowen case was named Jewett. Jewett, in fact, hung himself in his jail cell approximately 6 hours before he was to be publicly hanged for killing his father. Whether Mr. Roy, in this case, would have taken his life at another time does not control or even inform this court's decision. In the Bowen case, where they referred to Mr. Jewett, the person who took his life, as the culprit, the court writes, "The culprit, though under sentence of death, is cheered by hope to the last moment of his existence." Returning to this case, when Ms. Carter realizes that Mr. Roy has exited the truck, she instructs him to get back into the truck, which she has reason to know is or is becoming a toxic environment inconsistent with human life. She is mindful that the process in the truck will take approximately 15 minutes. Whether that is a true fact is not relevant. What is relevant is that that is her state of mind based upon a text exchange between she and Mr. Roy during the period of June 30th to July 14th. She instructs Mr. Roy to get back into the truck, well knowing of all of the feelings that he has exchanged with her, his ambiguities, his fears, his concerns. This court finds that instructing Mr. Roy to get back in the truck constituted willful and wanton and reckless conduct by Ms. Carter, creating a situation where there is a high degree of likelihood that substantial harm would result to Mr. Roy. Ms. Carter knows, through her own admission, that Mr. Roy has followed her instruction. As she indicates in various text messages subsequently created to some of her friends, she indicates that she can hear him coughing and she can hear the loud noise of the motor. The court notes that I looked for independent corroboration of some of the statements that Ms. Carter made to make sure that there was no undue reliance on any one source of evidence. The photos taken at the scene of the crime, where Mr. Roy's truck was located, clearly illustrate the location of the water pump immediately adjacent to where he would have been sitting in the truck next to his upper torso and his head, thereby giving a good explanation to Ms. Carter's definition that the noise was loud within the truck. Ms. Carter, at that point, therefore, had reason to know that Mr. Roy had followed her instruction and had placed himself in the toxic environment of that truck. At this point in the court's analysis, the court took direction from a case, Commonwealth versus Levesque. In Commonwealth versus Levesque, it is indicated that where one's action creates a life-threatening risk to another, there is a duty to take reasonable steps to alleviate the risk. The reckless failure to fulfill this duty can result in a charge of manslaughter. Knowing that Mr. Roy is in the truck, knowing the condition of the truck, knowing, or at least having a state of mind, that 15 minutes would pass, Ms. Carter takes no action in the furtherance of the duty that she has created by instructing Mr. Roy to get back into the truck. She admits in a subsequent text that she did nothing. She did not call the police or Mr. Roy's family. She knew his location, again, according to a text that she sent, as being at the Kmart Plaza. According to one of her emails and other credible evidence, according to other credible evidence, the police officers who testified, the location where Mr. Roy's truck was located was approximately 1/2 mile from the Public Services Office of Fairhaven, which included both the fire department and the police department. She did not notify his mother or his sister, even though just several days before that, she had requested their phone numbers from Mr. Roy and had obtained them, and had opened a line of communication with Camden Roy on, I believe, July 10th, but just a few days before the events in question. She called no one. And finally, she did not issue a simple additional instruction: get out of the truck. Consequently, this court has found that the Commonwealth has proven beyond a reasonable doubt that Ms. Carter's actions and also her failure to act, where she had a self-created duty to Mr. Roy, since she had put him into that toxic environment, constituted each and all wanton and reckless conduct. And this court further finds that the Commonwealth has proven beyond a reasonable doubt that said conduct caused the death of Mr. Roy. This court does not find that the intentionality necessary for such wanton and reckless conduct is obviated by Dr. Bregan's theory of involuntary intoxication, in that the court did not find that analysis credible. Ms. Carter, please stand. This court, having reviewed the evidence and applied the law thereto, now finds you guilty on the indictment charging you with the involuntary manslaughter of the person Conrad Roy III. This court further finds that the Commonwealth has proven beyond a reasonable doubt that you are a youthful offender and you are a judge sole at this time. You may be seated. That verdict is now recorded and it is in writing as well. Commonwealth, do you wish to be heard?
The Commonwealth moves for sentencing, Your Honor.
Pardon me?
The Commonwealth moves for sentencing.
Sentencing is not appropriate at this time. Chapter 119, Section 58 requires that a pre-sentencing report be prepared and given to the judge before sentencing can be imposed.
Understood, Your Honor. With that, the Commonwealth would ask that Ms. Carter's bail be revoked and she be taken into custody.
And the basis for that request?
She's now been convicted of a felony, and clearly she's a danger not only to others, but based on the testimony, to herself.
All right. Thank you. Mr. Cataldo, Mr. Madeira, do you wish to be heard on the Commonwealth's request?
Yes, I ask you not to revoke the bail, Your Honor. This case has been pending for a couple of years now. She showed up each and every time. She's obeyed the conditions, all the conditions that she had of her release, and I do not think that the evidence shows that she is a danger to the public if she's released.
Mr. Cataldo, are you willing to inquire of your client as to whether she has a passport?
Yes, one moment, please. No, she does not have a passport,
all right,
Your Honor.
The court notes that, as Mr. Cataldo points out, this case has a long history. To my knowledge, Ms. Carter has never failed to appear. When she was interviewed by the police at the King Philip Regional High School, she was cooperative with that interview. She's cooperative with allowing the police into her home. I believe that revised conditions of bail release will suffice to secure the concerns of the Commonwealth, as well as to allow for the completion of the sentencing report before it is done. Consequently, Mr. Cataldo, assuming that your client accepts the following conditions, I will allow her to remain on bail. She will have no contact with any member of the Roy family or any of the witnesses who have testified in this case. And by no contact, obviously I mean no texting, no Facebook, no Snapchat, none of those things that provide for any type of direct or indirect communication, including, of course, anything through a third party. She shall not apply for nor obtain a passport. She shall not leave the Commonwealth of Massachusetts except by further order of this court. But I do not restrict that to just me in the event I am not available. A request may be made of any judge who is sitting here in the juvenile court. Commonwealth, recognizing the court's position on this, do you have any other requests as to additional bail conditions of release?
No, thank you, Your Honor.
All right. Okay. I'm going to ask that the probation sentencing report be provided by July 21st. Can that be done?
Yes, sir.
Thank you very much, Ms. Taylor. I want the attorneys to understand that it is the position of this judge that sentencing reports prepared by the probation department are for the judge. In fairness, since I give them careful reflection in coming to a sentencing determination, I will allow the attorneys as well as any necessary individuals within the district attorney's office, to be provided with one copy that may be read by those individuals that I have just identified, and that Mr. Cataldo, you, Mr. Madeira, and your legal defense team may similarly be provided with one copy. It is not a public document. It is not filed with the clerk's office, and there is no public access to that document. So you are prohibited from disseminating any of the information contained in that sentencing report to any individual other than within your own defense or prosecution team. Now, that being done on July 21st, I would like to see if we could schedule a sentencing hearing, perhaps for the week of July 31st, subject, of course, to the respect that I have for people's vacations, or the first week in August.
August 3rd, please.
I'm sorry, August
3?
What day is that? I don't have
Thursday.
Thursday? Is that okay, Madam Clerk?
That's fine, Judge.
All right. Then this matter will...
And welcome back to Law News Network. I'm Jesse Weber. You were watching the verdict in the Michelle Carter case. Now, why are we bringing this up? Because later on today, we're actually going to be getting the sentencing in the Michelle Carter case. And as you heard from that clip, the judge in that case ruled, and that was a bench trial. There was no jury. He ruled that Michelle Carter was guilty of involuntary manslaughter for pressuring her then-boyfriend, Conrad Roy III, to commit suicide. Now, when you were listening to his analysis, it was that Conrad Roy III broke that chain of causation from his suicide. It was, specifically when Michelle Carter urged him to get back into that truck when he had left that truck. That is what recklessly caused the death of Conrad Roy III. So later on today, we're going to actually be hearing the sentencing. And as we said earlier, Michelle Carter faces up to 20 years in prison for involuntary manslaughter. But considering that she is a youthful offender, considering that she has been on bail since this conviction ruling, it's possible she might just see a rehabilitation punishment. She might not see any jail time. But stay tuned to that. We're going to be covering that. Again, as we spoke about earlier, there's another case that we're going to be covering here on Law News Network. It's the case of Henry Segura out of Florida. This is a quadruple homicide. He's charged with the deaths of four individuals: Brandy Peters, his girlfriend, and their 3 children: Tamia Peters, Tania Peters, and Javante Segura. So Javante Segura was 3 years old. Tamia and Tania were 6 years old, and Javante was actually his own son with Brandy. We're going to be hearing the opening statements in that case out of Florida. As soon as we get a live stream for that, we're going to be covering that. But again, we are also going to be covering the Joshua Gaspar case out of Ohio. This is a case we have been already covering here on the Law News Network. It's out of Ohio. Gaspar is charged with aggravated vehicular homicide for allegedly striking and killing Ohio State Trooper Kenneth Velez on September 15th, 2016 while driving under the influence. But this is not about Gaspar being drunk. Rather, these are DUI charges that stem from him having methadone in his system. Now, this was due to a treatment he had just received minutes before the accident. So, in anticipation of the Gaspar trial coming back today, I actually want to turn to the testimony of Dr. Richard DeFranco. Now, this is the doctor who gave the defendant methadone, and he explains the methadone to the jury. And it was the defense's theory that this individual, Joshua Gaspar, was not under the influence when he drove that vehicle. Instead, the idea was that methadone couldn't do this. So this doctor's testimony is crucial to the defense's case. So I think we should turn to it. And let's turn to this testimony, and we'll be back here with analysis or live coverage as soon as we have it. So let's now turn to the testimony of Dr. Richard DeFranco in the Joshua Gaspar case.
This is an article where they took 5 patients who were on methadone, gave them their dose of between 100 and 120 milligrams of methadone, and then measured their plasma levels at 1, 2, 4, 6, 8, 10, and 24 hours, and then try to determine how quickly the methadone plasma level went up after their dose.
Okay. Does it basically agree with the statement you just made that peak absorption occurs 1 to 2 hours after ingestion?
Well, the study is only looking at 5 individuals, but according to this, it seems that the peak is a little later, maybe 3 or 4 hours.
Okay. You agree that the graph shows the blood plasma level begin to rise at the 0, the vertical left line, so that's the point of ingestion. So it becomes detectable in the blood plasma immediately or shortly after ingestion?
Well, actually, in this study, these patients were on methadone already, so at time 0, their blood level was pretty significant.
Okay, but it still demonstrates a rise in the graph.
Not in all cases. For example, the first subject listed, in 1 hour, his blood concentration went from 0.73 to 0.70. So that one fell. The next 2 went up. The 4th one fell, and the 5th one went up. So.
Okay. So that also speaks to the variability of physiology that you talked about a few minutes ago.
Right.
Okay. Methadone hydrochloride is the generic or the actual drug name that can then be branded under various other manufacturers' specific labeling, correct?
Yes.
Okay. So in the methadone clinic setting, when we talk about methadone, we're talking about the drug methadone hydrochloride, regardless of the brand name.
Yes.
And you said that Ohio, in the clinical setting, is a liquid administration state. Is that correct?
Yes.
And the clinic is open 7 days a week.
It was when I was there, yes.
Okay. So, for everyone's understanding, then, if you're in the program, in this program, are you required then to attend daily to receive your prescribed dose?
Until you earn take-home doses, yes.
And how does that come about?
Well, if we feel it's safe to give people take-home doses after a certain number of months, according to the state and federal regulations, we can allow them to take anywhere from 1 day a week to 6 days a week, or even 13 days every 2 weeks home.
Yeah. May I approach it?
Yes.
I want to show you several photographs. They're 1443, 1444, 1445, and 1446. Tell me if you recognize what's depicted in each of those.
These all seem to be photographs of a bottle of methadone hydrochloride, similar to the ones that we sometimes use at the clinic.
Okay. And we've all received prescriptions where you get the box and there's that folded up piece of onion skin paper with all that tiny print that's tightly bundled and attached to the box. Is one of those on that big bottle there?
Yes, it is.
And in medicine or pharmacology, that's called the package insert, correct?
Yes.
What's described in the package insert?
Well, the characteristics of the drugs, the side effects, the clinical uses, some of the pharmacology. There's quite a bit in there. Yeah.
Okay. The intended therapeutic effect would be one topic, correct?
Yes.
In medicine or pharmacology, when we talk about a contraindication, are you familiar with that term?
Yes, I am.
Define it, please. What is a contraindication?
A contraindication may be a characteristic of the patient that would make whatever particular medication you're thinking of using have some deleterious effect. There's sometimes maybe medications we use that could be harmful, but we have to make judgments about risk and benefits. So if a medication, for example, if someone had a cancerous tumor, we might give them chemotherapy that would make them quite sick. However, our hope would be that the beneficial effect of helping their tumor regress would be greater than any harmful effects. So contraindication, there's relative contraindications, which means that, well, if the patient has this or that characteristic, you might want to think about this harmful thing that could happen if you use this medication, and compare that to the benefits you expect from the treatment.
The package insert contains other areas of either cautions, notice of potential adverse effects, and then also warnings, does it not?
Yes.
Tell us a little bit about each of those topics. What might they cover?
Well, basically, they're discussing various degrees of contraindication.
So, notice of potential adverse effects would be what? On the subject of methadone.
You mean what would some of the adverse effects be? Perhaps constipation, lack of libido, problems with sexual functioning, problems with sleep.
Okay. Still called, what the layperson might call a side effect.
Yes.
Okay. What is a warning?
Well, a warning would be a more serious contraindication, I suppose you could call it.
Okay. And, let's get right to the point here. One of the obvious and typical ones would be do not attempt to operate machinery or operate a motor vehicle while on this drug. Is that a sometimes listed warning? In general terms, for any drug.
I imagine that warning exists, yes.
And then what is a black box warning?
A black box warning would indicate the most severe class of these contraindications.
Okay. And the purpose of making it a black box is to make it front and center to everybody's attention that this needs to be considered as a potential worst case event.
Yes.
I want to show you, if I may approach, Judge. States 1447. Can you take a moment and look at that, please?
Well, to be honest, with the state of my eyes, I'm not able to read much of this, but
That type of thing before?
yes, I've seen this before.
What does it appear to be?
Oh, this appears to be the document that we were talking about, the folded up paper document on the side of the methadone bottle.
The package insert.
The package insert, yes.
And the title reads methadone hydrochloride. Would you agree?
It does, yes.
Okay. And right after, it goes into the technical details. It's methadone hydrochloride, oral concentrate, USP, 10 milligram per milliliter, dye-free, sugar-free, unflavored, and methadone hydrochloride, oral concentrate, USP, 10 milligrams per milliliter, parens cherry, closed parens, for oral use only, RX only. Would you agree that that's the title?
Probably, yes.
Okay. Immediately following the title is one of these black box warnings that we just discussed, is it not?
Yeah, I'm going to object. I'm not sure you can see that.
Yeah, I'm really having trouble. It's perhaps my bifocals. I'm sorry.
It's a great copy.
Can we, I believe we can enlarge it on the monitor.
Okay, you can't have to give me that one.
All right, it's very difficult to read. It is legible because it's barely, so
Can we enlarge it on the monitor?
if you don't, you won't be able to testify.
That's what I intend to do.
Yeah.
And then if he needs to adjust his position, or we'll adjust it.
Move the monitor pass forward.
Yes, sir. where you're sitting and where you're pulling forward. I think a little bit.
Yeah, I can see that, yes.
All right. Are you able to read the black box that I brought up on the Londo pad?
Yes.
Okay. Can you read it for me, please?
Deaths have been reported during initiation of methadone treatment for opioid dependence. In some cases,
Slow down, please.
drug interactions with other drugs, both licit and illicit, have been suspected. However, in other cases, deaths appear to have occurred due to the respiratory or cardiac effects of methadone and too rapid titration without appreciation for the accumulation of methadone over time. It is critical to understand the pharmacokinetics of methadone and to exercise vigilance during treatment, initiation, and dose titration, dosage, and administration. Patients must also be strongly cautioned against self-medication with CNS depressants during initiation of methadone treatment. Respiratory depression is the chief hazard associated with methadone hydrochloride administration. Methadone's peak respiratory depressant effect typically occur later and persist longer than its peak analgesic effects, particularly in the early dosing period. These characteristics can contribute to cases of iatrogenic overdose, particularly during treatment initiation and dose titration. Cases of QT interval prolongation and serious arrhythmia, torsades du pointes, have been observed during treatment with methadone. Most cases involve patients being treated for pain with large multiple daily doses of methadone, although cases have been reported in patients receiving doses commonly used for maintenance treatment of opiate addiction.
Okay. So like basically all drugs, when properly administered, methadone is a safe and effective treatment for opioid addiction and the management thereof. You would agree with that, right?
I would agree.
Okay. But again, there are inherent dangers based on the chemical class of what methadone is. It's an opioid, and it carries the same risks as any other opioid.
Yes.
And let's define some.
Welcome back to Law News Network. I'm your host, Jesse Weber. You're watching the testimony of Dr. Richard DeFranco in the Joshua Gaspar case. This is a case we are covering here on the Law News Network, and we believe it's going to be starting any minute now, along with the Henry Segura trial out of Florida. But as soon as we get the Henry Segura live feed up, we're going to be turning to that. But in the meantime, I'm joined today by Law News' senior editor and former prosecutor, Ron Blitzer. Ron, great to see you as always.
Good morning. Great to see you too.
So many cases to talk about today, but I think I would be remiss if we didn't talk a little bit about Michelle Carter, the sentencing, which we will have in that case later on today. I believe it's going to be covered by Aaron Keller at around 2 p.m. I want to talk a little bit about the Michelle Carter case. We've seen ups and downs, a lot of things about this case. It's breaking new ground in terms of criminal law. But what we see today is a lot of analysis about what she's going to be sentenced to. Will she be given an adult sentence and sentenced to the maximum of 20 years in prison? She was charged as a youthful offender. Will she be sentenced to a Department of Youth Services until she's the age of 21? Will there be probation? Will it be a combined sentence? I'm curious what your thoughts are on what her sentencing will be.
My personal opinion about, maybe not what it will, but what it should be is on the lower end of this. I think she should be considered a youthful offender. She was in high school at the time that this happened. But on top of that, she didn't kill her boyfriend. She encouraged it. What she did was horrifying and awful. But when it comes down to it, this was a suicide. It was an encouraged suicide. It was a really troubling situation all around with Carter, sending text messages, saying do it, after her boyfriend said that he wasn't going to go through with it, he was attempting to kill himself in a vehicle, and then told her that he had stopped and couldn't go through with it, and she said, no, get back and do it. It's disgusting, and I think justice will be served to a degree with her facing consequences for it. However, to convict someone of manslaughter for this in the first place is controversial. So I think to have an excessive sentence on top of that would be surprising.
Well, the judge in this case, when we heard his ruling, he said this isn't novel ground, this isn't new ground, and he cited a case from 200 years ago. So it was his belief that he's not doing anything out of the ordinary, but if you look at any other legal scholar, you look at anybody who's trying to analyze this case, they say it is new ground. We've never seen anything like it. So the idea, maybe that he would, I agree with you. A part of me was like, he's going to convict her, okay, but then to sentence her to the maximum might have been too much to handle. But I'm curious because we are going to be hearing some some statements made by the family of Conrad Roy III today during the sentencing. And I believe Kim Bosey, who's Roy's aunt, said 20 years may seem extreme, but it's still 20 more than Conrad will ever have. That's a good point. The point is she was convicted of recklessly causing his death. So we have a 20-year punishment for involuntary manslaughter for a reason. Now, having said that, you do have somebody who committed this crime when she was 17 years old, and she has been out on bail since the conviction. Does that play in any way in your mind?
Yeah, I mean, she's been out on bail, so clearly there was no need to keep her incarcerated during this time. This is not a case of someone who's going to be a serial killer who is going to go out and commit further crimes. This was a specific situation. There was evidence during the trial that she was suffering from her own issues. These were two troubled teens that resulted in a tragedy. And yes, Roy killed himself, when after Carter pushed him into it, but there's a strong argument that if it didn't happen then, it would have happened another time, whether she was involved or not. To sentence someone who was a teenager, who was 17 years old, to 20 years over text messages, as horrible as they were, and they were terrible, I think is a bit extreme.
Yeah, so I think what you're saying, and I agree with you, is the sentence is going to be today to show that she deserves a punishment, to set an example, but not to, it's not draconian. It's not going to be so severe as if she was a mass murderer and she was a 17-year-old girl, as opposed to someone who has a violent history, who's dangerous to the community, and we might see a different result. Then again, who knows what we'll see today? Yeah,
I mean, if you have a judge pointing to a case from 200 years ago and acting like, that's plain case law, saying, oh, this isn't a novel issue, it happened 200 years ago. That's a little ridiculous. I'm not saying that he's totally wrong by saying that there's no link between the cases, but when your best support for your decision is a case from 200 years ago, it's a little tenuous.
They're going to appeal this.
I'm sure.
Yeah, this case isn't going away.
Yeah.
This issue is not going away. So we are going to be covering that again at 2 p.m. today, or around 2 p.m. But while I have Ron here, I want to quickly turn to his analysis of the Henry Segura trial, which is our new case that we are going to be covering here on the Law News Network. This is a case out of Florida, the quadruple homicide. Terrible case, such young children, a young girl, his young girlfriend as well. This case is 6 years old. We've had 9 delays. It was only a few months ago that Segura's attorney had to step out because of a conflict of interest. Have you ever seen anything like this, a case going on for this many years?
I haven't. You have 9 postponements, so many changes in attorneys and judges over something that at first seemed fairly straightforward. You have Segura, who is charged with murdering his girlfriend and her 3 children, one of them being a child shared by the 2 of them. These kids were 3 and 6. The 2 of them were, I think there were 6-year-old twins and a 3-year-old. The girlfriend was found beaten and shot. 2 of the kids, I believe, were shot and another was drowned. And there was plenty of evidence pointing to Segura. Another former girlfriend of his had told investigators that she had seen him a few days beforehand and that he was angry and made reference to needing a gun. There were shell casings found at his home. So there's plenty of evidence linking him to this. But then you have more evidence that comes out over the years saying, wait, maybe it was someone else. You have a partial match for DNA of someone else. You have what seems to be a confession by someone who said that he ordered the killings in prison due to a connection with a drug cartel, which, to me, reading about this, it, seemed to come out of nowhere. And now there's a question of, well, how much of that information is going to end up being presented to the jury? So there's a lot going on in this case. It's a lot more than what first it appeared to be. And I'm very interested to see where this is going to go.
Absolutely. I mean, let's talk a little bit about this other theory that the defense is putting forward. So yes, they do say they have evidence of a partial DNA match to someone else. Now, first, the idea is if it's anybody else but Segura, that could be enough to show reasonable doubt. But if they can link it to, and his name is, he's a Colombian national, Angel Avila Quijones, who's now living in Italy, and he worked for Los Zetas, which is the same Mexican cartel that Brandy Peters, the victim in this case, allegedly worked for. And there's this whole case, this whole kind of theory that she had skimmed money out on a cocaine deal. And that was the nature of these kinds of, this terrible situation, this terrible murder. And the judge in this case actually said that even though he understands that Santos, his name is James Carlos Santos, who's a Vice Lord's gang member, and he claimed that he ordered the hit on Peters, even though that Santos's testimony has been excluded by other judges in the past, he's actually going to allow how and why he ordered the hit and who Quijones is in relation to the cartel. All that information is going to be admissible, but everything else is going to be hearsay. Now, we've seen cases before, when I'm specifically talking about the Aaron Hernandez case, when Jose Baez put out a different theory on that could have been a drug deal gone bad, something else. Just putting that theory in the minds of the jurors and showing that there is some sort of doubt out there, could that be enough to get Henry Segura off? I mean, the case hasn't started, the trial hasn't started yet.
Yeah, I mean, absolutely. Depending on how strong the evidence is, this could totally end up being a win for the defense, because despite all the evidence against Segura, if you can convince a jury that the victim in this case was connected to a drug cartel and that there is credible evidence linking members of the cartel to her and a confession from someone connected to it saying that it was ordered as part of a cartel hit, that's a pretty strong alternative theory that would create, I think, more than just a shred of reasonable doubt. I think depending on what this evidence is and how much of it ends up going before the jury, it could be very effective.
Exactly right. The only flip side of it is it's so outrageous to even say that jurors might be like, we're not going to believe this. This doesn't make sense.
Exactly. Which is why it depends on how much evidence the jury's allowed to hear and how credible it seems. Because it does, like you said, it seems to be so way out there. You have this one theory of the case that this was a boyfriend who owed tens of thousands of dollars in back child support payments, who said that he needed a gun days before. He had reportedly lied to investigators about his whereabouts in the hours before the deaths. So that seems like your typical straightforward domestic violence murder case. But then you bring in this whole elaborate scheme of a drug cartel hit, and it's like, what? But if there's credible evidence, that could be all they need. At
the end of the day, it's for the jurors to decide which story makes more sense to them. That's what it is. That's what it is. Which story makes more sense to them. And as you said, a domestic violence incident like this, which is tragic to hear, which we hear happening all the time and we really shouldn't be, sometimes can make more sense to the jury as what happened here as opposed to some sort of, as you said, elaborate drug cartel situation gone wrong. The one part about this case I also want to talk to you about is, again, it's 6 years old. That's an advantage to the defense, wouldn't you say? Memories fade, evidence goes away. 6 years is a long, long time. Would you say that is an advantage to the defense as opposed to the prosecution?
It sure could be, because you're going to have officers who are testifying. You're going to have witnesses testifying in this case whose memories are going to be impeachable if they, if they seem to be a little too prepared. The defense could say, well, oh, wow, you remembered that much detail so many years later. Or if they're not as prepared, oh, well, their memory is faded, you can't rely on them. At the same time, then they also have the defense of, well, my memory is a little hazy because it was so long ago. That doesn't mean what I'm saying isn't true.
Exactly. Okay, Ron, last case I want to talk to you about really, really briefly before we turn back to our coverage of it. Before we cut in with Ron, we were actually looking at the testimony of Dr. Richard DeFranco in the Joshua Gaspar case. Now, this is actually the doctor who prescribed the defendant methadone, which is the big issue in this case, driving under the influence. We're not talking about alcohol. We're talking about methadone, which is what he was prescribed. The whole issue that the defense is putting forward is that he wasn't really impaired, that it wasn't a situation of impairment. But at the end of the day, even if that is true, couldn't he have been driving recklessly, which they also want to put down? So this is two separate theories. I want to first talk about the impairment. We're going to be turning back to the coverage of this case as soon as we have a live stream, but I will be turning back to the prior testimony of Dr. Richard DeFranco about the methadone issue. I'm curious about this impairment issue. What were your thoughts when you looked at his testimony?
I thought it was very effective. You compare it to the later testimony from yesterday from Sergeant Gable, who talked about why he thought Gaspar was impaired, about how he was speaking slowly, he seemed confused, he had constricted pupils. When he took field sobriety tests, while he sort of passed, there were also issues that made the sergeant think that he was impaired. But then you have the doctor saying, well, no, he probably wasn't impaired because methadone doesn't do that. And he's talking about how there have been studies shown that it's fine to drive while taking these substances, and that these types of impairments would not result in from methadone, especially not the dosage that Gaspar was taking. He was taking, I believe, 70 milligrams a day, which was an average dosage. The doctor saying how he's prescribed higher to other people, and that in his estimation, it would not cause impairment. So, the sergeant on the scene could say all he wants about what he thinks may have been the case, but when the doctor says, no, this is chemically highly improbable, that's a pretty strong defense argument.
I agree with you, and if they knock that out and then it's only left with reckless, that's going to be tough because according to the prosecution, they changed it. Gaspar was only allegedly driving 65 to 70 miles per hour in a 60 mile per hour speed limit. Now that is driving over the limit, but we're not talking about 100 miles per hour. We're not talking about 150. We're talking about 5-10 miles over the speed limit. At the end of the day, this could have just been an accident, a terrible accident, but an accident nonetheless.
Yeah, and earlier reports that I had read said that he had been driving much faster, but then, yes, I've heard since then that he was only a few miles per hour over the speed limit, not, crazy fast like, one might imagine or associate with reckless driving. And, he's in a situation where he's not going overly fast, he's, confused and startled while a car is passing in front of him, he stops short. He has a choice of either go onto the shoulder, which most people would probably do out of instinct, or drive into traffic, which most people would instinctively not do, and as a result, accidentally kills this trooper. What is more problematic for Gaspar is that there's a strong argument that he shouldn't have been on the road in the first place, because he had a license, but he's allegedly lied on his application for a license by failing to say that he already had his license suspended. So, I think there's a very strong case that he'll be found guilty of charges related to that, and the fact that he probably shouldn't have been driving in the first place, even if he didn't do anything wrong while he was actually on the road. Just being on the road really hurts him in this case.
Well, you're right. He shouldn't have been on the road in the first place, but will that be enough to convict him? We will see. Ron, thank you. We're going to be turning right back now to our coverage of the Joshua Gaspar case. But I want to turn, before we do that, I want to turn now to the testimony of Richard DeFranco. This next clip is basically, he's going to be continuing his analysis. This is where he talks a little bit about this methadone medicine. This is the next clip that we have right in the series of many clips that we have from Dr. Richard DeFranco. So let's turn a little bit now to his testimony. Well, as soon as we have a live feed in either the Segura or the Gaspar trials, we're going to be turning to it. But let's continue our coverage of Dr. Richard DeFranco.
Okay.
Yes.
How do you approach that subject? What are your concerns? What boundaries do you set? What's your management practice?
Well, my management practice is that patients on methadone maintenance therapy can thrive just as well as patients not on methadone maintenance therapy.
All right. Is that true in all cases of somebody receiving methadone, including, let's say, non-compliant individuals?
Well,
My question is there a line here somewhere where it's not appropriate to be driving on methadone?
I suppose you could think of a scenario where it was, but so yes, there could possibly be a scenario where it was unsafe to drive on methadone.
In what you're thinking of, tell us what you're thinking of. Where would that occur? Or how would that occur?
Well, I don't really know. It's the patients that I'm used to are patients who have been using short-acting opiates in high doses quite often. So when we start them on 20 or 25 or 30 milligrams of methadone, it's not enough to make them intoxicated. In fact, it's not enough to make them totally comfortable. And we do titrate them slowly. So I don't think there's a point where most patients would have difficulty driving. There have been studies of patients on opiates and patients on methadone driving, and that literature is also 50 years old. And it's well documented that people on opiates drive automobiles safely.
Okay. Would you agree that there is, I mean, you attend, I assume, as a practicing professional, yearly continuing education classes in your field of practice to maintain your license?
Yes, we do.
Okay.
Yes, I do.
And for somebody who's never attended one of these, it could be a half a day, it could be a day-long seminar, it could be a week-long seminar with various presenters, right?
It could be. It could also be online or reading the literature and so forth. There's lots of different mechanisms.
Right. I mean, like with the Ohio Bar, we can go online and view some material and certify that we've reviewed it and studied it, and then we get the credit for having done so.
Yes.
Same as attending the seminar, right? Or we can watch the taped performance. Same thing in medicine?
That's correct. In addition, I'm certified by the American Board of Addiction Medicine, and we have something called the MOC, which is Maintenance of Certification. So every year, in addition to our hourly CME, continuing medical education activities, we have articles that we read and answer questions and that kind of thing. So,
and at these seminars, you're presented with the state of medicine or medical knowledge and whatever recent developments may have occurred since you last attended a seminar. Isn't that one of the usual objectives, an update?
that is sure.
Okay. And they don't just say, okay, we're just going to look at Ohio medicine. You could have people from across the United States or even indeed international presenters from Europe or somewhere to say, okay, we did a study on methadone and here's what we found.
That's true.
Okay, and have you had that professional, personal experience?
Yes.
Okay. Would you agree or disagree with the following statement? Numerous European studies of long-term methadone maintenance patients have shown that appropriately administered methadone does not cause significant psychomotor or cognitive impairment when administered regularly and when the subject abstains from all other drugs.
That sounds true.
it's a positive statement of the benefits of a properly administered maintenance program, right? So you would agree with that statement?
Yes?
Doctor, is that your experience in the field too?
Yes.
Is your experience consistent with that statement?
Yes, that it's safe and it doesn't cause those problems you mentioned. Yes, that's my experience.
Would you agree or disagree with the following statement? However, in the majority of cases, patients did not exhibit stable abstinence from drug use and had an increased occurrence of simultaneous psychiatric/neurotic disorders or personality disturbances which, by themselves, could be a reason to doubt their driving ability.
Well, I don't know. I suppose somebody could have something else going on that would impair their driving ability. Is that what you're saying? Yes.
So that's what it's touching on.
Mm-hmm.
Maybe I'm going to object. I'm not sure what we're reading from.
I can readily identify. You objected to the document, so
The law enforcement document?
it's 1552.
I'll look at it. Yeah.
Welcome back to Law News Network. We are cutting out of that prior testimony to now turn to our live coverage of the Henry Segura trial out of Florida. This is the quadruple homicide, brand new case here we're covering on the Law News Network, 6 years old. Finally, we have a trial. Let's take a look.
Any questions, nor encouraged to ask large numbers of questions. However, if it will help your understanding of the case, you are encouraged to do so. As I indicated, the next thing to occur is the attorneys will be given an opportunity to give their opening statements. As I've also said, what the attorneys say is not evidence, and you should not consider it as such. However, I do encourage you to give them your careful attention. Opening statements are intended to give you an understanding of the evidence that the attorneys expect to present and the issues in the case. We'll start with the state of Florida. Mr. Hughes.
Thank you, Your Honor. Your Honor, can I ask you to turn on my speaker, please? Good morning, ladies and gentlemen. I'd like to start off by thanking you. I know, Artie, I thank you for when you were called for jurors and paying attention to myself and Mr. Prince through the jury selection process. As I mentioned back then, we obviously cannot do this without you. I'm thanking you now because you're no longer potential jurors. You are, in fact, the jury. You're selected by myself, my co-counsel, as well as Mr. Prince and Mr. Segura and his co-counsel, because we felt that you were the best to try this case, listen to us throughout the long trial that's before you. So I'm thanking you very much for doing so in advance, because I'm confident you are, in fact, going to do that. As the judge has explained, Your Honor, if you can put on podium 8, on attorney 8, please, and then send all. Should say send all. I'm sorry? No, I Is that right?
Modern technology. We're meeting in this courtroom because the jury room on my normal courtroom is real small, and putting 14 people in there is be quite cramped, but I'm not real familiar with all the controls in here. Although I did have a little course yesterday, I thought I understood.
Your Honor, I took the instruction beforehand, and I can get a look at it, so.
About what?
Actually,
whatever you want.
welcome back to Law News Network. I'm your host, Jesse Weber. We are taking we're going to cut to a better feed for the Segura trial. Again, this is the Henry Segura trial out of Florida, the quadruple homicide. This is a trial where he's on for the murder of his girlfriend, Brandy Peters, and her 3 children, Tamia Peters, Tania Peters, and Javante Segura, who is Segura's own son. I'm here with Ron Blitzer. Ron, I'm sorry, we're going to have to turn back to our live feed of the Segura trial. Take a look.
I'm not real familiar with all the controls in here. Although I did have a little course yesterday, I thought I understood.
Your Honor, I took the instruction beforehand, and I can get a look at it, so.
The fan just kicked on the projector.
Oh, there we go. Got it. All right. Sorry about that. We ran through it beforehand to make sure it worked, and of course, as computers worked years ago, sometimes you have some problems. Obviously, you were here today for State of Florida versus Henry Segura. What the judge explained to you at this point is what the opening statements are, an opportunity for the attorneys to tell you what it is that they expect you to hear about the course of the trial. And of course, what I'm going to do is explain to you how the state created the evidence, or not created, but came up and investigated this particular case, found the evidence, and ultimately charged Mr. Segura with this particular crime. So let's talk about this. What you're going to hear, back on November 20th of 2010, law enforcement officers were called out to 908 South Creek Run. They were called out there for a welfare check by a friend of Mrs. Peters, Brandy Peters. You're going to hear that this is located in the southeastern side of Tallahassee. You can see the fairgrounds are right here. We have Jack McLean Park, Capitol Stadium. This is Tram Road, 4 Points, and then heading out this way on Jack McLean Road. This is the location of the home. What you're going to hear, this is of course the home of Brandy Peters. Her 6-year-old twins, Amaya and Tanaya Peters, and a 3-year-old son, Javante Segura. Again, you're going to hear that law enforcement officers responded to this scene. And who you're going to hear is that Officer Jernigan responded as well as Officer Kidd initially. They approached the home. They were able to see blood on the outside. This was consistent with the phone call they got. And what you're also going to hear is that C.C. Timmons, who is a friend of Mrs. Peters, had been talking to Brandy the night before. And since that time, had never been able to get her on the phone. And this was unusual because usually they go back and forth, they talk on a regular basis. But for some reason, on that particular morning, Miss Peters was not responding. Now you're going to hear that Miss Timmons was actually at work, so she called her son, Artron Timmons. And Artron went over to the home, and he went to the home, and he was able to see blood on the outside of the home. obviously, as anybody else would, he realized there was a problem. So he called his mom. Mom subsequently called law enforcement. Law enforcement officers respond. And they come up and they approach the home. And what you're going to hear is they try the door. And the door's locked. Can't get in. But they also see the force carpets over here. You'll find out there's blood here on the side of the home. So at this point, they're a little alarmed, and they break the window in order to gain entry. They break this right-hand window right here. And you're going to hear that officers reach in, and they unlock the door, and they open the door, and you're going to hear what they found. They found Brandy Peters right there. You're going to hear that they were joined by Officer Wyman. Officer Wyman has training experience. He's actually former in the United States Army. He actually takes what they call point or lead, and the three of them proceed to what they call clear the house. Clear the house is a situation in which they go through the house and they make sure nobody's in there. They may be still alive at this point. It was fairly apparent that Peter was not alive, so they would not be able to help her. So they want to go through and make sure that there's not somebody else there that may be still struggling, holding on to life, or what have you, or maybe even possibly the person that did this. So they're going through and they're clearing the house, and they go through room by room by room to make sure of that. And as they go room by room by room, they find Tanaya, Tamaya, and Javante. And that's not a good name of that word. They fall on wide all three of them.
Move it on this view.
I am. So now the question is, what happens next? Once they get done clearing the house, they pull out of the house. They start preserving the house for purposes of the crime scene. They put up that tape that you saw earlier to make sure nobody can come in. They contact the investigation division. The investigation These are the people that are trained in the course of these investigations for homicide in this particular case. And they come in and they start doing what it is that they do. What you're going to hear is that investigator Mark Lewis is the person that has been assigned to the case, and he's the lead investigator. Now what a lead investigator means doesn't necessarily mean that he does everything involved in the case. What it means is he's kind of the ringleader. He coordinates. It's almost like the head coach of a football team. He coordinates and tells the other people, if you will, the assistant coaches, what to do, how to do it, come up with ideas, and kind of helps put it all together and make sure and direct traffic, if you will, as far as how the case proceeds. In addition to that, they also call the crime scene investigation. In this particular case, Amy Pressey is the primary crime scene investigator. There are multiple people that do in fact respond in addition to her because
and then Hi there, welcome back to Law News Network. We're having a little bit of technical difficulty with our feed in the Henry Segura trial out of Florida. So in the meantime, let's turn back to the testimony of Dr. Richard DeFranco in the Joshua Gaspar case. And as soon as the Gaspar case is up, we'll turn to that as well. Thank you for joining us here on Law News Network, but let's continue right now to Richard DeFranco.
In the majority of cases, patients did not exhibit stable abstinence from drug use and had an increased occurrence of simultaneous psychiatric/neurotic disorders or personality disturbances which, by themselves, could be a reason to doubt their driving ability.
Well, I don't know. I suppose somebody could have something else going on that would impair their driving ability. Is that what you're saying? Yes.
Well, that's what it's touching on.
Mm-hmm.
I'm going to object. I'm not sure what we're reading from.
I can readily identify. You objected to the document, so.
The law enforcement document?
It's 1552.
I'll look at it. Yeah.
I don't know if a comfort break would be appropriate now. Ms. Knox took one without us, so.
All right, ladies and gentlemen, we're going to take a brief break, probably till 10 till. Keep in mind, don't discuss this case. No one will discuss the case with you. Don't form express an opinion. And no independent investigation or media. And you do not have time to go down to the
For sex with driving, okay, as a general topic. And I think we established the point that a person who's compliant can be safe to drive.
Okay.
Okay.
Do you agree?
Yes. We established that point.
And we saw from the black box warning on the subject of dose initiation and dose titration that you have to have a specific period before one can, the treatment provider, the physician, can conclude the person is stable on a new dose. We covered that subject, right?
Yes.
Okay. You also said that, I think in your estimation, it was 5 to 6 days of new dosing before you would look at whether stability has occurred.
Yes.
And we talked about how many misses a person can have in their treatment administration of methadone before it becomes problematic, right?
Yes.
You said there's no firm line, 1 or 2 days versus 3 or 4. It's a matter of discretion, I believe your answer was.
Yes.
Okay. As a medical provider in a methadone maintenance program, what are you personally aware of in terms of Ohio state law regarding impaired driving on opioids?
Well, I haven't reviewed the statutes, so I'm not familiar with those.
Okay. In the treatment setting, is it part of your thought process? Do you have a concern about somebody driving while on methadone?
There have been many studies to show that it's safe to drive on opiates, so I don't think that's part of my daily thought process, no.
Would you agree that there are different levels of law in different jurisdictions? And, for example, in some states of the United States, they have a statute that says a certain level of methadone is prohibited, just like you would have for alcohol or marijuana.
Well, I don't know about that, but I do know that there have been studies with so-called low-dose methadone, and they have shown that doses of 80 milligrams or less are far less effective for treatment compared to doses of 80 milligrams to 120 milligrams. So, we do try to put patients on a therapeutic dose that's going to help them.
Are you aware of any studies that conclude that a person in a methadone maintenance program is per se unfit to drive?
I don't know of any, no. Risk prior to prescribing and monitor all patients regularly for the development of these behaviors conditions. Serious life-threatening or fatal respiratory depression may occur. Monitor for respiratory depression, especially during initiation or following a dose increase. Accidental ingestion, especially in children, can result in fatal overdose. Pardon me? QT interval.
Hey there, we're switching back to our live feed of the Henry Segura trial out of Florida. You don't want to miss it. It's the opening statements.
So after doing this, after talking to everybody, what they figured out was that Randy Peters was one who always had her cell phone around. We talked about that in jury selection. Randy Peters was one of those. She had her cell phone all the time. She was last seen on November the 19th, which was the day before. Around 5 o'clock in the evening, she had come home, she had picked up the girls. Archer on Timmons is going to tell you that he saw them eating Burger King around that time period. And they went back to their home. We know how the bodies were discovered because our front end of the CCTV called for a welfare check. Our guys, boyfriends, and we also figure out that the children have two different fathers. Mayans and I have their fathers, Antonio Anthony and Javante Peters. His father is Henry Segura.
Hi there, welcome back to LawNewz Network. Again, we apologize for the feed issues that we're having in the Henry Segura trial out of Florida, but as soon as we have a live stream back up, we will turn right to it. In the meantime, let's continue our coverage of the Joshua Gaspar case, which will be live any minute as well. But in the meantime, we're going to be turning to a replay of the testimony of Dr. Richard DeFranco, who is the doctor that prescribed the methadone to Joshua Gaspar in that case. So let's listen to the critical testimony of this witness in that case.
Risk prior to prescribing and monitor all patients regularly for the development of these behaviors conditions. Serious life-threatening or fatal respiratory depression may occur. Monitor for respiratory depression, especially during initiation or following a dose increase. Accidental ingestion, especially in children, can result in fatal overdose. Pardon me? QT interval prolongation and serious arrhythmia, Torsades du Points, reported closely monitor for changes in cardiac rhythm during initiation and titration. Prolonged use during pregnancy can result in neonatal opioid withdrawal syndrome. Advise pregnant women of the risk and ensure availability of appropriate treatment. For detoxification and maintenance of opiate dependence, methadone should be administered in accordance with treatment standards, including limitations on unsupervised administration.
Thank you, Doctor. I appreciate that this is not pleasant to be on the witness stand in a matter such as this, but I appreciate your cooperation. Turning to the subject at hand, Mr. Gaspar, I want to show you a record, states 1461, if I may approach, Judge.
Yes.
Can you review this, please? Tell me if you know what that is or recognize it.
Hey everyone, welcome back to Law News Network. We're turning now to the Henry Segura trial. We have our feedback up, and again, we apologize for the inconvenience. Take a look at the opening statements, prosecution's opening statements in Henry Segura.
As well. So once again, they can come back and relate it to you. And you can hear Dr. Lisa Flanagan is the person that performed the autopsy. And what you're going to hear is, in the course of the autopsy, what she found was that inside the stomach of Tanaya was undigested food. And that undigested food is consistent with having been eaten within the past 3 hours. So when you take that in context with Archon Timmons' testimony of seeing them eating Burger King approximately sometime around 4 to 5 o'clock in the evening. In addition to that, on scene, we found a Burger King receipt where Burger King was bought around 4:30 in the evening. Now we have the undigested food that would have, or that was eaten within the past 3 hours. And then you take another look back at home, and you see over here where somebody was in the process of eating something. So you take all that into context, and you sit down and you think about what it is that normal dinners and things are eaten between the hours of 5, 6, 7, 8 o'clock in the evening. And all that adds up and is being consistent with the murders occurring between those hours that we talked about, 6:53 and 8:21. So now they've established when they believe the murders occurred. They've established communication at what Brandy's doing. They've gone out and they've done this. And they start looking towards how are we going to apply this. And of course, as we talked about during jury selection, motive. Who had a reason to do this? You're going to hear investigators talk about the training that they have, and one of the main things and some of the things that they look for as it relates to this, as we already talked about, the wounds are very personal. So as it relates to the motive, one of the things they know through their training and experience is that many, many times these things come down to a couple of different situations. Either motive, love, relationship, money, in some way, shape, or form is usually connected to these. So they start looking for what that motive would be. What they're also going to look for is means. Who's got the ability to carry out something like this? One of you think you're going to hear from Dr. Flanagan is one of the wounds in the forehead area on Brandy Peters was she was hit so hard it actually crushed the skull. And she was hit repeatedly over and over and over. But because of that hit on your skull, somebody who did this had to have a lot of strength. Had to be really, really strong. The other thing you're going to hear from is Florida Department of Law Enforcement, Jeff Foggy. Jeff Foggy is now an agent. Back then he was a firearm analyst for many years. You heard that we actually recovered projectiles, which are the spent bullets, from the scene. We found one in the bathroom, or actually two in the bathroom, one in the hallway closet. Also, during the autopsy, other projectiles were removed actually from Ms. Peters. She was shot multiple times as well as beaten. The gunshot injuries were not the cause of the death, however. However, they were the cause of death. What you're going to hear is that so they start looking for these questions. And of course, the other thing they do is they look for who had the opportunity to do that. Who had access to the house? Who was there? Remember, there wasn't a forced entry at this home. So who would have been let in? Someone they knew? As I said, you're going to hear from Foggy, Jeff Foggy, that the gun that was utilized in the projectile were a .32 caliber. Now, the interesting thing about 32 caliber is apparently there are two different kinds of bullets that can be used in a 32 caliber pistol. And it's a pistol round, it's not a rifle round. And if you use the wrong one, it actually doesn't work like it's supposed to. What happens is, and he can explain this a lot better, but essentially what happens is the bullet doesn't get the velocity and the energy that is usually you think of when it comes to firearms. And as a result, it doesn't have the power that it's supposed to. And what you're going to hear is with Brandy's injury, that she was actually shot one time in the head and it never pierced her skull. And as I said, none of those injuries, or gunshots, were the cause of her death because they didn't do enough damage. You're actually going to see photographs from the scene that show where a bullet basically bounced off one of those thin rails that are on shower stalls. It hit it, made a small dent, and bounced down to the ground. You're going to see another one where it hit a porcelain toilet and bounced onto the ground. So these were, even though they were gunshots, they didn't have any power behind them for whatever reason. So one of the things law enforcement officers do, of course, they've established that these are the kind of things they need to know in order to figure out where this investigation is going to go. Now what you're going to hear is that one of the first things they do is they're actually notifying Henry Segura of the death of his son. They know that Javante Segura is Henry Segura's son. They haven't heard from him. So law enforcement officers have to notify somebody. Tell them. Your son passed away. And you're going to hear, of course, that law enforcement officers, when they do interviews, and this would apply no matter whether the person's a suspect, just a person that's a witness, or whatnot. And at the time, Mr. Segura was not a suspect in any way, shape, or form. This is for the purposes of letting them know about his child. This is for the purposes of going back and talking to family members, known acquaintances, getting that information they need from Brandy to figure out who might have done this, figure out who Brandy Peters was. That was the purpose behind this. So they're asking them questions. But of course, law enforcement are trained. They look for verbal and nonverbal cues. Not only what they say, but how they say it. Their posturing, things along those lines that might give an indication about whether the person's truthful or not. They look for whether the person has emotions or lack of emotions when they're telling certain information. They look, of course, to whether they're being deceived. And ultimately, they apply their investigative tools, the education they receive, their common sense, and those tools that they utilize day in and day out. And you're going to have an opportunity to see this initial this interview. And what you're going to see is Mr. Segura has a lack of emotions when he's told about the child. And not. Mr. Segura says, I was at home on the 19th during the time period. Just check my phone records. It'll tell you I'm home. Here's my phone number. 519-8380. Says that the next day, he went down to Silas Thornton's house. Silas Thornton lives in Sopchoppy area. And the next morning, on the 20th, he went down to Mr. Thornton's house. So law enforcement officers, all of course, want to talk to Mr. Thornton. So they ask for the phone number. And this actually is not on the interview. What happens here is that Mr. Segura tells law enforcement, so I don't have it on me, so investigator Lewis goes out to Mr. Segura's car, and at that point, Mr. Segura says, Mr. Thornton's phone number is 850-408-8669. He says, wait a minute, that's not it. And he gives another number. Officer Lewis takes him both down. Doesn't think any more of it. Next day, they go out. And talk to Silas Thornton. Silas Thornton says, yeah, I know. Henry Segura. I don't know. Randy Peters. That's not my phone. You're going to hear that there's a CID meeting. And during this meeting, Chris Corbett's there along with the investigative team. And he's letting him know about this cell phone information. And he says, whoa, that number, we need to find out who it is that owns that 408-8669. Because that number was in contact with Randy Peters all day on the day of the homicide. Multiple times throughout the course of the day. Investigator Lewis has recognized this. So wait, that's the one that belongs to Silas Thornton. Silas Thornton. Again, he says, I know Henry Segura, I work with them. They're both welders. So that 408-8669 number used to be his, but he was with Segura working with him and actually dropped it in some water and got some water damage. And during that time period, Mr. Segura says, dude, put it in a bag, put some rice in there to absorb the water out of it and maybe it'll work again. That's what he does. However, he left it in Segura's truck, got a new phone, and moved on. But he does know that Mr. Segura uses that phone at that point. So now we have two phone numbers. We know the importance of this one because it is the one that Randy Peters is talking about all day long in the day of the homicide. And this is the one that Mr. Segura tells us about. So you're going to hear at this particular time, but we really don't know who owns this phone. Mr. Segura says it's Silas Thornton. Mr. Thornton says it's Henry Segura. So now we're going to go back to the phone record. And this is where Investigator Corbett comes back in. Investigator Corbett says he goes back and he analyzes these particular records. And what he has found is that 8:30 in the morning, so we're talking about November the 19th, the day the state of search is the time of the homicide, that there's a phone call between Randy Peters' phone and that 408-8669. Investigator Corbett's going to tell you that one of the things these records will let you know about is star 67 was used to make that phone call. What star 67 is a block. It doesn't tell you, caller ID, who it is that actually that phone belongs to. So this is a phone call that's being sent out from that number, but it's blocked, so it won't show up on this Peters phone. What you're going to hear is that phone call lasted for 56 minutes. Fair to say that 56-minute phone call, probably someone she knows. What Investigator Corbett's also going to tell you is between 1:18 and 1:28 on that same day, there's a series of calls, all of which Star 67 is utilized. I'll tell you again, at 2:13 p.m. there's another phone call lasting for 2 minutes and 35 seconds from that same phone number. Again, Star 67 is used. Now, at 2:19 p.m., Ms. Peters sends a text message to 509-83 or 4380. That's the one and the phone number that Henry Segura gave to law enforcement as his phone number. And in that, she said, "You hang up on me?" 2:13, 2:19. What does that tell you about who she was talking to on the phone? If she's returning the text message to Henry Segura's phone, she talked to Mr. Segura. What you're going to hear then is at 2:27 p.m., the 408-8669 returns the phone call to Ms. Peters' phone, again, using the Star 67 function. Again, this is the phone number that Mr. Segura gave, said it was Cyrus Thornton's phone number. Never told law enforcement it was mine. Law enforcement officers dig a little deeper. They talked to Calvin Moore. Calvin Moore says, yeah, I know he had a 408 number. They talked to Tyra Wilcoxon. Said, yeah, I know he had a 408 number. So friends of Mr. Segura are confirming that they've actually talked to Mr. Segura on that 408 number. So now we've actually confirmed that that 850-408-8669, through the testimony, you're going to hear it, through the testimony of Tyra Wilcoxon, Calvin Moore, as well as the cell phone record, that this is in fact a phone that Mr. Segura utilizes. So we go back to our tools that is being utilized by Investigator Lewis. One of the things is emotions or lack of emotion. And the biggest one is, of course, deception. So now, Henry Segura has become a suspect. Based upon that. We know he deceived. We know he didn't have any motives. So now the question becomes, let's go back and apply what it is that we've learned as an investigator. And Investigator Mark Lewis goes back and he starts directing. Here he directs it to figure out, was there any motive? And again, we go back to what motive is. What they find out through a search of records and Vance Wiggins from the Florida Department of Revenue was going to come in and testify. And you're going to hear from Mr. Wiggins that the records at the Florida Department of Revenue show that Henry Segura was ordered to pay child support on Javante Segura and was actually behind on the child support by a pretty large amount of money. As we've already seen, money many times is the motive in a murder. But that's not all. It doesn't necessarily mean, of course, that he killed his son. But it's there. The next thing is they ask means. Investigator Lewis has an opportunity to observe Mr. Segura. They've done the investigation. You're going to hear from him as observations. And of course, you're going to see him during the course of the interview. Of course, you can see him in court. Means, strength, murder weapon. Testimony is going to tell you from Silas Thornton. He's a welder, big, strong guy. You're going to see it. So he has the strength to carry this out. Talked about that injury. Ms. Flanagan is, or Dr. Flanagan has been testified to. This is a gun. You're going to hear from Calvin Moore. Calvin Moore is a longtime friend of Mr. Segura. Calvin Moore has known him for years and years and years, back to high school, even before then. Calvin Moore was in the United States Army, I believe it was. He knows about firearms. And he's going to tell you, I saw Henry Segura with a .32 caliber pistol before this. You're also going to hear from Tyrell Coxon. Tyrell Coxon is a former girlfriend of Mr. Segura. And what you're going to hear is that following these homicides, there was an anonymous tip made to the Crime Stoppers Network and said that just before the homicide, Mr. Segura had told this anonymous person that wanted to get a throwdown gun. Law enforcement officers, in doing their investigation, their background information, are now going out and talking to people that they know have talked to Mr. So they go to Ms. Wilcoxon's and they start asking her questions, and she says, "Oh, you're here about that anonymous tip." Law enforcement officer had no idea she was the one that made the phone call. Turns out she was. What Ms. Wilcoxon is going to tell you is that just before these homicides, Mrs. Segura approached her and asked her for that throwdown gun. Also, she's going to tell you that she had regular communications with him on that 408 number. So now we add that up. Got a gun that's consistent with a crime scene. Got a strength. Does that add up to me? So next the question becomes, did he have the opportunity? Was he there? Did he have access? He obviously would have access to the home. Devontae Segura is his son. In fact, you're going to hear he was actually at the home a couple of days before, on the 17th, the Wednesday before. But was he there at the time? Go back to the cell phone records. And you're going to hear Investigator Corbett does a comparison. He's going to come in and he's going to talk about this. And he's going to compare the data between Randy Peters' phone and Mr. Segura's phone. That 408 number, the one he didn't tell law enforcement about. And he makes a comparison, and he finds out that both of the phones are inactive between 6:53 and 7:23. At that point, Randy's phone remains inactive, and Mr. Segura has two data sessions at 7:23 and 7:37. And then both of the phones again are inactive from 7:37 to 8:21. And we already talked about at 8:21, Randy's phone is powered down. Also, at 8:21, Mr. Segura made a 2-second call with an immediate disconnect. Both of them at the exact same time. Now, cell phone data doesn't always just tell you what calls were made, what texts were sent. It doesn't always tell you what the contents were. It can also tell you what they call RTP data. And you can hear from Investigator Corbett, and he can explain this a lot better than I can. But what essentially RTT data is each cell phone communicates with a cell phone tower. And each one of those towers have 3 different sectors. And each one of those sectors covers roughly 33% of the circle. Okay? also happens is, in order for our phones to communicate, investigator Corbett is going to tell you that these phones send out receive it back. And the cell phone companies do a calculation. It's essentially a time calculation. The speed these things are going out, they can do a calculation to tell you the distance essentially that the phone would be from that cell tower. They tell you communicating as well as what sector of the tower it was communicating. And what Investigator Corbett's going to tell you is that he took this data and essentially he gets the information about how far the cell phone was from a particular tower. And he'll do a plot and he'll figure out things. This is the phone number that he said, check phone records. I like my house. And investigator that when he analyzes that RTT data, that phone number is consistent, that data is consistent, that phone would be at Mr. Segura's house. Exactly where it said it would be. But he's also going to tell you it was inactive. It was only receiving. Nothing was being sent from that phone. We know the phone was at his house, or consistent with being at his house. But nobody was utilizing that particular phone. So now, we go back and we look at his 408-8669 number. Look at the phone we now know to be Segura's. And you know that because you heard at this point you reported to Mr. Cox, she's had conversations with him there. Mr. Moore, because he had conversations with him. Silas Thornton has told you that it's his phone number, as well as you take into account the context that Investigator Corbett has already testified to, and that exchange of phone calls and text messages that we already talked about between the two phones. And when you chart that arc and that distance arc, Investigator Corbett does this. Finds out that 847 in this sector is where the phone is communicating. That the sector, it really isn't a hard line, it's more of a, they can go kind of either way at certain points, and it kind of falls right along where Brandy Peters' house is. And when you do the arc calculations about where it was, I'm pretty close to it. But at that point, law enforcement then go and they talk to Silas Thornton. And they go with Silas Thornton to Walmart. And they purchase a phone. Silas Thornton says, that's the phone that we're talking about. That's the kind of phone we're talking about. The cell phone data also tells what kind of phone, the type of phone that is being utilized. So Investigator Corbett also utilizes that to make sure we're doing the same phone. And they purchased the phone from Walmart. Same phone, same make, same model. They conduct their own test. They go out, they make phone calls, they make text messages, they make data. They go to different locations. They go to Brandy Peters' house. They stand in her living room. They stand outside the home. They go to a bunch of different locations, and they're going to tell you about it, including Mrs. Segura's home. Bunch of different places, almost 100 of them. In order to conduct, that way they can compare the data between the two phones. And they get the cell phone data as to this new TPD phone, if you will. It's the one that they purchased. It's identical to the one that's connected to the 408 number. And they chart those same arcs. And when you put them side by side, they're nearly identical. Now what you're going to hear is all of this took a long time. This isn't something, as we talked about CSI, it's done overnight. In fact, it took almost a full year to get to this point. And you're going to hear at this point, Henry Segura is no longer a suspect. Henry Segura is being arrested for this charge. And you're going to hear that Henry Segura was actually arrested up in Minnesota. You're going to hear that he, I misspelled Minnesota. And you're going to hear that he was transported to Oklahoma on his way to Florida. This is actually transported by different entities. But he's taken to Oklahoma, and he's there at Oklahoma, in which he has a cellmate named Kelsey Kennard. This immediate after his arrest, we're talking 2011, almost 1 year after that. And you're going to have an opportunity to hear from Kelsey Kennard. And what Mr. Kennard is going to tell you that Henry Segura said. He did this. A lot more information he's going to tell you. He's going to talk about all the things that Mr. Segura said, including the fact that there were 2 kids, multiple kids. Now we look at it. And again, investigator Lewis applies the motive, what he's learned. He applies the motive. It means the opportunity to add in the confession. And that's why the state is going to actually return a verdict of guilty as it relates to Henry Segura versus State Court.
Let's take 15 minutes. We'll let the jury step back. Okay? Leave your notes where they are.
Nope, can't do that. Why not? You can't get the back so that you can start it all. Why not? Because like, you can't get their image or likeness. I've been recording 2 to 3 millions and Welcome back to Law News Network. I'm your host, Jesse Weber. You were looking at the opening statements, the prosecution's opening statements in the Henry Segura trial out of Florida. You heard him basically lay out the case that the state is going to present to the jury. A lot of evidence pointing towards Segura. And when we come back, we're going to hear the defense's opening in the Segura case, and they are going to point to a theory that someone else committed these brutal murders. But in the meantime, I want to continue our coverage of the Joshua Gaspar case. This is the case out of Ohio. Gaspar is charged with aggravated vehicular homicide for allegedly striking and killing Ohio State Trooper Kenneth Velez on September 15th, 2016, while driving under the influence. But it's not a case of driving drunk. It's a case that stems from methadone that was in his system that he took a few minutes prior to the accident. I believe we have our live feed back in the Joshua Gaspar case, so let's take a look at that. We'll turn there, and when we have back from Segura, we'll turn back to Segura. But now, let's look at the Joshua Gaspar case out of Ohio.
If I drown. But still, we encourage seatbelts, right?
Yes, sir.
Because in general, it's a lot safer to have the seatbelt on than not to. Right?
Yes, sir. Yes, sir. Yes. Mm-hmm.
Now, I mean, as far as the danger out there of being outside the car, I guess the danger would be how do you indicate to drivers that your intentions? How do they recognize these hand signals?
That's what. So when I would conduct the flagging, I would point at a car.
Isn't there a danger that when you point at a car, they misinterpret that and just stop?
That's a danger when we turn our lights on too, that they just come to a dead stop.
Right, but wouldn't it be true that most folks are a little more used to having patrol lights as opposed to a trooper actually on the side of the road pointing at them?
If you're asking if the more common way way to stop a vehicle would be to get behind it to turn lights on, then absolutely that's the most common. That's statistically speaking the most common way. Way that you would stop a car. Yes, that happens far more often than a flagging operation. Yes.
Now, did you have an opportunity to go back and watch all the prior stops that the trooper made that day?
I did.
Did you do any other stops using this flagging technique?
He did not.
Okay, so the only stop he did with the flagging technique was the last one.
Yes, sir.
Okay. Even in the first stop, how did he execute that first stop that he did?
So pulled out of the crossover. So got behind the vehicle, turned his lights on. The vehicle stopped partially in the as a left-hand lane of travel.
Okay.
And then he approached the vehicle, and then had moved them over to the right-hand side.
How did he approach your vehicle? He got out of his vehicle?
Yes.
Okay. So even earlier this day, Trooper Velez has an individual stop in the fast lane of 90, just stop there, and he gets out of his vehicle at that time and approaches. Do you agree with me that that whole situation is just inherently bad news? It's dangerous.
It's bad all around for everybody. Yes.
Isn't there a loudspeaker in the car that you can tell people pull over?
Yes, there is.
Okay, he chose not to use that?
So my experience for that, when you're sitting out there, the loudspeaker is not my preferred method of telling somebody to move over.
At least with the first stop, though, he's got the flashing lights and everything, right?
Yes, sir.
He's actually behind that car. Really, his car is providing some kind of block for that car, right?
Yes.
Is that a policy you guys use to put your own vehicle between yourself and traffic so that if somebody does do something crazy, they're going to hit your car, not you?
It's uses one of our some methods of traffic control. Yes.
Okay. And it sounds like a good idea, right? To put a barrier between yourself and oncoming traffic.
Yes.
Okay. And in the first stop of the day, Trooper Velez did that. He left his patrol car in the fast lane of I-90, or did he get off to the berm? I'm sorry, let me go slower for you, sir, I apologize there. In the first stop of the day, car stops dead on 90, fast lane, just like happened on the last stop of the day, correct? I mean, as far as car stopping in that lane.
The last stop of the last stop of the day is kind of an anomaly because there was an impact that took place. But the first stop of the day stopped in the lane of I-90. Yes.
And does Trooper Velez put his car behind that car in the lane and then exit his vehicle, or does he go to the berm and then exit the vehicle?
The right berm, or
I guess.
So I believe that he stops behind the vehicle, he approaches, and then they both move off to the side.
So at that point, you've got two cars now stopped in the lane.
Yes.
But at least when Trooper Velez approaches the car in front of him, he's got his car there to protect him.
But protect everybody.
Theoretically, though, if somebody comes up and says, holy cow, there's cars stopped in the lane, and they smack into you, they're going to hit his patrol car as opposed to hitting him.
Yes.
Well, the last stop of the day, Trooper Velez didn't use his car as a shield when executing that last flagging signal, did he?
Well, you're talking about two different situations there. The traffic stop, the first traffic stop that we're talking about, that was the methodology that he had used to initiate the traffic stop. He had used his patrol car to initiate the traffic stop for the first one. For the striking violation, whatever that one, he had got out and he was attempting to gesture to a vehicle to pull over, say to the side. Now, obviously, I can't testify to what he was going to do after that, but when when we typically make those kind of gesturings and movements, the next thing is us getting back inside of our cruiser, so turning on our lights and then reapproaching the vehicle afterwards.
Okay. Now, you're part of the accident reconstruction.
Yes, sir.
And so you really have a good idea of where, as best as possible, is where Trooper Velez was and where his vehicle was and where the other cars were, correct?
Yes, sir.
Is it safe to say that Trooper Velez's car was not struck at this time?
I don't believe his vehicle was struck, no.
So we can take from that had Trooper Velez been in his car, he could not have been struck at this time, or he would not have been struck based on this accident.
That's true, yes.
And had Trooper Velez stayed behind his car and used his car as a block, as he did earlier in the day, he would not have been struck in this accident.
Well, he was behind his car, but not immediately behind his car, but he was behind his car when he was struck.
I guess he was behind his car as far as where he was situated in the roadway, but his car was not positioned between himself and the lane of traffic.
No, no.
He was positioned closest to the lane of traffic.
Yes, yes, he was.
Thank you, sir.
Yes, sir.
Lieutenant, you said that there was a sound of windshield wipers. What vehicle?
The defendant's vehicle, sir.
When you pull somebody over, do you loudspeaker to them for their license number?
No, ma'am.
Do you loudspeaker to them for their insurance card?
No, ma'am.
In every single traffic stop that's initiated, does the trooper have to get out of the car?
Yes.
So the only difference in this collision is the timing of the stop when Ken got out of his car.
Yes.
Okay.
There are times when we use our loudspeaker to say to do things, but not normal traffic stop operations. No, ma'am.
My point being, do you always have to get out of the car?
Yes.
So is there always a risk of this happening in every single traffic stop that you initiate?
Yes, ma'am.
Do cops get shot at?
Yes.
Do they then stop responding to gun calls?
No.
Does Cleveland Police still patrol the unsafe neighborhoods?
Yes.
Is that inherently dangerous?
Yes.
Is your job as a trooper inherently dangerous?
Yes, ma'am.
Or are you going to stop doing it?
Nope.
Mr. Sin asked you if you were familiar with the location Ken was in when he was struck. Was Ken in the median or was Ken in the lane of travel?
Say by median, you mean the area that is outside of the land. The median for that area is a solid concrete wall, say with a little bit of grass that's between it. But say between the median and the travel portion of the roadway, there's a paved shoulder. So Trooper Velez was in the paved shoulder. So he was not in the lane of travel, but he was also not beyond the concrete wall or in the grassy area for the median.
Now, Lieutenant, you mentioned, was this area used frequently for flagging by the Highway Patrol?
I'm not specifically aware that it's a common area, but when I looked at Trooper Velez's citations and one of the other videos that was contained on his video card, there was video of him flagging at that exact location, so like I said before, I had documentation. So from the previous citations, I had pulled up his citations and I had read the comments and read aloud the old ones for any kind of documentation that he had done this, say, in the past for that location, and had found 3 other times that he had done it at that specific location.
Was he struck and killed in any of those?
No, he was not.
I mean, is flagging something that is commonly used by the patrol in areas where you can't run a laser?
Well, it's typically used in conjunction, say with stationary laser. It's also used a lot so when we work with the aircraft. So the aircraft will fly over a speed zone, and we'll be outside of our vehicles, and then the aircraft will radio to us that I've checked this vehicle at this speed. He's number 1 to you. He's number 2 to you. He's number here. The next vehicle coming to you will be him, and if it's possible to initiate the traffic stop that way, then you flag over that vehicle that the aircraft is called to you. But also if so you're working a laser, speed check and flagging is an option. Yes.
I mean, are there areas where radar doesn't work?
Yes.
What?
The traffic volume is too heavy. The radar works upon the vehicle that returns the greatest energy to you. So even if you have a car that's going 90 miles an hour and you have a semi-truck that's going 60 miles an hour, the radar might not return that car at 90 miles an hour because the semi-truck is returning far greater energy to you. And plus, the radar, for you to be positive that you're checking the vehicle that you're checking, there's a lot of different things that you have to go through. You have to listen to the radar output. You have to not to get too much into it. There's a lot of things that you have to keep straight there with a radar check. And in an area like a 90, so it's 4 lanes of traffic, it'd be impossible for that time for you to do a radar check. So maybe not impossible, but would be extremely difficult for you to differentiate between vehicles that you're getting a radar check on. The laser is far more, so pardon my euphemism, but cop-proof, because you point it at the vehicle that you want to check and you pull the trigger, so you can use it in say higher traffic locations.
So in a heavily trafficked area like I-90 westbound, is this a tool that multiple state patrol officers use to pull over vehicles, flagging and a laser?
Yes.
So in years, how long have you been a crash reconstructionist at this post again?
I was a crash reconstructionist for approximately 9 years total, but I was a reconstructionist for the Cleveland District for 6 years.
Any other fatal flagging crashes where troopers are killed in all that time?
No, ma'am.
You've watched this video, I'm assuming, many, many times?
Yes, ma'am.
Any other vehicles head in Ken Velez's direction on that video, as if they're going to crash into him?
No, ma'am.
Nothing further, Your Honor. Thank you.
Sir, I understand what you're saying about the laser being easier to use in high volume situations than the regular radar, right?
Yes, sir.
Is it possible, though, that you could still use the laser to clock somebody, but then have another trooper pull them over in a patrol car as opposed to pointing at them?
Yes, sir, it is possible.
That's policy. That happened that morning with Trooper Velez, right?
He was working with another unit, yes, sir.
A tag team.
Yes.
So it's not necessary, in order to police these type of areas, that a trooper put himself in the kind of danger of pointing at traffic. That's not necessary, is it?
Well, to the best of my knowledge, there were no other troopers that were in the area. Say for them to work.
Welcome back to the Law News Network. I'm Jesse Weber. We're going to be continuing our coverage of Joshua Gaspar later today, but we are going to be turning now to Henry Segura, the trial out of Florida, the quadruple homicide. We're now going to be hearing the defense's opening statement in that case. Take a look.
Y'all come in, you can be seated, they're standing for you. Everybody be seated. You may proceed with the Prince.
The crimes are absolutely unspeakable. Horrific. I have seen some of the worst autopsy photos and crime scene photos you can imagine. None of those hit you in your soul like the pictures you will see in this case, like the testimony you will hear in this case. What I'm going to ask you to do is what you said you would do in jury selection, which is respect the presumption of innocence. And I don't mean just sit there and wait for the state to prove the case. I'm going to do something to help you. Of course, right? Of course. I'll show you DNA because I have DNA. I'll show you forensic evidence because we have forensic evidence. I'll show you step by step by step where Mr. Segura was throughout the day, and I won't ask you to draw any conclusions. They're not totally supported by the evidence that you hear. This case is a terrible tragedy. But tragedy is compounded where more innocent people suffer. And so to prevent that, let me just ask you from the outset to remember your oaths and remember the instructions regarding the presumption of innocence that the judge gave you. I have a lot of evidence that I'm going to present to you during the course of the trial, all different kinds. I just mentioned some. As I sat there last night pondering what the heart of the defense is in this case, it isn't the forensics. It's not the DNA. It's the heart of the man sitting at the table with the defense team. My oath to you is that I will not ask you to step over bodies on the way to a not guilty verdict without showing you, with evidence, a window to that soul. That isn't fair to you. I know. Burden of proof, it's their burden, solely and exclusively. I know. 3 dead babies. I know that too. We're all people in this courtroom. I know that too. So while I, at one instance, ask you to follow the law, I'm not going to just hang it on you and say, oh, follow the law, ignore the facts. I will show you who he is. You'll know who he is, as I know who he is by the end of this trial. But of course, the forensic evidence and DNA and all that kind of stuff is important too. So let me tell you about the conclusions that both the defense DNA expert and the state's DNA expert drew upon review of the DNA evidence in this case. Over 200 DNA samples were collected from around the murder scene in this case, from places relevant to the investigation, relevant to the murders. Henry Segura was not included as a contributor to a single evidentiary exhibit. In fact, he was excluded, meaning eliminated as a possible contributor for most of them. Consensus from Jo Ellen Brown, the FDLE analyst who did the initial work on this case, did it blind without having any idea who the suspect was, what the state's theory of prosecution would be, who the suspects were for the investigating agency. Those were her determinations. The defense expert years down the road, came in, looked at the same electropherograms, which are charts that you'll see during the course of the trial that are essentially the paper printout of what a DNA profile looks like. She reviewed those, the defense DNA expert reviewed those, and drew the same conclusions. Henry Segura is not included in anything. Henry Segura is excluded from virtually all of the DNA samples collected. But that's not all. Other people were found to have contributed DNA. People outside the victim's family. People outside the victim's group of friends. Angel Antonio Avila Quinones. The phone that was ripped out of the wall. Phone cord ripped in half. His DNA was found on that phone cord, on that phone cradle. The defense DNA expert looked at the evidentiary sample, looked at the DNA chart, the electropherogram, for the swab of that phone. He compared it to the DNA profile for Mr. Avila. He was able to do what they call inclusion statistics. Rather than saying, you know, it's a 99.9% match, that's not what the DNA experts say. They do it in terms of rate of inclusion or frequency of occurrence. What frequency of occurrence means is you would expect to see this particular DNA profile occur this many times within a given population. In this case, the rate of occurrence, or frequency of occurrence, was 1 in every 15,000 Latins. Mr. Avila is Latin. It occurs one time in every 15,000 Latins. One person would be included. That means, he'll tell you, the opposite, 14,999 people out of 15,000 would be excluded, eliminated as possible contributors, and could not have contributed to that DNA because they don't have those DNA numbers at those DNA markers. Math is simple. 99.95% of the population of the Latin people on this planet are eliminated from being a possible contributor to that DNA mixture. But Angel Antonio Avila Quinones was included. He wasn't the only person who they found evidence relating to, though. It was obvious, and you'll see pictures of this, it was obvious Brandy Peters fought heroically for her children's lives. It's true. It's true that she was beaten to death with multiple different objects and suffered horrible wounds. But she continued to fight until the life left her body. Her fingers are broken. Her acrylic nails ripped from her hand. Her knuckles bruised and cut and swollen. There was DNA under her fingernails. Under Brandy's right index fingernail, foreign female DNA, I always say foreign, that means not her DNA, was found. Not her daughter's, not anybody else around the house who she's friends with or family with. Under her right pinky fingernail, foreign female DNA. Under her left index fingernail, foreign female DNA. Under her left middle fingernail, foreign female DNA. There was also a shovel located right next to Brandy's body in the foyer. Upon the shovel, Joe Ellen Brown discovered foreign male DNA. Henry Segura is excluded as a possible contributor to the foreign male DNA on the shovel found right next to her body. The crime scene forensics also proved definitively that multiple people were involved in the commission of the offense. There were 4 separate sets of footprints in the blood in this case. Footprints that did not belong to the victims and did not belong to law enforcement. Victim Peters suffered wounds from multiple different types of objects, sharp and blunt. At least 2, plus the gun. The forensic evidence further proves that one of the victims, Tanaya, was held up by one person and shot by another. The way that we know that is that, number one, there's no saturation of her blood on the floor, meaning once she was shot, her body never hit the ground. Secondly, there's something called stippling on the back of her head. What that means is that the gun that shoots her has to be within roughly 3 feet of her head at the time she's shot. What we don't see, however, is soot deposit, which means that the gun has to be at least a foot away from her head. So if it was one person, he'd have to be holding her like this with the gun way back here and then hold her up after she's shot. Suppose someone could make that argument, but you won't hear me make that argument. In addition to that, we have, as I mentioned before, foreign DNA at different locations on different objects from different people. Again, consistent with the notion that multiple people were involved in the commission of the offense. And then we have the type of evidence that we talked about in jury selection, circumstantial evidence. One of the types of circumstantial evidence you'll be asked to consider here is evidence pertaining to motive. There are a few things you should know about the motive the state's asserting here. It's true Mr. Segura did have a back child support judgment against him. He was going to be asked to pay $700 and some odd a month. It's also true that he was a little bit behind at the time. He was a little strapped for cash. He'd been injured and wasn't able to work like he normally did. But it didn't take him that long to get back on his feet. By the time he was arrested up in Minnesota, he was on a job where he was making $10,000 a month. Now, I'll tell you, Mr. Segura doesn't report all of his income. Sometimes he gets paid partially under the table. Sometimes he gets paid totally under the table. But he had no shortage of cash under normal circumstances. His wife, Malika, or now ex-wife, Malika, will tell you Henry would routinely spend $700, $800, $900, $1,000 a month fixing up the old cars that he worked on at his house. Another thing that you'll be asked to consider, and you'll hear evidence about pertaining to his child support debt, is that he actually helped facilitate institution of that child support debt. He went twice on 2 separate occasions, because they lost paperwork once, to the DFS office on North Monroe Street and provided paperwork to help push that process along, move it along, so that he didn't have to keep having the victim ask him for cash as opposed to just paying through DFS. Another thing that you'll hear testimony about is that Mr. Segura had been through the child support process before and knew exactly how to deal with it. One of his child's mothers, and he does have children out of wedlock, Tamika Steele Hawkins, Clark, I guess she's now married, Clark, will testify on his behalf at this trial. She went further than victim Peters had ever gotten with her child support dispute with the defendant. She actually had him at one point, several years ago, many years ago now, thrown in jail. But he got out, he went to court, he got the child support judgment reduced because, as in this case, Ms. Hawkins waited until her child was a few years old to go have paternity established. And when that happens, a large back child support judgment hits. Mr. Segura went to court. He explained to the judge he'd been buying items and providing cash all throughout the child's life at different intervals. And the judge reduced the judgment, and he never got put back in jail after that. He knew how to do it. That's all he had to do in this case. And that's what he would have done in this case, because he had been making cash payments at irregular intervals during Javante's lifetime. He simply didn't have time to do that before he was killed. The other thing that you'll hear testimony about and be asked to consider in the context of thinking about the motive the state has put before you is that it wasn't just Brandy that was killed. Javante is Mr. Segura's son. The 2 little girls that were killed lived with him. He and Brandy, during a time when Malika Segura and Henry Segura were going through a rough patch, Brandy was one of Mr. Segura's girlfriends, and he lived with her for a while. Those little girls called him Daddy. He took them to school. He helped potty train. Ask yourself, in the context of motive consideration, as you hear the evidence, whether slaughtering those 3 children could possibly have anything to do with child support. Another important piece of circumstantial evidence relates to the time of death. You've seen the cell phone data. We don't dispute the cell phone data. Henry is at Brandy's house between 5-ish, a little after that maybe, and 8 o'clock. He lied about that I'll explain that to you in a little while. He was there at her house between 5 and 8 o'clock. But she wasn't dead during that time. And there's a lot of circumstantial evidence which can be introduced to prove that. Number one, there's a witness named Marquise Davis who lived with one of the witnesses the state told you about, C.C. Timmons. Marquise Davis, on the day of the murder, saw someone else's vehicle in Brandy's driveway at 8:30 p.m., right after Henry had left. In fact, that's the reason Henry left, because somebody else was coming over. Marquise Davis will tell you he knows for certain what Henry's truck looks like. Henry has a very distinctive truck. It has big fat back tires, it has sparkly green paint, and it has a spoiler on the back. That truck in her driveway was not his truck. Another piece of important evidence. You heard the state talk about the digested food in the victim's stomach. Marquise Davis fed the victims their last meal at 7 o'clock p.m. the day of the murder. They don't know that because they've never spoken to him. Marquise Davis was making oxtail stew on the day of the murder. He had been cooking it for some hours. At 6:53, C.C. Timmons texted Brandy and asked her if she wanted some. The girls were over playing at their house at that time, at C.C. and Marquise Davis's house. Brandy said she didn't want any. So he fed the girls some of the stew. They ate it and shortly thereafter went home. Another piece of evidence, which tends to indicate the murders happened much later, is that Brandy's sister, Monica Peters, told police the day the bodies were discovered on the scene that she last spoke to Brandy at 10 o'clock p.m. Why is that significant? Because both sides agree Henry Segura is home by 9:31 p.m. on the night of the murder and never leaves again. Both phones, his girlfriend phone and his primary phone, are home and active for the rest of the night. Monica Peters says she talked to her at 10 o'clock p.m. Another piece of circumstantial evidence is that someone did hear something. Just not the type of someone you might have thought. These houses are really close together. And the evidence is going to show they're not, by any stretch of the imagination, quiet houses. In fact, if you stand in front of Brandy Peters' house, you can hear the toilet flush in either one of her next door neighbor's house. At 12:30 p.m., the dog at the house right next door to Brandy Peters started going absolutely insane. Absolutely insane. To the point where neighbors, probably 100 yards away, called the police. The police actually came out and did a report. Welfare drive through the neighborhood, didn't see anything. That fact is significant because you'll hear forensic evidence which shows at some point during the altercation, Brandy Peters made it out of the house. There are blood transfer marks going from inside her house to outside her house, through the front door. There's blood spatter on the vinyl siding outside of the house, meaning she gets out the door, somebody hits her from behind. She made it all the way to the grass. We know that because she's got a grass stain on the bottom of her sock before she's grabbed and taken back inside. That evidence is consistent with the dog going crazy, to the point where neighbors have to call the police. Another piece of important circumstantial evidence has to do with the cleanup scene, Jack McLean Park. At least one of the people involved in the commission of the offense probably cleaned up at Jack McLean Park. How do we know that? Within 5 days of the offense, law enforcement discovered clothes that had been covered in blood, the assailant's blood, apparently. They discovered shop towels, they discovered bleach, they found a bunch of pairs of latex gloves, they found blood drops on the sink at the bathroom at the park. There's a couple interesting pieces of information about the clothing that they found there. Number one, the shirt, there's a dress shirt and a t-shirt. The dress shirt has some puncture damage through one of the sleeves. And from that puncture area, blood covers the shirt. That blood was tested. It excludes the victims. Henry Segura has not been included as a contributor to that blood. Additionally, new clothing tags were found at the scene. Pants tags, shoe tags. The pant size was 44 waist. Mr. Segura was size 36 at the time. You'll hear from his wife. You'll see pants from his dad that had been at his dad's house since he was arrested. Mr. Segura is also a size 11, not a size 12. Another thing that you can glean from the evidence found at Jack McLean Park with respect to the damage to the shirt and the blood on the shirt, especially when you combine it with the state of Brandy's hands, is that the person or people who were engaged in battle with Brandy would have been messed up. Mr. Segura is a light-skinned African-American man. Light-skinned African-American people tend to show bruises, tend to show scratches. He was photographed by TPD the day after the incident without a mark on it. Now, he did have one tiny little scratch on his forearm, nowhere near the injury point on the sleeve. Tiny little scratch, couldn't have produced blood. That tiny little scratch was from shooting bows and arrows and retrieving arrows out of a rose bush earlier that day. Not at all consistent with the type of injuries someone engaged in this violent conflict would have shown. One of the other pieces of circumstantial evidence you'll be asked to look at is the lack of evidence that ties Mr. Segura to this offense. There is no DNA. There are no witnesses that tie him to the offense. There's no physical evidence of any kind which ties him to the offense. You'll hear from the medical examiner, crime scene reconstructionist, that there was blood spatter everywhere. The people who committed this offense would have been covered in the victim's blood. None of the victim's blood is in his car or his truck. None of the victim's blood is found on clothing anywhere near him. You'll also hear that following the murders, Tallahassee Police Department not only got all his communications from both his girlfriend phone and his normal cell phone, they wiretapped or put listening devices in his truck and followed him with GPS. Over the course of months, not a single communication ever with any co-conspirators. No communications on either cell phone with any co-conspirators. And then we have the fact that an opportunity was missed to get at least some of the assailants on HD video buying their cleanup clothes. At the scene at Jack McLean Park is a UPC tag. You will hear that law enforcement can routinely, in the course of an investigation, if it's during the time frame where the store still has their video, and it was only 5 days, they can take a UPC code to Walmart. This is a Walmart tag, it said Walmart on it, the UPC code was fully intact, and get the video of the purchase where that item was bought. They just bagged it, took it to TPD, never bothered to get the video. You're also going to hear that during the course of the investigation, credible evidence was discovered linking a particular person to the offense, somebody other than Mr. Segura. Detective Basio claimed initially that that was nothing. It turned out to be nothing. They got the DNA, they talked to his alibi witnesses, got the cell phone. What actually happened was they got the DNA, they got his DNA, never sent it to TPD, or to FDLE for testing, never compared it to any of the evidentiary exhibits found in this case. They never went and interviewed any of his alibi witnesses. They never bothered to get his phone records. They did get his associate's phone records, and those phone records showed his associate in the area of Brandy Peters' house all night. When asked about that, why he didn't get that information regarding this particular suspect, Detective Basio said, well, he just had a gut feeling the guy was telling the truth. The last piece of circumstantial evidence you'll get to see is not overwhelming. It's just a glimpse. It's just a glimpse into how Mr. Segura was feeling and dealing with this. Witnesses will tell you, after the deaths, on his dashboard in his truck, he constantly kept Javante's obituary. I submit that's inconsistent with the state's theory. So why are we here? You heard some of the evidence. There's obviously some evidence which made it look bad initially. Let's start with why he lied about being there. Henry Segura is one of the most unfaithful people you will ever hear about. He always had been. He has children out of wedlock, cheated on his wife basically their entire relationship. He had a son pass away about a year and a half before this incident from natural causes. He was born prematurely. At that point, he made a promise to his wife that he was done with that. He would not cheat anymore. He broke that promise. Repeatedly. He lied about one thing over and over and over in his multiple interviews with the police. Not one of those lies was specific to Brandy Peters. They asked him, do you cheat on your wife? Not since our son died. Do you cheat with Natasha Hawthorne? Absolutely not. We're just friends. Cheat with this person. You cheat with that person. No, no, no. You're going to see his text messages. He's texting random women. Sex, question mark? He's having conversation with Natasha Hawthorne constantly about hooking up. What happened with Brandy Peters is that sort of a chance encounter led them to hook up again. It had been quite a while since Mr. Segura and Brandy Peters had been together, but this was how that sequence went. On Tuesday, Brandy Peters was mad at Henry. She texted him basically saying, I'm going to have you put in jail for not paying child support. Wednesday, Henry goes over to her house and kind of smooths it over. Look, I've been injured. I haven't been able to work. You know I make money. Let me get on top of it. We'll take care of it. Everything was fine after that. How do we know it was fine after that? Because on Thursday, Brandy Peters texts Henry and says, man, you look good yesterday. If you weren't my baby daddy, I would have hooked up with you. Henry, ever the opportunist, immediately starts calling back with her. That's why they're calling all day Thursday and Friday. They're planning their hookup. The call at 2:15 or so, Brandy's basically telling them we're going to pick up the girls from school, we're going to be back soon. It took a little longer, however, than what they had planned to actually get to do it because Brandy's mom was with them. Brandy ended up going to get a snack at Burger King. She brought it back. Finally, Brandy's mom left at about 5 o'clock. That's when Henry came over. They did have sex. He left at some point later after they had sex. He was there while she was on the phone with her mom. He was there when she was making herself some food to eat. He was talking with Javante. He spent a little time with him, and then he left. And then we know someone else was there. I know when you hear the information about the Star 67 calls, that sounds nefarious. There was nothing nefarious about that. What you'll hear is that the only reason he was Star 67ing Brandy is because she psycho calls. And he doesn't want her psycho calling him when he's with one of his other girlfriends. That's what he uses that Star 67 for, to prevent her from getting his girlfriend phone number. If she's going to call him, he wants it to be on his primary phone. We've got those text messages to show you. You'll see the communications that were taking place between Brandy and Henry. She knew that was his phone. And the other part of it is, he doesn't think anybody's ever going to find his girlfriend phone. That's what he's trying to hide. He has no reason to block the phone number to prevent it from being on phone records. It shows up on phone records anyway. Just because you start Star 67 doesn't mean the number isn't going to show up on the phone records. That's not what he was trying to do. He was trying to prevent her from calling him constantly. The other reason that we're here is because of Tyra Wilcoxon. Tyra Wilcoxon says Henry came to her the week of the murder. He was all mad. He wanted a gun. That's not what the evidence is going to be. Tyra Wilcoxon and Henry had a messy breakup. He left her on the side of the road in Savannah, Georgia after a fight. She called his wife Malika and told her that she was on the road with Henry and they had been having an affair. And she saw an opportunity to make money. There was a $25,000 Crime Stoppers reward. This guy is her ex-boyfriend. And so she goes and tells TPD, he came to my house asking for a gun. The cell phone records will prove Henry Segura was nowhere near Tyra Wilcoxon's house during the week of the murder, as she claims. And then you have Kelsey Kennard, last but not least. His testimony is not consistent with the other evidence, not consistent with the facts, and not consistent with logic. And you'll be given an instruction by the judge that tells you to use extreme caution when evaluating the testimony of snitch witnesses. There's a reason we're here, right? There's a reason we're here. There was some evidence which made it look like initially Henry Segur was involved in or committed this murder. But that's not the best evidence. The best evidence will be introduced by the defense. I will show you who he is before the end of this trial. Thank you.
I think it's a little bit early, but I think we're going to take a lunch break at this point, because I have a legal issue I need to resolve with the attorneys, and we don't need you sitting in the jury room while we do that. So let's go ahead and take our lunch break at this point in time. Let's be back at 12:30. I'll give you an hour and 10 minutes. We ought to be able to get our legal issue resolved and have enough time for a little lunch. You've explained to them where you want them to meet. Just leave your notes where you are. Have a nice lunch. Mr. Timmons going to be your next witness, Mr. Keith?
Give him the lunch break, yes, sir. Actually, it's going to be Mrs. Timmons.
What's that?
It's going to be Mrs. Timmons.
Okay. One or the other of them. It was going to be a little difficult to get them here quickly,
yes,
so that's why I wanted to go ahead and take the lunch break. All right, we wanted to be heard. Y'all were going to work out which photos we're talking about?
I don't know how relevant Mr. Fuchs thinks the pictures of victim Brandy Peters' body are. It does show some blood spatter on the walls around her and the ceiling. There will be testimony about blood spatter. If that's the purpose for which he intends to introduce it, I don't think I would object to that. If it's not for that purpose, I wouldn't see any relevance to those pictures. With respect to the pictures of the kids in the tub, I absolutely object. Those pictures are not relevant to any material fact issue at all. Nothing as part of the defense reconstruction testimony will touch on the kids being in the bathroom.
Let me see what photos we're talking about. They've been marked.
These are the initial photos we're talking about. There are going to be some more crime scene photos as it relates to things that are in addition to those of the initial witnesses.
Well, what I was hoping is y'all were going to narrow it down to what pictures are actually objected to. So,
there were two in there. They're the only two. With respect to the kids, there's just two of them in the back that I object to both of those.
I would take it the objection is to state's composite 6L and M. Those are the two pictures you're talking about. Two of the.
I don't know the composite exhibit number, but if those are those two, yes, sir.
All right. Mr. Pugh.
Your Honor, crime scene. It's what law enforcement officers came into the home. It's what law enforcement officers found. There's going to be testimony from law enforcement officer Wyman that when he first came and cleared the house, that he was only able to see that there were two children in the bathtub, that he was actually told by witnesses outside that there was supposed to be a third, so he had to go back in and see the children. Your Honor, because time of death is an issue, there's clothing issues that are involved, how the children were found, all the things are relevant as far as where the children were found. I don't understand how a crime scene photo, we try to minimize them as much as possible, but how the children are found in the bathtub, in the manner in which they are, how it's not relevant. So I try to minimize them as much as possible, but I can't change the way that the children were found and the way by law enforcement officers.
Further, Mr. Prince?
just to the extent that there is an issue of that nature that needs to be addressed, I think it would be more appropriately addressed through testimony. Again, those issues are not in dispute.
I'll overrule the objection. Further issues we need to resolve before we get into the testimony?
Not from the defense.
And Your Honor, I will show the video that's in question to Mr. French during the break, and he can renew any objections regarding that.
Is it going to basically show the same thing?
Yes, sir. Would you like me to give you the disc as well so you can look at it?
No. Anything else?
No.
All right, we'll be in recess till 12:30.
Welcome back to the Law News Network. I'm your host, Jesse Weber. You were just watching the ending, the defense's opening in the Henry Segura trial out of Florida. A very passionate defense's opening. I think it was, in my opinion, a stronger opening for the defense than it was for the prosecution. Basically just eliminating the possibility for why Henry Segura would be the suspect in this case. So they're in a lunch break right now. We're waiting to hear back about the Joshua Gaspar case as well. We're going to be turning to that coverage as soon as it comes back from break. I will be signing off, so thank you for tuning in with me. Deborah Blum will be taking over. But in the meantime, as we wait for Gaspar and Segura, I am going to turn now to a clip from Joshua Gaspar. Again, we were covering this earlier. This is the testimony of Dr. Richard DeFranco. He's the doctor who actually prescribed methadone to the defendant in this case, and methadone is what we're talking about when we talk about driving under the influence here. This was in the Joshua Gaspar's system as he was driving, and the question is whether or not this did affect his driving ability, did it impair his driving ability. Well, the doctor, Dr. Richard DeFranco, takes the position that methadone really wouldn't affect his ability to drive. And if that's the case, then that charge about driving under the, aggravated vehicular homicide, about driving under the influence, might not stand. So he provides very important testimony in this case, key testimony. So let's take a listen at that, and we'll be back here with more analysis and coverage.
Risk prior to prescribing and monitor all patients regularly for the development of these behaviors conditions. Serious life-threatening or fatal respiratory depression may occur. Monitor for respiratory depression, especially during initiation or following a dose increase. Accidental ingestion, especially in children, can result in fatal overdose. Pardon me? QT interval prolongation and serious arrhythmia, torsades du points, reported. Closely monitor for changes in cardiac rhythm during initiation and titration. Prolonged use during pregnancy can result in neonatal opioid withdrawal syndrome. Advise pregnant women of the risk and ensure availability of appropriate treatment. For detoxification and maintenance of opiate dependence, methadone should be administered in accordance with treatment standards, including limitations on unsupervised administration.
Thank you, Doctor. I appreciate that this is not pleasant to be on the witness stand in a matter such as this, but I appreciate your cooperation. Turning to the subject at hand, Mr. Gaspar, I want to show you a record. States 1461, if I may approach, Judge.
Yes.
Can you review this, please? Tell me if you know what that is or recognize it.
This is a report generated from the clinic, CAAA Methadone Clinic, for the dates from February 24, 2016 through September 29, 2016, indicating methadone dosing, and it includes the date and time that the dose was given, and also the nurse that administered the dose.
And who's the patient?
The patient is Joshua Gaspar.
Were you the treating physician for the time period in reference?
During that time, yes.
Just tell us the interrelationship of when a person comes in, let's say they're an established patient, what is the protocol, or how does the clinic work? I come in, I see the nurse. How often do I see the nurse? How often do I see you, the treating physician? How does that all work?
Okay, so sometimes the patient just comes in to get their dose of methadone, and they do that daily, at least for the first 6 months. And in that case, they come into the clinic and they wait in line, go to the dosing window, and they talk to the nurse and identify themselves by name and by their clinic ID number. And then they're given their dose, and the nurse talks to them afterwards. And during that time, the nurse is watching them and assessing them and seeing how they look, and that's all part of it. As far as how often do they see me and the nurse that I work with, they would see me for an initial visit, and then they would usually see me weekly until they're stabilized, and then less frequently, sometimes monthly to start with, but there are some patients that I would review every 3 months but would maybe not see more frequently than once in a 6-month period if they've been there for a few years.
Okay. So in that scenario of the compliant patient, somebody who's attending regularly, they're on a good dose, they're stable, and they show regularly, you can extend your review period by your discretion.
Well, we do a 90-day review of all patients. When I started, we had about 350 patients, and after 4 years, or just short of 4 years there, we had almost 750. So we had a lot of patients, but there are government and state regulations that we have to review their dose every 90 days. So we had a mechanism, and I developed a flow chart so that each patient would have, every 90 days, there would be a document produced that would have their name, how many counseling appointments they've been to, their dose, what their urine results were, all that information, comments from the counselor, we would review those. And for patients who were struggling, we would meet and discuss them. So there was that 90-day process, but in addition, I would see them in the intervals that I stated.
Okay. Now, can there occur a circumstance where somebody does not appear as scheduled, falls out of compliance, that would trigger a sooner than 90-day review by you to find out what's going on with that patient?
Yes.
And how would you become aware of that?
Well, at the end of each day, there was a report generated that was patients who had not shown up for 2 days in a row or longer, and then, if there were a certain number of patients, we would talk about those and ask, does somebody know why, were they out of town in the hospital or whatever, and if there was no explanation, we would investigate that.
Okay.
So we did keep track, yeah.
Obviously. And then let's say you summon you have the power, the ability to summon the patient in if they've missed, right?
Well, yes and no. Some patients are difficult to get a hold of, but if somebody missed for 3 or 4 days, we didn't know why, we would have usually the counselor first try to call them. If we couldn't get a hold of them, we would put a note in the computer for them to see the doctor before their next dose. So we had different ways we tried to get in touch with patients.
Turning to the exhibit in front of you, the dose record for Mr. Gaspar.
Yes.
Do you see what's indicated as to the I think it's the 10th and the 11th of September 2016 on the first page there?
Yes, I do.
And what does it indicate?
That he did not dose on September 10th, and he did not dose on September 11th.
And the record shows absent, correct?
Yes.
So where we see absent, it means patient did not appear for dosing.
Yes.
Okay. So in this particular instance, were you aware of that when it occurred?
I don't recall.
Okay. Do you recall having any office visit or checkup with Mr. Gaspar after his 2 misses on the 10th and the 11th, but before this event? That brings us here on the 15th.
The date of the event was the 15th?
Correct. September 15, 2016 was the day of this fatality.
So you're asking me, if I understand this, did I see Mr. Gaspar during that 4-day interval?
Correct.
I don't know.
All right, I understand. You manage how many patients? Back then, how many patients?
Back then, it was close to 7, maybe 680.
I'm sorry?
About 680.
Okay. So how many patients would be in a daily case, though? If you're having a day full of appointments, how many could you see in a day?
Quite a few, up to 30, maybe 35.
Okay. Obviously, as we'll talk about, you became aware of what happened on September 15th, right? With Mr. Gaspar?
Yes, I did.
Okay. How and when did you become aware?
I became aware the day after when he came into my office.
All right. And how did he come into your office?
With officer escort.
Okay. And he was in custody, right?
Yes.
He was in handcuffs, right?
That's correct.
And why were they bringing him to you the day after this fatality?
That's a good question. It may have been because of the 2 days absent, or it may have been because he had a scheduled appointment. I'm not sure. They were presumably bringing him to the clinic to get his methadone dose.
I understand. The record before you, what's that exhibit number once again, please?
1461.
Okay. It trails off after what date? What's the last recorded dose administration?
September 17th, 2016.
And so he appeared on the 16th and the 17th, and then the record stops, basically, right?
He was absent 2 days, and then he appeared on the 12th, 13th, 14th, 15th, 16th, 17th. And then after that, it says absent for the remainder.
Okay. There's various columns like a spreadsheet on that exhibit. For the 15th, does it have a time of dosing recorded?
It does.
And what is the time of dosing administration on September 15th, 2016?
12:34 p.m.
And from your personal experience, do you know the computer clock that's on that record to be accurate?
You know, we did have disparities of a minute, a few minutes, but yes, in general, accurate, yes.
But no, not huge disparities?
Not hours, no.
Okay. So would you accept 12:34 on the 15th as the time he received his dose?
Most probably, yes.
So returning to my earlier question, we have absence on the 10th and the 11th. Then we have successive dosing, 12th, 13th, 14th, and 15th, right?
Yes.
Was there a dose increase during this relative time period for Mr. Gaspar? Was his dosing changed?
From what date to what date are you asking about, please?
Well, in this week that we're looking at, if the 15th, I believe, was a Thursday, let's just look at the preceding 7 days. Was there a dose change that you recall or are aware of?
Yes, there was.
And how do you know that?
Welcome back to the Law News Network. I'm Deborah Blum, and we're going to go live back into the Joshua Gaspar trial. He's accused of killing State Trooper Velez. Let's go live.
What time's he land?
11.
Oh,
What time would you want me to finish the direct?
10 till.
A little bit impossible.
I don't know, how long do you think it'll be?
I just explained the conversation we've had. I'm going to try to be as efficient as possible. 20, 30 minutes is like a guess. It could be shorter.
So if you don't, so you probably would finish his direct, and I don't know if you intend to cross, then you may have to do it after your expert.
Okay.
Can I bring the jury judge?
Yes.
All rise. Court is in session. Please be seated.
On behalf of the state.
Thank you, Your Honor. The state calls Doug Elliott.
Sir, do you solemnly swear or affirm, subject to the penalties of perjury, that the testimony you're about to give here will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated.
Thank you.
Good morning, sir. Would you state and spell your name, please?
Good morning. My name is Doug Elliott, E-L-L-I-O-T-T.
Where are you employed?
I'm employed with the Ohio State Highway Patrol.
What is your rank?
I am a sergeant.
Where are you assigned?
I am assigned to our investigation section in Columbus, Ohio, located at our general headquarters.
I'm going to ask you to stay on the front of the mic because your voice isn't carrying right now if you're not on the
Sure.
Thank you. What are your duties in Columbus?
I am a assistant post commander for our investigative section. My duties, I have supervisory oversight of highway patrol personnel, as well as I have some case management oversight of the things that they do, and I also initiate criminal and non-criminal cases.
How long with the patrol?
I've been with the highway patrol since 1999.
Could give us a brief summary of your prior career experience.
I was first assigned right out of our training academy in 1999 to the Swanton Post, which covers the western third of the Ohio Turnpike. From there, I went to Toledo. I was assigned to the Toledo Post. From there, I served at a temporary assignment at our Findlay District headquarters as a temporary investigator. And then from there, I went back to the Toledo Post for a short time, and then I was assigned as a trooper to our general headquarters investigative section, where I am today, and I was promoted about 3 years ago.
What is the critical incident response team?
The Highway Patrol has a critical incident response team. The team is combined, or it's managed out of Columbus. It's managed out of our general headquarters, out of our investigation section. And it's comprised of a commander, which can be a captain, a staff lieutenant, or a lieutenant. And then it's comprised of some other personnel, to include myself at the rank of sergeant. And the critical incident response team is responsible for responding to defined officer-involved incidents that are serious in nature by policy.
Can you give us a brief description of what qualifies for a critical incident response?
We have about 7, different things that we respond to, or the critical incident team responds to, and one of those is the on-duty death of an officer.
During the course of a year, how many trooper fatalities on average?
Not very many. 1.
Are there years without any?
There are years without any, yes.
So, given the nature of the law enforcement agency being statewide, and you have posts throughout the state, but is there this centralized command function that can deliver resources to individual post commanders that they would ordinarily have?
Yes, there is.
What does it bring to the table, so to speak?
It brings to the table something that's the purpose. I should back up. The CERT team, its purpose is to kind of create a professional, unbiased, and consistent reporting system, investigation. So it's not uncommon that a post commander or a district commander might request us, depending on the situation.
Okay. Being based in Columbus, and you have a distant incident to respond to, are aircraft available to you?
Generally speaking, yes, depending on other things that are in place at the time.
But in the case of an officer fatality, is time of the essence to get to the scene before it's released? A major interstate can't be stopped for 24 hours, can it?
No, it cannot.
Okay. So is time a factor in how the patrol can respond to an interstate fatality?
Yes.
So you said that uniformity of reporting and assessing the incident. Why is that important to the patrol?
It's important that we handle our things in we try to be consistent. We don't want vast differences in the way we report these. We want to be consistent, and so what one person might do in another district may be acceptable, but we want to maintain that consistency of our critical incidents and the way we report them the same.
Is there any requirement that the patrol not be the investigating entity for its own employees on the job fatality?
No, I think it's a situation where, should we arrive on scene with another law enforcement agency that shares the jurisdiction with us, those issues are usually worked out at a rank much higher than me, but it's a cooperative effort.
Okay. You've heard the topic raised by Mr. Sin of the label I'm going to put on it to cover all these questions he may have asked in this regard, investigative bias, that you're investigating one of your own, so to speak, and his conduct or her conduct prior to their death. Can you speak on how you view that subject in answer to the claims or the questions raised by Mr. Sin about investigative bias?
When we investigate things, we are searching for the facts. We're not searching for opinions. We're not searching for anything else other than the facts. And we interview people. We submit reports. We submit lab reports. We take photographs. We are looking for the facts. We're not looking at anything beyond that.
In a hypothetical situation, if your employee did something that led to or caused their own death directly without the fault of the driver, would you still charge the driver just to cover the misconduct, if you will, of the employee?
No.
Why not?
It's been my experience that it's not professional. It's not truthful.
So let's turn to September 15, 2016. Where were you working that day?
I was working that day. I was working in our office in Columbus.
And were you notified of this event?
Yes, I was. My immediate supervisor, my lieutenant for the section, notified me of what had occurred and that a CERT team response was needed to the Cleveland area.
Do you recall from your own memory approximately what time you were notified?
That was about 1:30 p.m.
Now, prior to taking the stand here today, have you reviewed a report that you created covering the investigation that you participated in?
Yes, I have.
Let's work from memory for the time being, all right? Take us through what your initial decisions were before leaving Columbus.
As soon as I was notified, of course, with Columbus and Cleveland are quite a big distance away driving, not taking into account traffic conditions or whatever, things may have come along our way. So we had to make some decisions, some game time decisions of if I was going to drive or if they were going to see if there was an aircraft, Highway Patrol owned aircraft was available to fly me to Cleveland. And that was what was the decision that was made, that I was going to go to our hangar, which is located at the Ohio State University Airport, and one of our pilots was going to fly me to Cleveland.
Was that your personal decision or someone above you in rank?
That was somebody above me in rank.
Okay. So you're told, get on the plane, you're going to Cleveland?
Yes, sir.
Okay, then what?
Make contact with our aviation section. They had already been aware of it. There was a few other things that they were dealing with, but arranged to make that 20-minute drive to where the airport's located at. Met with the pilot. The pilot proceeded to go through their normal pre-flight inspections and so forth, and we were wheels up, so to speak, from Columbus.
What time did you arrive at Burke Airport here in Cleveland?
It was roughly 3:30, 3:40 p.m.
Okay. If you know, what time do you recall arriving on scene?
I was picked up by one of our Brook Park OSP troopers. In that day, there were some traffic issues, so it took us approximately a half an hour probably to negotiate that traffic to get to the scene.
Okay. You know who Lieutenant Ryan Chapman is?
Yes, I do.
And who is he?
He is one of our staff officers, and on this day, he was our critical incident team commander.
Okay. Upon arriving on scene, did you meet and consult with him as to what had been viewed or learned to that point?
Yes, I did.
And what issues did you identify? Now, are you in the position then of taking over control of this scene, or are you working for Chapman, so to speak? Which is it?
Staff Lieutenant Chapman is the commander of that scene, so he's making decisions and he's directed me to do different things.
Right. So he's giving you directives and you're bringing resources to his investigation?
Yes, that's correct.
Okay. So what tasks were immediately identified that you could aid in?
At the scene, I took possession of a iPhone, and at the scene, I also took possession of the in-car camera video that was saved to Trooper Velez's inside the car, the hard drive.
Okay. And what did you do with those items once you possessed them?
They were retained until we made our trip back to Columbus.
Okay. For the moment, I'm going to press pause, if you will, here. Ultimately, was the iPhone password protected?
Yes, it was.
Was it encrypted?
Yes, it was.
Were you able to open it and look into it?
No.
And did you attempt to obtain a search warrant for that purpose?
Yes, I did.
Okay. Did you ever attend any events that took place at Fairview Hospital?
Yes. After I had left the scene, I went to the hospital. Wasn't there very long, and which I took possession of some urine evidence and some blood evidence.
And what did you do with those items once you had them?
Those were transported back to Columbus, where I met with one of our lieutenants, who is a supervisor at our crime lab.
How were they transported?
They were transported by vehicle.
Same day?
Same day.
Okay. Now, if this was a different circumstance, would those be popped in a FedEx box and mailed?
Those are usually mailed, yes. Unless we have resources in place that we can relay those down, but typically they're mailed.
Would it make sense to do that if you're directly returning from Cleveland back to Columbus where the lab is?
No, not to put them in the mail, no. Wouldn't make sense.
Did you contact or consult with the medical examiner's office regarding Trooper Ken Velez?
Yes, I did.
Tell us a little bit about that.
I made some contact with the medical examiner's office to find out when their examinations would be done, and they gave me some feedback, and then ultimately I attended that examination.
You attended the autopsy?
Yes, I did.
Did you participate in issuance of any preservation requests to any telecommunications company concerning Mr. Gaspar?
Yes, I did. I had sent, I don't remember the exact date, but I did send, I think it was the day following the crash, I sent a preservation letter. And what that preservation letter is, it just asks the cell phone provider to retain those records for a period of time until we're able to proceed with other court orders as needed to obtain records.
Okay, I'm going to throw an acronym at you. OARRS, ORS. What is it?
That is a database that I believe is maintained by or regulated by the Ohio Pharmacy Board.
Okay, what does it do?
That shows our prescription histories that doctors issue out to us.
Okay, are you able to make law enforcement queries for prescriptions of individuals?
Yes, through a designated person for our agency.
Okay, was that query done for Mr. Gaspar?
Yes, it was.
Do you know what the results were?
Yes, there was some prescription history in there, I believe, if I recall correctly.
Now, this stretch of I-90, an interstate with ODOT jurisdiction over primarily this interstate, correct? Does ODOT have a system of cameras on their light poles throughout the state?
Yes, they do. They have a system of cameras, and those cameras are monitored from their traffic center in Columbus, which their office is actually located right next to mine.
Does every light pole have a camera?
No.
Tell us how that works.
It's my understanding, and I don't know, I'm just a layperson's understanding of this, but throughout different metropolitan areas around the state, the Ohio Department of Transportation has installed live camera feeds to monitor traffic.
Did there come a point in time in this investigation when ODOT was queried as to whether or not a camera had captured this event?
Yes.
What did you learn?
Couple things. Learned that the traffic video is only retained for 72 hours, and they do that because of the vast storage space that's needed to collect all the camera video throughout the state is limited. So they set a 72-hour limit on that, and then it purges.
Was there also a situation where the camera closest to this event was pointing in the opposite direction and could not have captured it?
That is my understanding, yes.
In terms of data capture, if you will, was anything done to attempt to query Ken Velez's laser device that he was using that day?
Yes, the laser device is, of course, manufactured by a company, and I made some contact with the company to see if there was any way that laser retains any kind of data from its use, much like your computer. If you save information to your computer, you can go back and look at the data. And from my conversations with the manufacturer, the data is not retained. So once the speed is displayed on the laser, there's only a short time until that laser goes into a sleep mode, so to speak, or shutdown mode, and it erases off the display.
Did there come a point in time when Sergeant Gable submitted an email to you detailing his observations for the roadside sobriety test that he's testified to?
Yes, there was a time, yes.
Okay. And did that get incorporated in your report?
Yes, it did.
Why?
He sent me the information, and typically when people send me that information, I usually include it in the report. In my day-to-day activity of what goes on.
Now, I'm going to press pause again in the timeline narrative. So we know this is a fatal that day. We we know from earlier testimony that the Ohio State Highway Patrol laboratory returned positive blood results within 2, maybe 3 days. I think the last report was the 19th, if I recall from the testimony. Given the nature of this type of case, why not march into Lakewood Muni Court with OVI tickets and pursue a municipal charge? Or Cleveland Municipal Court, whatever the jurisdiction is appropriate.
Because of the complexity of this case, and I'm vaguely aware of some legalities that the courts must deal with, and because of the complexity of the case, we basically compile all the information. We consult with the prosecuting attorney's office of what we have, and we make decisions whether or not to take this case and present it to a grand jury.
Okay. And in consultation with local prosecutorial authorities, specifically our office, the Cuyahoga County Prosecutor's Office, was a determination made for a grand jury present?
Yes, it was.
Okay. And in that instance, would you then still pursue a municipal court charging or presentment there?
It's been my experience, no.
Were there certain elements of this case that would take longer than 90 days to complete?
Yes.
Okay. And would that be compatible with the municipal court timeline for a municipal offense?
I don't know that I can answer that. I don't know what those timelines are.
Did there come a point in time when ODOT did send you some video and you couldn't access it or something like that?
Yeah, yes, they did.
Tell us about that.
At some point in time, I received an email from Staff Lieutenant Chapman that had an attachment from our ODOT personnel, and for whatever reason, I could not open the attachment. I think the attachment was corrupted.
Okay. Was that later cleared up or viewed?
No.
Do you know whether or not it contained a depiction of the event?
It did not. As we previously mentioned, the cameras weren't pointing the right way.
Okay. Did you have the opportunity to speak with Lieutenant Huggins and then learn of the interview of Dr. Keegan Connery?
Yes.
And did you incorporate a summary or a restatement of that interview in your report?
Yes, I did.
Why?
It's normal for us to go out and do some follow-up interviews with people. And Lieutenant Huggins and I, who were working together, decided that we would attempt to do some follow-up interviews of some witnesses.
Did you have any interaction with the plainclothes detectives in terms of their investigative activities at CAAA, Community Action Against Addiction, or in terms of records or search warrants for that clinic?
The troopers that were working on that part of the investigation briefly explained to me what they had found.
Okay. Did you request any professional records, yes or no, on Dr. DeFranco?
Not that I'm aware of. Not on my behalf, no.
Okay. Do you know of someone else in the course of this
Objection,
investigation?
relevance.
Sustained.
During the days, weeks, months that followed, did you have periodic investigative group meetings, follow-ups, and then also on occasion travel to Cleveland to meet with members of the prosecution to discuss the case?
Yes, I did.
any physical evidence that you handled, was it appropriately logged and handled in the correct fashion for physical evidence as dictated by Ohio State Highway Patrol policy?
Yes, it was.
So you flew to Cleveland. Did you fly back to Columbus?
No, I did not. I actually rode with Staff Lieutenant Chapman on the way back to Columbus.
And the physical samples that had been obtained at Fairview, they were in that vehicle with you?
Yes.
What was done with them upon your return to Columbus?
They were provided to Lieutenant Rudy Zupants, who is a supervisor at our crime lab.
Did you have any interaction with Mr. Gaspar on scene that day?
No, I did not.
Did you observe his conduct at any point that day?
No, I did not.
Thank you.
No questions, Your Honor.
So you can start talking. Thank you. All right, ladies and gentlemen, we're going to take a lunch break. If you're back downstairs at 1:20, we're going to be having an additional witness at 1:30. Maybe someone taken slightly out of order, but I'll have more information for you at that time. Won't consume you at all for your lunch. Keep in mind, don't discuss this case. I only want to discuss the case with you. Don't form or express an opinion. No investigation, no media. But do enjoy a nice day before the rain comes. Betsy Kling assured us it's coming, so.
Nice lunch.
We were just listening to testimony in the Gaspar matter, which is a case unlike many others. But now I want to get back to the Segura trial, which is also a case unlike many others. There was a brutal death of 4 people here, a mother and her 3 children, and the main suspect, the man that we see accused of the crime, is Henry Segura. But you're going to find out a lot of interesting details in this case, that the woman who was brutally murdered, she's linked to a Mexican drug cartel, and her death and her children's death could possibly be at the hands of this Mexican drug cartel. I want to take us back to the prosecutor's opening statement, and in my own personal opinion, I don't think the prosecutor did a strong enough job in saying, you know, the fact that she was linked to this Mexican drug cartel. He needed to say that absolutely, without a doubt, you shouldn't find that they were responsible for her death. Here's why, unequivocally, you need to find that Segura is the one that was responsible for her death. So I'm curious about your opinion when you listen to the opening statement of the prosecutor, which we're going to listen to now.
Around 4:30 in the evening. Now we have the undigested food that would have, or that was eaten within the past 3 hours. And then you take another look back at home, and you see over here where somebody was in the process of eating something. So you take all that into context, and you sit down and you think about what it is that normal dinners and things are eaten between the hours of 5, 6, 7, 8 o'clock in the evening. And all that adds up and is being consistent with the murders occurring between those hours that we talked about, 6:53 and 8:21. So now they've established when they believe the murders occurred. They've established communication at what Randy's doing. They've gone out and they've done this. And they start looking toward how are we going to apply this. And of course, as we talked about during jury selection, motive. Who had a reason to do this? You're going to hear investigators talk about the training that they have, and one of the main things and some of the things that they look for as it relates to this, as we already talked about, the wounds are very personal. So as it relates to the motive, one of the things they know through the training and experience is that many, many times these things come down to a couple of different situations. Either motive, love, relationship, money, in some way, shape, or form is usually connected to these. So they start looking for what that motive would be. What they're also going to look for is means. Who's got the ability to carry out something like this? One of the things you're going to hear from Dr. Flanagan is one of the wounds in the forehead area on Brandy Peters was she was hit so hard it actually crushed the skull. And she was hit repeatedly over and over and over. But because of that hit on your skull, somebody who did this had to have a lot of strength. Had to be really, really strong. The other thing you're going to hear from is Florida Department of Law Enforcement, Jeff Foggy. Jeff Foggy is now an agent. Back then he was a firearm analyst for many years. You heard that we actually recovered projectiles, which are the spent bullets, from the scene. We found one in the bathroom, or actually two in the bathroom, one in the hallway closet. Also, during the autopsy, other projectiles were removed actually from Ms. Peters. She was shot multiple times as well as beaten. The gunshot injuries were not the cause of the death, however. However, they were the cause of death. What you're going to hear is that so they start looking for these questions. And of course, the other thing they do is they look for who had the opportunity to do that. Who had access to the house? Who was there? Remember, there wasn't a forced entry at this home. So who would have been let in? Someone they knew? As I said, you're going to hear from Foggy, Jeff Foggy, that the gun that was utilized, the projectiles, were 32 caliber. Now, the interesting thing about 32 caliber is apparently there are two different kinds of bullets that can be used in a 32 caliber pistol. And it's a pistol round, it's not a rifle round. And if you use the wrong one, it actually doesn't work like it's supposed to. What happens is, and he can explain this a lot better, but essentially what happens is the bullet doesn't get the velocity and the energy that is usually you think of when it comes to firearms. And as a result, it doesn't have the power that it's supposed to. And what you're going to hear is with Brandy's injury, that she was actually shot one time in the head and it never pierced her skull. And as I said, none of those injuries, or the gunshots, were the cause for death because they didn't do enough damage. You're actually going to see photographs from the scene that show where a bullet basically bounced off one of those thin rails that are on shower stalls. It hit it, made a small dent, and bounced down to the ground. You're going to see another one where it hit a porcelain toilet and bounced onto the ground. So these were, even though they were gunshots, they didn't have any power behind them for whatever reason. So one of the things law enforcement officers do, of course, they've established that these are the kind of things they need to know in order to figure out where this investigation is going to go. Now what you're going to hear is that one of the first things they do is they're actually notifying Henry Segura of the death of his son. They know that Javante Segura is Henry Segura's son. They haven't heard from him. So law enforcement officers have to notify somebody, tell them. son passed away. And you're going to hear, of course, that law enforcement officers, when they do interviews, and this would apply no matter whether the person's a suspect, just a person that's a witness, or whatnot. And at the time, Mr. Segura was not a suspect in any way, shape, or form. This is for the purposes of letting them know about his child. This is for the purposes of going back and talking to family members, known acquaintances, getting that information they need from Brandy to figure out who might have done this, figure out who Brandy Peters was. That was the purpose behind this. So they're asking them questions. But of course, law enforcement are trained. They look for verbal and nonverbal cues. Not only what they say, but how they say it. Their posturing, things along those lines that might give an indication about whether the person's truthful or not. They look for whether the person has emotions or lack of emotions when they're telling certain information. They look, of course, for whether they're being deceived. And ultimately, they apply their investigative tools, the education they receive, their common sense, and those tools that they utilize day in and day out. And you're going to have an opportunity to see this initial this interview. And what you're going to see is Mr. Segura has a lack of emotions when he's told about his child. And not. Mr. Segura says, I was at home on the 19th during the time period. Just check my phone records. It'll tell you I'm home. Here's my phone number. 509-8380. Says that the next day he went down to Silas Thornton's house. Silas Thornton lives in Sopchoppy area. And the next morning, on the 20th, he went down to Mr. Thornton's house. So law enforcement officers, of course, want to talk to Mr. Thornton. So they ask for the phone number. And this actually is not on the interview. What happens here is that Mr. Segura tells law enforcement, so I don't have it on me, so investigator Lewis goes out to Mr. Segura's car, and at that point, Mr. Segura says, Mr. Thornton's phone number is 850-408-8669. He says, wait a minute, that's not it. And he gives another number. Officer Lewis takes them both down. Doesn't think any more of it. Next day, they go out. And talk to Silas Thornton. Silas Thornton says, yeah, I know Henry Segura. I don't know Brandy Peters. That's not my phone. You're going to hear that there's a CID meeting. And during this meeting, Chris Corbett's there along with the investigative team. And he's letting him know about this cell phone information. And he says, whoa, that number, we need to find out who it is that owns that 408-8669. Because that number was in contact with Brandy Peters all day on the day of the homicide. Multiple times throughout the course of the day. Investigator Lewis has recognized this. So wait, that's the one that belongs to Silas Thornton. Silas Thornton. Again, he says, I know Henry Segura, I work with them. They're both welders. So that 408-8669 number used to be his, but he was with Segura working with him and actually dropped it in some water and got some water damage. And during that time period, Mr. Segura says, dude, put it in a bag, put some rice in there, they'll absorb the water out of it and maybe it'll work again. That's what he does. However, he left it in Segura's truck, got a new phone, and moved on. But he does know that Mr. Segura uses that phone at that point. So now we have two phone numbers. We know the importance of this one because it is the one that Brandy Peters is talking about all day long in the day of the homicide. And this is the one that Mr. Segura tells us about. So you're going to hear at this particular time, but we really don't know who owns this phone. Mr. Segura says it's Silas Thornton. Mr. Thornton says it's Henry Segura. So now we're going to go back to the phone record. And this is where Investigator Corbett comes back in. Investigator Corbett says he goes back and he analyzes these particular records. And what he has found is that 8:30, in the morning, that we're talking about November the 19th, the day the state of search is the time of the homicide, that there's a phone call between Brandy Peters' phone and that 408-8669. Investigator Corbett's going to tell you that one of the things these records will let you know about is star 67 was used to make that phone call. What star 67 is a block. It doesn't tell you caller ID who it is that actually that phone belongs to. So this is a phone call that's being sent out from that number, but it's blocked, so it won't show up on Ms. Peters' phone. What you're going to hear is that phone call lasted for 56 minutes. Fair to say that a 56-minute phone call, probably someone she knows. What Investigator Corbett's also going to tell you is between 1:18 and 1:28 on that same day, there's a series of calls, all of which star 67 is utilized. I'll tell you again, at 2:13 p.m. there's another phone call lasting for 2 minutes and 35 seconds from that same phone number. Again, star 67 is used. Now, at 2:19 p.m., Ms. Peters sends a text message to 509-4380. That's the one and the phone number that Henry Segura gave to law enforcement as his phone number. And in that, she said, "You hang up on me?" What does that tell you about who she was talking to on the phone? If she's returning the text message to Henry Segura's phone, she talked to Mr. Segura. What you're going to hear then is at 2:27 p.m., the 408-8669 returns the phone call to Ms. Peters' phone, again, using the star 67 function. Again, this is the phone number that Mr. Segura gave, said it was Silas Thornton's phone. Never told law enforcement it was mine. Law enforcement officers dig a little deeper. They talked to Calvin Moore. Calvin Moore says, yeah, I know he had a 408 number. They talked to Tyrell Coxon. Said, yeah, I know he had a 408 number. So friends of Mr. Segura are confirming that they've actually talked to Mr. Segura on that 408 number. So now we've actually confirmed that that 850-408-8669, through the testimony, you're going to hear it, through the testimony of Tyrell Coxon, Calvin Moore, as well as the cell phone record, that this is in fact a phone that Mr. Segura utilizes.
Clearly I'm a novice at this because I threw to a clip of the prosecutor's opening and it was like a snooze fest. I don't know if you at home agree with me, but certainly I am not persuaded by this prosecutor. Let's talk about what we know in this case. The victim, the grown victim, was associated with a known drug cartel, and she was what's called a transporter. So when she would transport the drugs, she would skim a little bit off, so she would keep some of the cocaine for herself. And this, of course, aggravates the drug lords. So it's very likely that somebody somebody could have wanted to kill her for this or wanted the money back, and if she couldn't make payment, that they're going to get her. One of the things that I've learned as a defense attorney is that narcotics trafficking is a very dangerous profession to be in. And sure, maybe we shouldn't call it a profession, but I'm going to bring in our guest now. He is from California. His name is Adam Sastrin, and he is, like myself, a criminal defense attorney. Welcome.
Well, thanks for having me.
Yeah, of course. It's so great to be with you. So let's talk about some of the judge's rulings in this case. The judge is going to allow in testimony of a known drug cartel member who said that he ordered the hit from jail on Brandy Peters' life. 2, DNA evidence from another drug cartel member was found at the scene of the crime. And 3, most likely the judge is going to order a force order, meaning that 2 witnesses who don't want to come to court to testify, they're in prison, so the judge is most likely going to order that they be brought into court to testify with use of force because they both admitted to killing Brandy Peters and the children. What do you think about all of this?
Well, I mean, doesn't it all seem like in a way, the defense attorney is sort of creating a theory that it's sort of a rush to judgment. There are so many other people, so many other interesting factors in this case that don't involve the defendant who's charged. I mean, how often is it that you have a victim who's actually involved in, drug and weapons trafficking? You have numerous statements regarding other culpability with respect to the crime. So there is a real issue with reasonable doubt that the defense has been successful at crafting, I believe.
Absolutely. I fully agree with you. I think that the issue here is there are too many questions. We don't absolutely know beyond a reasonable doubt that Henry Segura is the person that perpetrated these horrific acts. Now, the prosecution's theory is that he owed approximately $20,000 in back child support. Is that a reason to murder somebody? Possibly, but what do you think the defense is going to do in this case to continue to highlight that there's reasonable doubt? Who do you think they'll call?
Well, first of all, going to the motive, I just can't imagine that a jury is going to believe that this person's going to kill their own son. There were 3 children. One of them was the son of the defendant because he doesn't want to pay child support to his ex. So they don't have a strong motive in this case. As far as other bases for reasonable doubt, well, it would certainly be the other 2 people that claim to have been involved that the judge is going to order out, so the defense can have more of a case in front of the jury to show that the defendant's not involved. And also with respect to the partial DNA match, which is so interesting, that there was actually at least another person who may have been present.
And what do you think that the prosecution is going to do here to try to prove their case? In their opening statement, which I accidentally had our staff here play for 15 minutes, despite it being extremely tedious to listen to, I hope that the prosecutor...
I'm so tedious.
I hope that the prosecutor gets to be a bit more uplifting and emotional. There's so much you can do in a case like this as the prosecutor. He tried to focus in on the fact that there were 3 innocent children that were murdered. But how would you handle that as a prosecutor, if you were to be a prosecutor?
If I were to be a prosecutor, which I never would be, you have to try to create a reason for the defendant's conduct. So what else can you say except for the fact that children were involved? Let's say, this is the prosecution's theory. The defendant did what he did because he was such a vile person that he didn't want to make payments and that he killed them. So you're trying to tug at the hearts of the jurors.
And how do you
But it's not really great. But nonetheless, I mean, there are issues with respect to, his ex-girlfriend saying that, this guy was looking for a firearm only days before the incident. So those are the things that I would sort of hit on. Well, yeah, it's hard to understand the motive, but at the same time, why is he asking for a gun?
Right, and I believe that the prosecution in their opening statement said that another individual, who most likely will testify or else they wouldn't speak about, is going to tell the jury that they too either saw the Henry Segura with a weapon or that he was asking about a weapon. So, you know, here we have these 3 beautiful children, but like you said, one of them was Henry Segura's own children. Now, in your experience, do you work with the defense of a lot of narcotic traffickers, or?
I do, yeah, I do drug sale cases.
And from your experience, you know, it is, would you agree with me that it is a really violent area of the law, and that people really do go to great lengths to make sure that they're able to continue trafficking, so the head of the organization is going to use a lot of violence?
Well, I mean, that's why it's so scary. You know, even when there's small quantities of drugs that are involved, often the prosecution would like a statement from the defendant saying, well, you know, where did you get these drugs from? But, you know, no one really wants to say anything because the consequences can be so severe. So they are scary cases, you know, whether it's a small quantity, you know, and of course when it's a large quantity of drugs.
I once had a realization while I was working on a federal narcotics matter where I realized that the reason that the sentencing is so harsh for people that are involved in drug crimes is because there is so much violence. People use traps, so they'll put the weapons, they'll put the drugs in a trap that could explode, causing great harm to other people. Here, it's interesting that Brandy Peters, she was 26, 27 years old, was the one that was transporting the drugs, and I've found that a lot of times the transporters do happen to be attractive women because they're going to fly under the radar. Have you seen anything similar in the cases that you've handled?
Well, of course. You know, it's so common to involve, you know, a female in cases like this. At the same time, going back to the trial, it makes the victim, unfortunately, a lot less sympathetic.
But I do think the fact that, I agree, we should go back to the trial. I do think that the fact that there were children here is a huge issue. You know, I'm curious about the relationship between the father and the child that it was murdered. I don't know how often he was seeing that child. I know that the defense in their opening statement said that, yeah, this is a guy that's not the best possible guy. He fathered children outside of his marriage. He was married at the time, and his child with his wife, I believe, died. So he made a vow to behave better, but he didn't behave better. So I wonder how that's going to come into play during the trial and what the prosecution is going to do with that.
Well, I mean, I think it's obviously it's a good point to raise, but at the same time, I mean, there are so many broken families, and just because you have a, you know, the defense can just say because you have a broken family doesn't mean you don't love your child any less, and that'd certainly be my tact in this case.
And you know, I know in this case that the police found inside the home a Walmart bag which contained shell casings, but I don't believe that those shell casings have actually been tied to the crime. Do you have any input on that?
You know, I don't either, and I was actually reading the same articles about it and wondering about it, so I think because the prosecution hasn't raised it, I think in fact that it is probably unrelated to the crime, but that doesn't, of course, mean that that the defendant did in fact fire a weapon that day when the incident occurred. But yeah, the fact that it's unrelated is something that I would absolutely jump on in this case.
I fully agree with you. Adam, we're actually going to go live back into the trial. Hopefully you'll still be with us when we have a break.
All right, great.
I mean, it's general. Sometimes we get calls to check on welfares of people. Say if the complainant hasn't heard from or seen a person in so long, they have us responded, check on them, make sure they're okay, check on their welfare.
Okay. Is that address in Leon County?
Yes, sir.
Okay, where is that located?
That's it's in the southeast section of town, and it's the nearest cross is going to be Paul Russell on Jim Lee Road, and you head south on Jim Lee, and it runs east and west. The street does, and you make a left on Saddle Creek Run.
So that's going to be over by the fairgrounds and Capitol
Tram Road
and Tram Road and all that, 4 Points and that kind of general area.
Yes, sir.
When you arrived at, I assume you went to 908 South Creek.
I did. I didn't go directly there, but more at the intersection of Jimley and Saddle Creek, where I met with the complainant.
Okay. And did you respond to the actual location?
I did.
Okay. Did any other officers respond?
Eventually, after me, I'd been there for a few minutes on my own.
Okay. When you first got there, what did you do?
Initially, I tried to find the complainant, and I talked to a couple of different people about what their concerns were, and they told me that there was a lot of blood on the outside of the house, and they hadn't seen the resident or her children.
Okay. And did you approach the house?
I did.
Did you wait for other law enforcement officers, or did you do it alone?
No, I did it alone.
Okay. When you approached the front door of the residence, what did you see?
As I approached the front door, I noticed there was blood on the exterior of the front door. There was also blood along the garage door on the east side of the garage, or I'm sorry, correction, on the west side of the garage door. So the house, as you walk up, the house faces south. The garage door the garage compartment juts out. So that exterior wall of the garage door, there was blood smeared along that as well.
Now you keep referring it to blood. How was it you were able to identify it as blood?
I just, with my experience in police work for the last 14 years and then state experience, but I recognized it as what appeared to be a dried color of blood.
When you say dried, what do you mean by that?
It was darker in nature, not fresh or runny.
Okay. All right. Whenever you observed what appeared to be dry blood on the house, what did you next do?
Obviously, I called in, or as I was approaching, I cleared the area of the front yard. There were children in a vehicle in the front yard, so I cleared the area.
What does that mean?
As far as clearing the area, I wanted to make it a safe area because I saw, a lot of dried blood on the exterior. Didn't know what was inside, if it was in the nature of occurring at that moment. So I was concerned with the children that were playing in a vehicle that was parked in the yard. And I was concerned for the neighbors, so I tried to get everybody back to a safe location so that I could scout the house and see what was going on, or if I heard anything.
What did you next do?
I went up, checked the getting cover, so I wasn't right out in the middle there in an unsafe position. Kind of moved alongside the garage door area, listening to see if I could hear, or seeing if I could hear anything. I got up to the front door to see if I could see in at all, and I couldn't. There were some curtains. I checked the door knob. It was locked. And then at that point, again, I was waiting for backup. I had emergency traffic, so only I would talk on the radio. And I went around, starting from the front, going around to the east of the house and circulating around the house, checking doors and windows and seeing if, listening for noises to hear if anything was active. And I made my way to the backyard.
Okay. And when you were checking for the doors or windows, did you find any that had been opened?
No.
Have you had occasion during your career to respond to burglaries and forced entry situations? Was there any sign of a forced entry at that point that you were able to see?
Not that I could tell. No.
Okay. So you made your way around to the back. What happened next?
Yes. I went around the back. Again, I was checking doorknobs and waiting for backup. The back door was locked. The window, there was a small area. The door was a window door, had glass. So there was an opening towards the bottom. I looked in the opening and I could see what appeared to be a leg or a body lying on the ground.
Okay. And from your perspective, where in the house are we talking about? Right there by the back door?
No, sir. It would have been the front area of the house. You could see a portion of it. So.
Now you mentioned that door. Had you checked that door to see if it was locked?
The handle, yes, and it was locked.
What did you next do?
I radioed. I was transmitting whatever I was experiencing or whatever I saw. Let them know that. Continued going around the house to check, and then went back to a position of cover to wait because backup was not too far away. So I went in next.
Right there. Right there. So you've gone around the side from the east side. Did you come up the west side, so you've done a full circle of the house?
I think I looked, I walked around to where I could look up the west side of the house to make sure there was nothing broken or damaged.
Okay. Did you find any signs of a forced entry at that point?
No.
Okay. What did you next do?
I went to the neighboring house, which would have been the house just east of 908. There was a car in the drive, kind of took a position of cover, waiting for the backup officer.
And then an officer finally arrived?
An officer arrived, and then we went to the front door.
Who was that officer?
Officer Kidd,
And that's spelled K-I-D-D, correct?
K-I-D-D, Derek Kidd.
So you and Officer Kidd approached the door?
Yes, sir.
All right, and we're talking about the door at 908?
The front door at 908.
Okay. What happens next?
Went to the front door, of course, still locked. I tried kicking the door, see if it would open. It wouldn't. I can't remember if he did or not. Then he got out his baton and broke the window on the right side, because the handle was on the right side, I believe, and he smashed the window alongside the right or the east side of the door.
Why was that done?
For entry.
Okay. Did y'all make entry?
Yes, sir.
How was it y'all were able to make entry?
Officer Kidd unlocked the bolt lock, both locks. The door handle was secured, and there was a bolt lock above it. So he unlocked the bolt lock, reached in the window first, and unlocked the bolt lock, and then entered that way.
Okay. All right, approach the witness.
You may.
I'm showing what you previously marked as State's Composite 5, photograph A and B. Without showing these to the jury, I should take a look at it, please. Do you recognize those?
Yes, sir.
As we'll refer to State's Composite 5A. What is it that we're looking at there?
The front lawn of 908 Saddle Creek Run.
Is that the home that you had approached with Officer Kidd?
Yes, sir.
It's the same home that you've gone around the circle and checked for any kind of entry?
Yes, sir.
Okay. Is that a fair and accurate depiction of that home?
Yes, sir.
Next, let's refer to photograph B, please.
Okay.
What are we looking at there?
The front door of 908 Saddle Creek Run.
Okay, and I noticed, I believe in that photograph, there may be a broken window on the right-hand side.
That's the window that he broke.
Okay.
With his
Your Honor, this time I move State's Composite 5, photograph A and B in evidence, please.
Any objection?
No, Your Honor.
They'll be admitted.
Publish to the jury, Your Honor, please.
You may.
Thank you.
As we go along, we'll show you things, but you'll have them to study much more carefully, during your deliberations. So don't feel like you have to memorize it. If you look at one and pass it on, so we don't have to wait for each person to look at both. We're going to be looking at a bunch of pictures. Seemed to me we could do it a lot quicker, show them on the presenter than wait for 14 people to look at it.
Yes, sir, I thought of that as I handed that one to the jury, but we'll do that in the future, I promise. All right, so at this point, you and Officer Kidd have reached in, you've unlocked the door. What'd you do next?
We just stepped inside to clear the immediate room, the front room just inside the front door and the kitchen area. And actually before stepping inside, I'm sorry, I had called into the window and asked if there was anybody inside and to present themselves, and I noticed a body on the floor.
Body on the floor, did it appear to have any life?
No.
What did you do next?
Then when we opened the door, stepped in and just cleared the front room and the kitchen, which was to the right there, and waited for another unit.
What do you say clear? What do you mean?
Clear meaning protective sweep, make sure nobody was in there alive or any suspects or anybody injured. Just checking the front room, whatever was visible, and checking the kitchen, and then backing off just a little bit and waiting for another officer who was almost on scene.
Who was that other officer?
Officer Sean Wyman.
Okay. So you remain in the, I guess, the general entry area?
Yes.
As you referred to, a body was laying there at the entryway.
Mm-hmm. Yes.
Was there any kind of blood pooling or anything like that?
Blood around her, on her, a large kind of hole in her head. So traumatic injury.
All right. Would it be fair to say that, I'm sure you made efforts not to, but that you would have had to step through some of the blood in order to gain entry to the home?
Yes, it was scattered all over. So.
And did Officer Wyman eventually arrive?
Yes.
Okay. And what happened after his arrival?
Then we conducted a protective sweep of the house, which is, again, going in rooms, checking doors, checking doorways, checking closets to make sure no other injured person was inside or suspects were inside. So.
And as you do a protective sweep, do y'all kind of all go together, or do you line up, or how's that done?
We go together. I was in the rear, Officer Wyman was in the front, and Officer Kidd was in the middle. So I was kind of keeping an eye out for behind us, what was going on.
Okay. As it relates to doors and windows, did you notice anything regarding I think you previously testified about the back door being locked. Mm-hmm. Did you notice anything about what the lock, the top lock, bottom lock, anything along those lines?
I think it was just a bottom lock, or the door handle.
How about How about the garage?
The garage was closed.
Okay. What about?
And we checked the garage.
What about the door that goes into the garage from the home?
I believe it was open, but I'm not 100%. So.
Okay. But the garage door itself is
unlocked, meaning, yeah.
Okay. Okay. No further questions.
Cross?
No questions.
All right, you can step down. Do we need to keep her any further?
She'll be retained, but she can go about her business, and we'll.
Do you need her for any reason?
She's still under defense.
All right. You'll be on call. You're free to go.
Okay.
The next witness?
Say we call with Officer Sean Wyman.
Kind of trying to get the PA system balanced. The controls in here are a little complicated, and we get it up too high and you get a big screech. So anyway, if at any point in time you can't hear somebody, just raise your hand. We're trying to kind of get it balanced, right? And along those lines, if at any point in time we've sat too long, you need a break for one reason or another, just raise your hand. We'll take a break, okay? Do you face the clerk and be sworn, please, sir?
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Have a seat.
Thanks,
Slide up the microphone, please, sir.
Good afternoon, sir.
Good afternoon.
Can you please introduce yourself to the jurors?
Hello, my name is Sean Wyman. I'm a Tallahassee police officer, 17-year law enforcement veteran.
And what is your role there at the Tallahassee Police Department?
Currently, I'm a patrol officer on the Northwest day shift rotation.
What does that mean?
Just means that I work on the northwest side of town during the day.
Okay. Back in 2010, did you have a similar role?
No, I was a canine handler at the time.
What does that mean?
Canine handler meaning somebody that has a patrol dog. My dog was narcotic certified and tracking certified, so we rolled around during the day and supported officers where we were needed.
Back on November 20th of 2010, did you have an occasion to respond to 908 Saddle Creek Run?
Yes, sir.
In the morning hours?
Yes, sir.
Okay. And as I understand it, you were not the first officer on scene?
No, sir.
When you arrived, what did you first do?
When I arrived, I went to the front door. I observed a woman that was laying there right by the front door, stepped around her, and went to the officers that were standing by at the hallway right there.
Okay. And what was your role to be, or what was your role ultimately there on the scene at that time?
Well, we wanted to secure and clear to make sure that there was nobody inside. And, you know, based on what they had already seen, what had already come out on the radio at that point, they were standing by waiting for another officer to get there so that we could do that safely.
Okay. When you say clear and go through the home and secure the home, is there a certain way you go about doing that?
Yes, sir.
How do you go about doing that?
Well, methodically, you want to clear anywhere where a human being could be actively hiding, and also look to make sure that there's nobody else that's hurt or injured inside, and that's what we were looking for.
When you do this, do you do it in a systematic way where you have certain people line up, or do you all just kind of go in shoulder to shoulder, or what's the deal?
It depends on who you're working with, to be honest with you. In this case, I was the most tactically sound as far, you know, because of my background. I was a TAC operator for 5 years before I went to K-9, and plus with my military background, I have a lot of tactical training with clearing rooms and things like that, so I took point.
Well, let me stop you right there.
Okay.
Let's talk about your experience real quick. You said you're in the military?
Yes, sir.
Okay, what did you do? How long were you in the military?
8 years.
And what was your duties there in the military?
I was an Army Ranger.
Fair to say, as an Army Ranger, you had a lot of experience clearing houses and things like that, and instructors.
Different locations, yes, sir.
And then you mentioned something about tactical offers.
Yes, sir.
What does that mean?
It's the Tactical Apprehension Control Team. A lot of people know it as SWAT, but we call it TAC here in Tallahassee.
Okay. So because of your experience, you took the lead?
Yes, sir.
Okay. Now, how do you go about systematically clearing a house in this nature?
Well, basically, you just start at the beginning. They had already cleared the main rooms, the living room and the kitchen area. They had already cleared those areas, so all we had left was the hallway and the corridor and the rooms that were along the hallway.
Okay. So what did you first do?
So we got in a line, one behind the other, single file, and I was the first one. I went to, the first thing I look for is which doors are open over which doors are closed. There's a couple of different rules that we follow. Open over closed, real over imagined, known over unknown. Well, in this case, the first door that I came to was on the right side, and that door was open, so that was the first door that I decided to go into.
When y'all are doing this in clearing rooms for safety purposes, do you have weapons deployed?
Yes, sir.
Okay, and by weapons, I'm talking about guns?
Yes, sir.
Okay. Did you have your sidearm?
Yes, sir.
Okay. How about the other officers? Same thing?
I believe so. Yes, sir.
Okay. So the first room you came to on the right-hand side, the door was open.
Yes, sir.
What room was that?
That ended up being a bathroom.
Okay. And whenever you clear a room, do you actually go into the room, or how do you go about clearing a bathroom in this particular case?
Well, it depends on what I can see and how big the room is. In this case, it was a fairly narrow room, so I was able to step in, turn the light on, do a quick sweep, if you will, and go from there.
All right, so you had to turn the light on?
I did turn the light on.
Okay. And what did you see?
I saw what I believed to be 2 juveniles that were in the bathtub, and the bathtub was filled with water, and I noticed that there was a red tint to the water.
What did you do next?
The next thing I did was I got on the radio and I called out that I have two deceased in the bathtub, and I turned around and walked right back out and started focusing on the next room.
Okay, and what's the next room you went to?
I believe the next room we went to was the next one down on the same side, but honestly I don't remember, because there were, I want to say there were 3 more rooms, but I don't remember exactly.
Okay. And each one of the rooms, in order to clear them, did you do the same procedure you would have done in the bathroom?
Yes, we went in, we cleared. If there was a bed, obviously we looked under the bed. If there was a closet, we looked in the closet.
Okay. In clearing this house, did you have an opportunity to basically go through each and every room, make sure nobody was there, and observe everything in that room?
Yes, sir.
You already talked about the body you found in the entryway, and then what you believe to be 2 juveniles in the bathroom. Did you find anybody else?
Not at that time.
Okay. I can show you what was previously marked as big composite 6, photographs 8 through N. You're on the first.
Good night.
Without showing these to the jury, actually take a look at those photographs, please. You have an opportunity to review those photographs?
Yes, sir.
Are those photographs a fair and accurate depiction of the home at 908 Saddle Creek Run whenever you made entry and subsequently cleared it?
Yes, sir.
Your Honor, this time I'm going to state composite number 6, photographs A through N into evidence, please.
Any additional objection
No, Your Honor.
prior to the subsequent, for the prior ruling of the court, they'll be admitted?
Thank you, Your Honor.
Is that M as in N or N?
N is in Nancy. What was the next thing you did, officer?
The next thing we did once we had it cleared was we got out of the house because we wanted to secure the scene. We didn't want to contaminate anything. I started looking for the best access point because I knew that there was going to be a lot of resources that were going to be coming in, and just started trying to do the basic crime scene things that we do: establish a scribe, establish security.
Okay, what do you mean? What does establish a scribe mean?
I apologize. A scribe is someone, their responsibility is to take notes of every person that comes into that crime scene, to document them, to put their name, the time they come in, and the time they exit. So we have an accurate timeline of everybody that comes into that crime scene, so we can keep track of that.
Okay, and were you able to establish a proper scribe?
Yes.
Okay. What's next?
The next thing was securing the area, using crime scene tape and just starting to rope off the area so that we could make sure that we didn't have anybody else coming in there. And then we just held what we had until the next set of resources got there.
Now, previously you had mentioned something about finding 2 juveniles, or what you believe to be 2 juveniles at the time. What do
Yes,
you
sir.
mean by that?
So what I mean by that is when I first went in, I saw 2. And believed that there were only 2. When we got outside and other resources started getting in and we started being asked to talk to witnesses, I talked to a witness and she was telling me that there should have been 3 kids in the house.
With
And
that information, what'd you do?
With that information, I went to Sergeant Armorod, who was the supervisor on scene at the time. I let him know the information that we had. I said, I only remember seeing 2, but there is a possibility that there could have been another one underneath, but I'm not sure.
Okay. And was anything further done in order to find out or not?
Yes, I was asked to go back in with a crime scene tech, go back into that room and verify if there was a third body in the tub.
And did you find a third body?
Yes.
You also mentioned that you were trying to, at one point, in order, when securing the scene, you'd be trying to find a way of going in and out.
Yes, sir.
How do you go about making that determination and finding a way?
The one thing I could do was I looked where obviously the most contamination, where the most blood was, where obviously where the body was laying. That's definitely a place we don't want to keep going through, and we don't want footprints and other things going in there and contaminating that scene. The cleanest resource place I found was the garage, so I made that the entry exit point based on what I saw. Because going down the hallway, you had the back door, you had the deceased that were in the bathtub. So based on everything that I saw, that was the most reasonable place to establish, and that's what I explained to the ID people when they got there, and they were able to make their own decision at that point. But that's what we set up.
Okay. You mentioned something about contaminating the front entryway and stepping across things. Whenever you first gained entry, did you have to do that though?
I did.
All right. You take efforts to minimize it, but you still had to do it.
I did my best, yes, to try to walk around and not step in anything or contaminate anything.
Okay. But would it be fair to say that there was a large amount of blood and you couldn't entirely do that?
Yes.
You mentioned also that as it relates to the bathroom, in order to clear that, you had to turn a light on.
Yes, sir.
Was that the only light you had to turn on? Did you have to turn on lights throughout the house in order to clear that?
I honestly don't remember. I just remember that one room specifically because it was dark when I went in and I had to flip the switch. And most likely I would have turned the lights on if they were dark when I went inside. That's normally what I would do, because if I can put as much light into that room, that's less that I have to enter a room. So I can see as much as I possibly can see before I have to move into or make entry into a room. I try to fill it with as much light as I possibly can to see as much as I can.
Around this time, I'd like permission to publish the photographs from 5 to 6, photographs 8 through 10. The jury. Your Honor, prior to showing that Mr. Cummins has raised an issue we'd like to approach and discuss.
All right. Good sidebar.
When they do sidebars, you can always stretch. the projector to show.
I think, oh, okay. It's on. It'd take a second to warm up my screen. I thought it was separate from that. Once you turn them off, they have to cool off before they come back on.
Would you like me to just hand them out in person then, since we're waiting anyway? I'll split them up into two.
Yeah, why don't we do it that way?
All right, thank you. When you collect all the ones off this row, and I'll switch the two. I may approach real quick, decide we don't need it for you.
The big bucks, Rachel. I don't know if Andrew Icebrook is still in that room. He could probably confirm. I thought I saw him back there. All right, yeah. You're listening to the Law News Network, folks, and we're currently carrying the Florida trial of Henry Segura. He's facing 4 first-degree murder charges related to the deaths of his girlfriend, his girlfriend's 2 daughters, twins, with another man, and his own child with that girlfriend. That's what we're listening to right now. This is the first day of the case, and it's a death penalty case in Florida. One of the really weird twists that we're waiting to play out in this Florida courtroom is this claim by another prison inmate that inmate played a role in the death and not the defendant. It's certainly an interesting claim. The judge just thinks it has no merit and initially didn't give it another thought, but ultimately it's going to come into this trial. The accusation from that other inmate is that the woman who died, the girlfriend, was actually a hit victim related to a drug debt. So this thing has elements of gang violence. It has all of the makings of a drug-laden soap opera, if we're to believe the evidence that's come out in the pretrial hearings. So we're continuing to listen to testimony in this case. Police officers on the stand just moments ago. Again, it's a death penalty case, and it's a case that's been on hold for quite a while because Florida had some issues with the operation of its death penalty, and this and several other cases we've covered there were put on hold while the legislature could straighten out the policies and the procedures that Florida was using as it tried to administer death penalty trials. So those are the basic facts in this case. Again, it's the Florida trial of Henry Segura, and he's facing those 4 first-degree murder counts related to the death of his girlfriend, 2 6-year-old twins, and a 3-year-old child. Caroline Polisi is in the studio with me, and whenever we have a case where there are murder charges involving toddlers, almost mere babies, it's a tough one for a jury to get into, especially with these kind of accusations.
It's awful. It's just heart-wrenching. I mean, how you defeat that as a defense attorney, it's very difficult to get over the extremely prejudicial nature of the death of a child, really. I think these children were found sort of in the bathtub stacked upon each other. I mean, it's just horrendous, just mind-boggling. I do think, however, that the defense is going to have to really harp on these new facts that we're seeing come up here, this new element of perhaps, there was more to this story here that meets the eye, that this was sort of a drug debt gone wrong, that there were other factors at play here. So I think we're going to learn a lot more about this story as this trial proceeds.
Well, we've got another witness taking the stand, as we can see right now. Let's listen in as he takes the oath and prepares to testify.
Other than that, it's up for the attorneys to present to you whatever they have to present. Okay? Yes, sir. Proceed, Mr. Hughes.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Back to it. You want to swear the witness, please?
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
I am Artron Timmons. I
Mr.
live
Timmons, if I can, how do you spell your first name?
Artron.
And how do you spell your last name?
Timmons.
Okay. Mr. Timmons, how old are you?
20.
Okay. If I can call you back to 2010, specifically November 20th of 2010, where did you live at that time?
Not on one side of Creek Ryan.
Okay. And did you know someone named Brandy Peters?
Yes, sir.
Did you know her kids?
Yes, sir.
What were the names of her kids?
Tamaya, Tanaya, and Javante.
Your Honor, may I approach?
You may.
And Your Honor, briefly, can I ask some questions from up here as long as I keep my voice up?
Yeah. Make sure you don't stand between the jury and him.
Thank you. Showing you photograph marked as State's Exhibit number 1. Do you recognize who that is?
Yes, sir.
Okay. Who is that?
That's Brandy.
Is an accurate depiction of Brandy Peters?
Yes.
Your Honor, this time I would state Exhibit number 1 into evidence.
Any objection?
There you go.
Be admitted.
Permission to show the jury.
You may.
Next, I'm showing previously marked as State's Exhibit number 2. Do you recognize people in that photograph?
Yes, sir.
Who is this?
Tamaya and Tanaya.
Which one's which?
That one's Tanaya, that one's Tamaya.
The one on the right is which one?
Tanaya.
The one on the right is Tanaya, and Tamaya's on the left?
Yes.
An accurate depiction of them?
Yes, sir.
Your Honor, this time I State's Exhibit number 2 into evidence.
Any objection?
There you go.
Be admitted.
And permission to publish, Your Honor.
You may.
Thank you. Now showing some previously marked for identification purposes of State's Exhibit number 3. Do you recognize who that is? Who's that?
Javante.
Okay. Is that an accurate depiction of Javante?
Sir, you need to instruct.
Yes, sir.
Your Honor, this time I move State's Exhibit number 3 into evidence, please.
Any objection?
No, Your Honor.
State's Exhibit 3 will be admitted.
And permission to publish, Your Honor?
You may.
Thank you. How is it you knew them?
They were basically like neighbors, family, friends.
Okay. Y'all both live on the same street?
Yes, sir.
How far away was their house from yours?
Across the street and 2 houses down.
Okay. And you're how old now? 20?
20.
Okay. So back then you were what? How old would you have been when they died?
14.
When is the last time you remember seeing them?
That Friday when I was coming home from school, I was walking down Jim Lee Road, approaching my house, and I seen them playing in between the houses. Well, in between my house and my neighbor's house.
Remember what time that was roughly?
It was around 4 or 5 o'clock.
Okay. When you saw them, did you see them with any food or anything like that?
Yeah, they had some Burger King.
Some Burger King?
Yeah.
Okay. And who did you see?
I seen, I believe it was Tamaya. Tanaya was somewhere, I think she had ran across the street. And Javante, he was playing.
Okay. Did you see Brandy at that time?
No, I didn't see Brandy.
Okay. Who did you see with the Burger King?
Whichever one of the twins were, I believe it was Tamaya. I believe it was Tamaya.
All right. Okay, and that's the last time you remember seeing them?
Yes, sir.
At some point, did you have, did they come over for dinner that night?
I don't remember.
Okay. Who do you live with?
My mom.
Who's that?
Cicely Timmons.
Okay. Did anybody else stay with y'all back at that time?
Yes, sir.
Who was that?
My stepfather.
What's his name?
Marquise Davis.
Okay. So on the Friday, which I think is November 19th, is that correct? Do you remember?
I believe so.
Okay. So the next day on the 20th, did you have any involvement at Brandy Peters' house? Did you go over there for any reason?
That morning, my mom had called the house and she told me go check on Brandy because her mom been trying to call her.
Okay. Did you go over there?
Yes, sir.
Did anybody answer the door?
No, sir.
Did you knock on the door?
Yes, sir.
What did you see, if anything, when you first got there?
I seen blood splatter like on the porch a little. Then the doorbell was smashed in and the curtains had blood on it.
And what'd you do next?
Ran back home, told my mom.
law enforcement officers respond?
Yes, sir.
You tell them what you saw?
I don't remember. I don't remember talking to them. Like, everything was a blur after that.
I understand. You want a moment?
No further questions. Cross.
Yes, sir. Mr. Timmons, you said you saw the twins with Burger King around the time you were getting home. Was it the actual food, or did you just see the discarded wrappers and bag?
I seen the discarded wrappers and bags and stuff.
So their food was already gone by the time you got home?
Yes, sir.
Okay. Do you recall at about 5:45 you were either called across the street or sent across the street to get Javante and Tamaya and Tanai and bring them back over to you and your mom's house?
When? That day, that Friday or that Saturday?
That Friday. Friday
No,
evening
sir.
at 5:45. You don't recall?
No, sir.
You recall doing a written statement for law enforcement in this case?
No, sir.
May I approach the witness, Your Honor?
You may.
And I can't read the signature at the bottom, but is that your handwriting in your written statement?
Yes, sir.
Okay. If you could, review it, particularly the top paragraph there, and see if that refreshes your recollection as to what happened about 5:45.
Just read it to yourself, Mr. Timmons.
You don't want me to read the top?
After having had a chance to read that refresh your recollection as to what you told law enforcement initially?
I don't remember it, but I'm pretty sure I was,
It does refresh your recollection?
Yes, sir.
Okay. Did you, at about 5:45, go across the street and bring Tanai, and Javante over to you and your mom and your stepdad's house?
Yes, sir.
Okay. Do you remember why you did that or not?
I guess it was for them to eat because my stepfather had cooked.
Do you remember that specifically, or are you guessing?
Kind of really guessing, but I'm pretty sure.
Around that time, you were like into rap and stuff, right?
Yes, sir.
And so you would spend a lot of time in your bedroom in the evening working on that kind of stuff?
Yes, sir.
Are you a fan of oxtail stew?
No, sir.
So you wouldn't have eaten dinner with your mom if she ate, or your stepdad, or the girls, or Javante?
No, sir.
Okay. Now, you're not here of your own free will today, correct?
Yes, sir. Wait.
Like, you're under a material witness warrant. You were brought here against your will.
Yes, sir.
You're in custody, in the custody of the Leon County Sheriff's Office, right?
Yes, sir.
And the reason is that you didn't voluntarily go to the hotel that you were supposed to be sequestered at during the run-up to the trial, correct?
Yes, sir.
And what was the reason that you were hesitant to participate and go stay where the state wanted you to?
First I didn't have any food or money. Then it was like, I was really like scared.
Who were you scared of?
The news, the media, the things that I was hearing in the media or in the news.
May I approach, Your Honor? May we approach, Your Honor?
Okay.
Mr. Timmons, I just wanted to clarify one thing. I don't want you to go into specifically what other person or group you may be scared of. I just want to clarify, it's not Mr. Segura that you're afraid of, correct?
No, sir.
I mean, that is correct. You're not scared
Oh,
of?
that's correct.
Thank you. No further questions.
Redirect. There you are. Any juror have a question of this witness? I'm sorry, that's what I should have been doing all along. I would have had my mind elsewhere. Nobody? All right, you can step down. Call your next witness.
Your Honor, at this time, I would request a brief break to get the next witness up here.
All right.
About an hour or so.
We'll take 10 minutes.
Thank you.
Welcome back to the Law News Network, everybody. I'm Aaron Keller, and we're getting ready for our coverage of the Michelle Carter sentencing in Massachusetts that's coming up in about half an hour. I'm here for the time being, along with Caroline Polisi, but we have some other guests on hold, and Dan Abrams will be taking my chair in just a couple of minutes. This is a case that has attracted a lot of attention nationwide and even internationally, because it's a case involving a young woman who was a teenager at the time who pressured her boyfriend, Conrad Roy, into suicide. That was enough for prosecutors in Massachusetts to charge Michelle Carter with involuntary manslaughter. She chose to be tried by a judge rather than a jury, and the judge decided to convict her. There are many sentencing options on the table before the judge. This could be everything from a probationary sentence to a 20-year prison sentence. But I think the overriding notion of the day is going to be that she's being sentenced on a youthful offender statute, and the goal of that law is to help guide someone, not to punish someone. So based on that, I'm wondering if this is going to be a very, very light sentence. Do you agree, Caroline?
I agree with you 100%. I think it's very indicative of where the judge is heading, that he let Michelle Carter out on bail pending the sentencing. You know, a lot of times judges will immediately remand defendants that are convicted of crimes that have prison terms. So I think absolutely the fact that she's a juvenile here definitely points to perhaps the criminal justice system not being the best place to treat her. Maybe perhaps some sort of a mental institution or some sort of type of psychological help that she should get.
Okay, we've got a lot of information up on LawNewz.com. For those of you following along on the web, I wrote a piece saying that I believe that this conviction is sound under state law, and I run through the litany of reasons why. Ron Blitzer, our senior editor here at LawNewz.com, completely disagrees with me. He thinks that this thing should be knocked down on other grounds, and it raises an important issue, Caroline, because a lot of people are saying, hey, wait a minute, we've got free speech in this country, and really what she did was speak. She didn't provide anything. She didn't give him the means to commit suicide. She didn't, she didn't provide anything. She just used words, and she wasn't even physically with him when it happened. And I can understand that argument. A lot of people are saying, hey, is this enough for a conviction to stick on appeal? I think in state court it will. The question is, do we get a federal habeas corpus review or some constitutional challenge?
I think we are definitely going to see this overturned on appeal. Something has to happen here because this is not right. This conviction should not stand. I love you, Aaron, but I agree with Ron on this point. The ACLU of Massachusetts has come out really vehemently opposing not only this conviction but this prosecution in the first instance. There's no reason that prosecutors should have brought this case. Involuntary manslaughter, they're trying to square a circle here. They're using her actions and trying to fit it into the involuntary manslaughter statute. Remember, there is no assisted suicide statute in Massachusetts. If the legislator had wanted to do so, it could have. So really important points that the ACLU is making here, that this is a slippery slope. We are infringing upon freedom of speech, freedom of expression, and it could have a really chilling effect on potential end-of-life discussions between loved ones. Aaron, you and I are friends. If I tell you to go jump off a bridge, am I going to be looking over my shoulder then for handcuffs? I mean, it's just ridiculous.
Well, Ken Belkin threatened to do the same thing to me yesterday, so now I've got two of my guests who want me to go jump off.
No,
now,
I don't.
Which bridge is it? Is it
No.
the Brooklyn Bridge? Is it the George Washington? Which bridge? You tell me.
I mean, we're laughing, but it's really not funny when you think about it. In a democratic society in which First Amendment rights are paramount, this is a very scary proposition that we are entering into, and I, for one, do not think that this conviction should stand.
Well, now constitutional grounds were not part of the analysis that I wrote for LawNewz.com. So those of you who want to check it out, certainly I encourage it. The bottom line is this involuntary manslaughter statute in Massachusetts has got a ton of wiggle room. You can drive a couple of freight trains through the language in it. It says that it requires an act, but failing to act once you put someone in danger can constitute a failure to act, and that is an act, and you can get in trouble for that.
Yeah, and the judge got himself tongue-tied too when he was saying that Michelle Carter created this toxic environment, that then she created that duty of her own to act. I mean, it is utter nonsense, Aaron. The fact is, these were text messages. This young lady was 30 miles away from where the suicide took place. And it's just ludicrous. It was neither involuntary nor a manslaughter. I think Ron made that point. It just makes no sense, and it's a legal fallacy that they're bringing this prosecution.
Well, the competing theories will continue here. So one thing that we want to mention as we set up for this hearing at 2 o'clock is that we're expecting at least letters to be read into the record that were submitted, according to local media reports in Massachusetts, by the victim's aunt, who is calling for the maximum prison sentence of 20 years, and by the defendant's father, who says she'll feel bad about this for the rest of her life and she should only get probation. Now, it's not uncommon, Caroline, for victims' family members to come forward and say, we want a max sentence. And these are understandable statements. Do those things actually mean anything? Do they sway the judge, or do you think this judge knows exactly what he's going to do before he walks into that room?
In my experience, judges typically know the sentence that they're going to give prior to hearing any of this evidence. Look, the fact is he's received these letters. He's read the pre-sentence report issued by the probation office. He knows the prosecution's stance on it. He knows the defense's stance. He likely has his decision already in mind. That's not to say that perhaps he could be swayed by some of these obviously moving statements that are going to be made, but sentencing is a whole different ballgame. There's so much more wiggle room involved in sentencing. It's a much more emotional exercise. And so I think that what this judge is going to want to do, as in any sentencing, is balance aggravating factors and mitigating factors. She has a lot of mitigating factors here. She was a young woman, a juvenile, as you stated, and she herself had many, many mental health issues. So I think that's going to be a big point that the defense is going to want to harp on. I really see her coming out with just probation in this case.
I want to bring another guest into the conversation now. William Kickham is a criminal defense attorney in Boston, and he's been kind enough to join us while he's spending a little bit of time in the Cape Cod area, as I understand it. So, William, welcome to the LawNewz Network.
How are you, Aaron? Good to be here.
I'm well. So what's your take on this? You practice in Massachusetts. My read of this involuntary manslaughter statute is that, as I said before, it's got a lot of wiggle room. Do you think it was enough to get a conviction in this case, or do you think that this should not have been a conviction at all?
No, I'm in your corner, Aaron. I was there long before we spoke. This statute clearly allows for this. I've analyzed this in several media and written about it on my blog. Words alone do not bar this type of conviction, and the involuntary manslaughter statute, which is what she was prosecuted under, clearly allows this. My prior observation, someone had told me earlier that this was just text messaging. It wasn't. These people were in each other's presence constantly. They were frequently around each other. She did this in person. She did this on the phone. She did this via text messages. She did this in several conversations. She encouraged him repeatedly. He tried to back out once before, and she punished him for it. He tried to back out during the act, and she told him, get back in the car. This kid took a vulnerable person who she knew was suicidal and she knew was troubled, and she not just encouraged him to commit suicide, she repeatedly pressured him to commit suicide. In fact, after he died, her entire focus was on herself. She held a gathering in her own town for herself. The evidence here is replete that this conviction was justified. And the ACLU is up in arms about it, but my reading of the statute that she was prosecuted under allows for this prosecution. And words alone do not bar this type of conviction. I'll offer you an analogy, a metaphor, which we lawyers work by, but if you're taking a walk by a cliff, and you see a blind man using a walking stick, and he asks you which way to the parking lot, and you know that it's left. You tell him to take a left to go to the parking lot. But instead, just because you have, a depraved heart, you tell him to take a right and walk 20 feet, knowing that if he does that, he's going to go over the edge and probably die. Now, if you do that in Massachusetts, that's sufficient for involuntary manslaughter. And that's allegorical to what occurred here. I think that she will be sentenced under a diversionary model. I don't see punishment here as much as redirection. But we're talking today about whether or not she could be convicted under this statute in Massachusetts. And my reading is that she could.
Yeah, and the judge made many of these points, and your analogy, I think, fits based on my analysis of the state law. You practice there, you're the expert far more than I do, but I still disagree. Do you think there's going to be some federal issue or some constitutional issue that's going to run up against these Massachusetts laws?
Yeah, I don't agree. I think that with all due respect, I think that analogy, while potentially helpful and elucidating, is not entirely accurate. In that case, there's no action on the part of the man. In this instance, Conrad Roy was a very troubled young man, and if you read over all of these text messages, he had the desire to kill himself. He talked extensively with Michelle Carter about his desire to commit suicide. I'm not saying, and I think that everybody on my side is repeating this, she is a morally reprehensible human being. It's horrible what she did. I can't even read the text messages. I get sick to my stomach reading them. However, it's not criminal conduct. Now, whether or not it fits under, you can square a circle fitting it into the involuntary manslaughter statute, it shouldn't be allowed to be prosecuted, and it's a scary state of affairs in this country if we put someone behind bars for up to 20 years for speech. It's just ridiculous.
Well, I want to go and listen to a little.
But with all due respect, you said that the metaphor doesn't fit. It's a metaphor that actually indicts her even more, because the metaphor that I offered with a blind man doesn't know which way to go, and for a depraved heart you tell him to take a right and over the cliff he goes. This situation that we're dealing with is even worse. You say he was suicidal. That's correct. Twice, however, he backed out of the suicide, and she punished him for it. Twice he backed out, and she still pressured him to do it. I mean, this is a situation that is not only replete with someone who is morally reprehensible, but someone who is legally guilty of this. And I've heard a lot of my colleagues speak about this case, and when they defend her and they say that this conviction wasn't justified, they open by saying the obvious, which it's no stretch to do, and big deal if they do it, which is they acknowledge that she was morally reprehensible. Then they follow with, but she shouldn't have been convicted. Incorrect. Legally incorrect, morally incorrect.
Well, where do you draw the line then? I mean, where do you draw the line?
This young boy to kill himself, and didn't stop until she was successful.
Well, the line would be drawn if you look at the case law. She should have done something when he tried to get back into the truck. That's the one point at this that everyone, the appeals court that looked at the sufficiency of the indictment, the judge who handed down the conviction, they all laser focused in on that one moment in time. And that's where they're saying this is where it went absolutely too far, because he was in a situation that was inherently dangerous. She had more or less led him there by helping him understand how carbon monoxide poisoning works. She told him how to set the truck up. Yeah, she didn't physically do it, but she walked him through the processes, and those text messages were all in evidence. But what they're honing in on...
And Aaron, what does her action, you point out something very, very prescient and very important here. What do those actions in her not helping him when he tried to get out of the truck, telling him to get back in, instructing him in beforehand how to set up a hose to fill the cabin full of carbon monoxide, what do all those actions speak to in evidence? Answer, one word, intent.
Yeah, and she was prosecuted under an involuntary manslaughter statute. It doesn't fit the statute.
However, her actions did not constitute voluntary manslaughter, but they did meet the statutory requisite for involuntary manslaughter. Clearly.
We just have a fundamental disagreement. I think, again, in the law favors bright line choices. I think that with evidence of this nature, where there is actually no physical act, it's just over text message when this young woman was 30 miles away. I mean, again, think of it in the context of having a very emotional conversation with a loved one talking about end-of-life care. I mean, you want to have a modicum of privacy, and
that's a completely different argument.
It's not. It's not.
No, it is. And the
Carolyn, the animus that was present in this case would not be present in your analogy of a caring, loving family member or friend talking about someone who's terminally ill with cancer.
You know,
that is completely inapplicable here.
And I'll jump in and say, well, let me settle this right once and for all right here. The Supreme Judicial Court, when examining the sufficiency of the indictment, said flat out that this is never to be construed as having anything to do with physician-assisted suicide counseling situations. I think that they nailed that coffin shut in that sufficiency of indictment decision, and they never want anybody to go there.
I'm not saying it's the same situation. I'm saying you're getting one step closer there. You have to concede that it's in the realm of possibility that these two issues could come into play at one point. You have to concede that.
I would not concede that, because I don't think that it could.
It is so remote and so inapplicable as to cause, completely needless and deliberate, confusion of the issue. This is just not applicable to that situation.
Well, we're going to see more and more of these prosecutions sprouting up then. I mean, this is going to be, if you're going to criminalize this conduct, you're going to see a lot more prosecutions for this kind of thing. And people better be nervous about what they say, what they text.
That right line angle very clear. I mean, for someone who opposes this person's conviction to say this conviction is going to open the door to people with assisted suicide counseling to be liable, that is absolutely ridiculous. And the court made that clear.
Well,
now,
let's
if she were prosecuted under the voluntary manslaughter statute, it would have been more difficult. But she was prosecuted under involuntary manslaughter, and this conviction is entirely appropriate under that statute.
I would agree with that point as well. Now, look, I mean, the standard here that the Supreme Judicial Court is going to have to look at if they face this thing on appeal is whether or not the conduct was wanton or reckless. And I'm guessing that that's the language in the statute that would prevent, for instance, yeah, that's exactly it. Yeah. I mean, so how, Caroline, would you argue that an end-of-life care decision conversation would meet that standard of wanton or reckless conduct?
Well,
because
if the conversation veers into, do you think I should do this? Yes, I do think you should do it. I wanted to do this for a long time. Okay, well then today's the day. Why don't you do it? It's not that much different. I mean, I agree. Again, I'm not defending this young lady. I'm not
It's
defending
not
her
that much
actions.
different.
Well, I'm saying the actual words used, why not do it today? I mean, that is essentially what Michelle Carter texted to Conrad Roy that day. Do it now, do it now. So yes, I can see this, I can see a slippery slope argument here.
Oh, Carolyn, you are trying to create something that doesn't exist here. You really are. I mean, to posit the idea and the notion that someone who is terminally ill and dying with cancer and has a conversation with someone would in any way equate to the animus and the depraved heart conduct that this defendant exhibited for months and months and months on end is absolutely ridiculous. It just is.
I mean, I can think of a number of hypotheticals which would, veer you in that direction. If somebody harbored hatred or resentment towards a loved one, secretively over years or something. I'm just saying that it could get there. It could get there.
But the states that have these,
Right.
physician-assisted suicide
And Massachusetts
cases,
doesn't.
okay, but the states that have them have ridiculously clear statutory standards in play to alleviate a lot of your concerns. They say, look, you need to have two independent physicians agreeing to things. The physicians are the ones that prescribe the manner of death. It's not somebody sitting in a Kmart parking lot in a vehicle with a hose hooked up to the tailpipe of a device. I see apples and zebras factually here.
I'm not saying it's not apples and zebras, but I'm saying it's in the same realm of possibility. I'm saying it gets you there. It gets you one step closer.
Absolutely illogical and, absolutely inapplicable. And the court's decision itself made that clear.
Well, let's talk,
absolutely inapplicable.
Well, let's talk a little bit about the First Amendment applications of this, because this I think might at least, it's a stronger hook for a complaint on appeal. And look, I mean, I've been a journalist most of my life. I'm a big advocate in favor of strong First Amendment protections. But even I looked at this speech and said, if we're going to criminalize some kind of a speech, this is getting awfully close to the kind of stuff that I personally don't have a big issue with there being some punishment for, because it might not be incitement to riot, and it might not be some of the other speech that can get you in legal trouble, but it gets so close that
it's perversely close. I mean, and this situation, the ACLU, I'm a criminal defense attorney, and I fight tooth and nail, skin and bone for my clients, defending them. But the ACLU has never found a situation where they cannot object to any form of speech. They don't want any restriction at all. I mean, for the ACLU to posit the idea that this is going to inhibit on free speech, it's just ludicrous. I mean, again, let us focus on the facts that we are dealing with. We are dealing with a person who spent months and months and months pressuring someone that she knew was weak and vulnerable to kill himself. And when he once backed out, she punished him for it. When he tried to back out again, she punished him again, and she did everything she could to get this kid to kill himself, and he did kill himself. And now we have the ACLU saying, well, if you allow someone to counsel someone who's terminally ill, God knows we make it into freedom of speech issues. I mean, this is just ludicrous. It's just, look, if anyone wants to posit an argument that is reasonable and cogent and logical, I'll listen to it. I'll hear it all day long, 8 days a week. But these arguments in favor of this defendant are absent any line of legal reasoning and any logic and any common sense whatsoever, on a legal level or a moral level.
Let me throw this argument on the table here. Some people are saying that this statute is a little bit vague, and I thought that argument might stick, at least in broader context, but the courts in Massachusetts have rather universally found that this involuntary manslaughter standard, which from my perspective seems a little bit loosey-goosey, and it covers a lot of stuff, the courts in Massachusetts have stood behind this at every single challenge. I wonder whether that standard is just a little bit too loose.
I don't think, given the construction of the statute, that it's too loose. And I will point to the fact that there's never been a prior prosecution under it that's been problematic. I mean, had this defendant been prosecuted under the voluntary manslaughter statute, I can see there would be problems. but it's involuntary manslaughter, and words alone are enough. A physical act is not required. I mean, the whole constellation, the totality of circumstances that surround this case, beggar the mind for why someone would say she shouldn't have been convicted. I mean, the only person that I can imagine who would say this person should not have been convicted is just some civil libertarian that will not see the light of day.
Well, we're gonna wrap this part of the discussion. We're going to wrap this part of the discussion right here because Dan Abrams is present and accounted for. He's going to be sitting in the seat in just a couple of minutes. But while we wait to make the switch for this hearing coming up in about 7 minutes, we're going to listen to some of the defense's arguments in closing at trial.
What we're dealing with is a suicide and not a homicide. And this is what we're dealing with is a suicide and not a homicide. And this is the government's burden, to prove that it was a homicide, a manslaughter under the elements. Proof, not by probable cause, not by clear and convincing evidence, but proof beyond a reasonable doubt. And that, of course, is, Your Honor, proof, not that it probably is more true than not even a strong probability that the charge is more true than not, but proof beyond a reasonable doubt. I suggest to this fact finder in this court that the Commonwealth has respectfully failed in its obligation to prove beyond a reasonable doubt that Michelle Carter, a 17-year-old female, caused the death by her reckless conduct. I suggest to this court the evidence shows the opposite, that the evidence actually establishes that Conrad Roy caused his own death. It was a suicide brought about by his own physical actions, his own thought process, his own intentions that are well documented in the evidence over 2 years of various psychiatric records, that you're dealing with an individual who wanted to take his own life, and in fact, at the end, tragically, he did. He accomplished what he wanted. He dragged Michelle Carter into this, Your Honor. I choose the word dragged her into it simply because that is exactly in the text messaging what Conrad Roy said to her, and you will see that in your review of the evidence. Am I selfish? No. Why? For wanting to kill myself so bad and dragging you along with this. Sadly, that's exactly what happened. Rather than running, rather than Michelle doing something else, she stayed in constant communication with Conrad Roy. She was brought into this by Conrad Roy. They had met back some time ago in 2012, the spring of. And then in October, you will see that Conrad announces to her that he's tried to kill himself and just gotten out of the hospital. That's in the Facebook records. You will see tried to kill himself and just gotten out of the hospital. That's in the Facebook records. You will see over the course of that conversation, he says that he plans to do it again, and this time he will be successful. He will not fail. That's his words. That's what he told Michelle in 2012. There is a long, continuous plan of intentions by Mr. Roy to take his own life. Those are well detailed in the various hospital records, therapist records, psychiatric records, where this is a gentleman who sadly was subjected to domestic violence. In fact, he tells, and you'll see in there, that he had daily intrusive thoughts, his words, daily intrusive thoughts of witnessing domestic violence. Those are his words he's telling his therapist and the counselors in the records, Your Honor. It is well documented in there. Sadly, that he did not think hospitalization would work for him. He did not want hospitalization. You will see in the records in August of 2013, he actually refuses to be brought in inpatient. He does not. Patient refuses. You'll see in the records that his mother said, I don't think he can wait a week, but he refused in any event during that time. This is somebody who wanted to eventually take his own life. It was his decision.
Hi everyone, you are watching LawNewz's live coverage of the Michelle Carter sentencing, which is expected in about 2.5 minutes from now. Who knows if it'll actually start on time. But this is a critical moment, not just because it's a sentencing, but because the judge in this case has so much latitude as to what kind of sentence to impose on Michelle Carter. She has been deemed a youthful offender. There's a lot of confusion over exactly what that means, because it doesn't mean exactly what you think it means. It doesn't necessarily mean that she's getting off easy. It doesn't necessarily mean she's being tried in juvenile court. It means, because she's not, it means that she has the possibility in sentencing to serve time in a juvenile facility, then to get transferred to adult court. But before we, as we're watching and waiting for the sentencing to begin, Aaron Keller wrote a really good piece on this about the various options here. I mean, Aaron, the sentence is up to 20 years is the possibility, but the judge could give her almost nothing.
Basically, yes. I mean, this could be a probation sentence, and there are a lot of twists and turns on how to get there, but a lot of it has to do with this youthful offender status in Massachusetts. There could be an incarceration term. There could, in theory, be a juvenile commitment in a different sort of facility, but she's over the age limit for that. So
isn't she almost 21 now?
Yeah, I think she is.
She's like a month away from being 21.
She's 21.
Yeah.
She was 17 when the offense was committed.
Right. So now, I mean, there is no real option to put her in a juvenile facility, right?
She could until she's 21, so 20
right.
to 21
okay.
for a very short
for
time.
a couple of days.
Yeah.
So you know, the way the law works there is if there's a sentence, it usually gets suspended at the point at which a defendant would then be transferred to an adult facility.
Just want to let people know we're seeing people come into the courtroom now live. And so it looks like this is one of the rare courtrooms where they're actually going to start on time, which would mean that we're going to be starting in about a minute from now. Quick predictions, Aaron. If you were predicting, what would you predict for a sentence here?
You know, look, I mean, I wrote the piece this morning that says I think that the conviction was proper under the involuntary manslaughter law in Massachusetts, but part of me wonders if this is going to be a light sentence because, look, she wasn't physically present. She didn't provide the implements. She suggested which implements to use, but she didn't provide them. She doesn't have a track record of other trouble. And under Massachusetts law, these sentences are supposed to be for guidance, not punishment for youthful offenders. I think that might play into it.
I don't think she's going to get anything like up to 20 years. Caroline, I think, what, 2 years?
I don't think she's going to spend a day behind bars.
You don't think
Quite
so?
Frankly,
Really?
I don't. I don't think this young lady is going to fare well in the criminal justice system. I think that she has mitigating factors here. There are things to consider. She has mental health issues. I think she could be better served really getting a hold of those mental health issues.
But you think, considering the judge's ruling, right? Considering reading between the lines of the judge's ruling, you think she's going to get probation?
Well, I read the tea leaves in that he let her out on bail pending sentencing, right? So she's been out of her own volition sort of for a couple of months now. I see judges often immediately remand defendants that get convicted that when we know that they are going to serve jail time. So I think that that's a pretty good indicator that he's thinking on the lighter side of the sentencing here.
But lighter and probation are two different things.
They are.
So I'm asking you to say you think you think she's actually going to get probation.
I do. I do not think she's going to serve a day behind bars.
And has she served time? I forget. Has she served time any time already in connection
with
this? No,
I don't believe
so. There's no time served that she can be using.
Dan?
William Kickham, yeah, real
Dan?
quick. What do you think?
As to sentencing, I don't think that she's likely to serve any time, and if it is, it'll be very, very soft time, very short time. I'm taken back to the case of Phoebe Prince in Massachusetts. Do you remember what that was all about?
Why don't you tell us? Because if I remember it, that doesn't necessarily mean that our viewers know it, so it's not particularly useful.
A girl was bullied in Massachusetts,
Yep.
in western Massachusetts, to the point where she hung herself. And a bunch of kids were prosecuted, and there was diversionary in terms of the sentencing, and there was no time involved at all. This is not a mirror image of that case, but it does involve juveniles. It does involve the death of someone. It's not exactly the similar case, or mirror image, but I don't see time being served here. It's not that I don't think it should be served here, but it'll probably be more diversionary in nature.
We are waiting on the judge to arrive inside that courthouse. I'm told Michelle Carter is in the courtroom preparing for the sentencing here. Aaron, one of the critical issues in a sentencing like this would be the position of the victim's family, right? What position they have taken. All I remember them saying is that they were satisfied with the verdict, that this is a tragedy. Have they weighed in, as far as we know, on what they think the sentence should be?
They have. The victim's aunt has said that she thinks Michelle Carter should be locked up for the max 20 years.
But how about direct relatives?
I haven't seen anything
Okay.
filed, so they may not have submitted it via letter. They may be preparing to speak, and that's one of the things that under the statute the judge has to consider.
Yeah, and because I think in a case like this, that could make all the difference. Meaning, typically you're not supposed to say, oh, well, the victims want this, and therefore we're going to give X sentence. But in a case like this, where the message has been sent with the verdict, right? The verdict of guilty of involuntary manslaughter has sent a very loud and clear message. And so it seems to me that if I'm the prosecutor in this case, I do care a lot what the victims' families, and I don't mean the aunt. I mean, look, in every one of these cases, the cousin has a thought, and the aunt, and this, and that. The bottom line is we're talking about what do his parents think, et cetera, the closest relatives. More important than in a typical case, you think?
Absolutely. Specifically in this instance, I always tell my defendants to really work on those letters, get your family to write those letters, because the judge really does read them. And I mean, even though there maybe aren't legal arguments to be made, there are emotional arguments to be made, and it can't be overlooked that in the courtroom, emotion plays a big factor. So absolutely.
You're watching LawNewz Network's live coverage of the Michelle Carter sentencing. For those of you who are just tuning in, of course, this is the case of the woman who texted with her sort of boyfriend, convincing him, I guess, to go back into a car to kill himself. That was one of the questions, was could you prove causation? Could you prove that she caused his death? And in the end, the judge in this case ruling that they could. As a result, finding her guilty of involuntary manslaughter. Remember, this was a bench trial, not a jury trial. The defense opted for a judge. And look, I had a debate with someone about this the other day. I think it was the right call. It's so easy in retrospect, right, to say, oh, well, the judge convicted, so she should have gone for a jury. Yeah, okay. Now we know she's been convicted, so between a conviction and maybe she should have gotten a jury trial, okay. But at the time it happened, I thought it was a smart move.
Good call. She made the right call on that one. Absolutely. She's not a sympathetic character, and a jury would have convicted in an instant on this.
The texts are terrible. The texts.
I don't think anybody is going to defend anything she did. The debate that we're having is whether or not the conviction should have stuck.
Right, no, but I'm asking,
disagree.
But in terms of a jury versus a judge, right?
Yeah.
If you were her attorney at the time, because I agree with you, as a legal matter, this is a tough case. As a moral matter, it's an easy case. And so she's horrible. This was awful. There's no way to defend what she did. Go ahead, Bill.
It's not as difficult a legal case as some people might think. I mean, it was characterized a few seconds ago. I'm not sure who was speaking at the time because I'm doing a phone with you, not video. But that Michelle Carter spoke to him one night, and when he was in his car suffocating, she encouraged him to get back in when he wanted to get out. That is not simply what happened. This girl spent months and months and months and months and months and months in person, on the phone, in text, via emails, dozens if not 100, telling this boy, this weak, vulnerable boy, to kill himself.
Yeah, well, that's not really accurate either. I mean, the way this started was he draws her into this situation. He's the one who says, I'm going to she doesn't say to him, hey, you know what would be a good idea? You should go kill yourself. He says, I want to kill myself. He makes references to maybe she killing herself with him in reference to Romeo and Juliet. But you know what? Hang on a sec. I gotta stop this. Hang on, Bill, hang on. We got to go live. Courtroom is live. Let's go to the sentencing.
Okay. Commonwealth set to proceed. And Mr. Cataldo and Mr. Madeira set to proceed. Okay. I'm going to tell everybody in the room, as I did the last time you were here, I have been continuously grateful for the decorum and courtesy that has been extended to this court and to the parties involved. Today I expect will be a somewhat emotional day. I expect that same level of decorum. Should there be any deviations from that, You will certainly hear a rapid and harsh response from this judge. So, Mr. Cataldo and Mr. Madeira, before we start this hearing, I wanted to alert you, I have here the ruling on Dr. Bregan's motion. I will file that. That'll be available to you in the clerk's office after this hearing. The second thing I wanted to bring to your attention is that I'm not sure you are aware that I think it was on Monday, I issued a sua sponte order impounding your sentencing memorandum. I was concerned that I may have misled you when I made my specific orders about the probation sentencing report to think that your sentencing memorandum, even if filed with the clerk, would also be impounded. So before we get to the sentencing aspect of this case, do you wish to be heard on whether you want that report impounded? Ongoing.
1 minute, please.
Yes, of course.
It can continue to be impounded at this time.
I'm sorry, it does not?
No, it can be continued.
It can be impounded.
We do not
All right.
object to that at this time.
So, all right. Commonwealth, do you wish to be heard on that issue? No, Your Honor. All right. I will impose the same impoundment order as I have, I think, on the other records was 10 years. I'll look that up, but I think the other records that we impounded were for 10 years as well.
I could be wrong, but my recollection was that it was a lifetime impoundment.
Or was it? Oh, whatever it is, it will be the same. All right? Again, in an interest of trying to treat everyone with the same level of respect. All right. Okay, I have reviewed the probation sentencing report, which I am sure counsel has also reviewed, and I've actually reviewed it several times. And before we start this hearing, I want to take this opportunity to thank Probation Officer Denise Taylor, the primary author of that report, as well as Assistant Chief Probation Officer Cheryl Beauregard, sitting to my right, for an outstanding report. That report was, to my reading, thorough, sensitive, intuitive, and highly professional, and was concise, especially given the amount of records to be reviewed, and to the point. Not only was it professional, but it also reflected a good understanding by both of these probation officers as to the statutory structure that governs this juvenile court. It has been an invaluable resource in my sentencing deliberations. Commonwealth, I will hear from you. Do you wish to present any evidence, Commonwealth, or are you going to just go forward by representation?
Your Honor, with the court's permission, the Commonwealth would like to present 7 family members from the Roy family to read their impact statements, and which time I will read a final impact statement by Lynn Roy, Conrad's mother, and then offer our sentencing recommendation. All right.
Chapter 258B limits those who may present testimony as a victim witness. In this case, given that Mr. Roy, the actual victim in this case, is deceased, under 258B, Section 1, those who may speak are limited to, I wrote it down, in this case, the parents and the sibling, I think, are the only individuals who would be within that parameter of the definition. So those are the people who will be allowed to testify. So you may call the first one if you wish.
Your Honor, the Commonwealth would ask that Camden Roy take the stand, please.
All right. Ms. Camden Roy, please come up. And please remain standing for one moment while you are sworn.
Please raise your right hand. Just swear before the court, swear to tell the truth, full truth, and nothing but the truth, so help you God.
Good afternoon, Ms. Roy.
Good afternoon.
It's very, very important that you keep your voice up nice and loud, please, for my benefit as well as the benefit of everyone in the room. Please state your full name and spell your last name for the record.
I'm Camden Roy, R-O-Y.
Thank you, Ms. Roy. Ms. Roy, we're going to try to make this as easy for you as possible. Why don't you tell me what it is you would like me to know and to consider?
Should I just read?
You certainly can, yes.
Or not having that one person I've been with every day since birth here and more is a pain that I will
Louder, please.
that I'll always keep with me for the rest of my life. Not having my brother always going to be there for me, and knowing that will always haunt me. Knowing I'll never be an aunt to Conrad's children or get to see him getting married is something I never thought I would have to live with. He gave me an amazing 13 years, being my best friend and the best role model any little sister could ask for. Not a day goes by without him being my first thought waking up and my last thought going to bed. Throughout those 13 years with him, I have countless amazing memories that will always be with me. From stuffed animals fights in his bedroom, to him trying to teach me how to throw a football, catch a baseball, and shoot a basketball. To pick me up in his truck whenever I needed him. It's crazy to think that whenever I needed him, he was always there for me. But it's even crazier that now, whenever I need him, he'll never be there for me. And again. I wouldn't trade those short years I've had with him by my side for the world. I'll never get over this pain I feel every day. But I know that he loved me more than any big brother ever could.
Thank you very much. Is there anything you want to say beyond what you have read to me?
No, thank you.
All right, ma'am, then you may step down. Thank you very much. Do you have a further witness?
Thank you, Your Honor. Conrad Roy Jr., please.
All right. That is, as I understand it, the father of this child, correct? Or this young man, pardon me. Good afternoon, sir. Please remain standing for one moment while you are sworn.
Please raise your right hand. Swear before the court, swear to tell the truth, whole truth, and nothing but the truth, so help you God. I do.
All right. Take a seat, sir. Make yourself comfortable. Please keep your voice up nice and loud. State your full name and spell your last name for the record.
Conrad Roy Jr., R-O-Y.
All right, sir. Do you wish to read or do you wish to speak to me directly? What would you like?
I wish to read.
Go right ahead.
I am Conrad Roy Jr. I am Conrad Roy III's father. I cannot begin to describe the despair I feel over the loss of my son. Perhaps I could ask you to imagine the worst emotional pain you have ever experienced and multiply it to an infinite number of times. I am heartbroken. Our family is heartbroken. My son was my best friend. Through the height of his depression, I was by his side trying to build his spirits and to affect his behavior positively, striving to lead him towards the bright future that was before him. As late as July 6, 2014, we were towing a fireworks barge back from Falmouth, and Coco drove the tugboat through the hurricane barrier by himself, with only the guide of a proud father watching over him. Coco was my first mate. In our future, I envisioned teaching him more skills and sharing my knowledge with him. Coco was sensitive, loving, intelligent, compassionate. He was a member of a supportive and wonderful family. His sisters adored him, and he was an excellent older brother. Although he did have some psychological troubles, we all felt that he was heading in the right direction and over the worst of it. Time and positive support from family and friends were critical to his emotional well-being. He had such a bright future. Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse. The fact that my son was convinced to kill himself makes his death unimaginable. How could Michelle Carter behave so viciously and encourage my son to end his life? Where was her humanity? In what world is this behavior okay and acceptable? Coco is missed beyond measure. His family misses him, his sisters miss him, his friends miss him, and I miss him. The last words I said to my son was "I love you." And Coco said, "I love you too." I miss him every moment of every day.
Thank you, sir. Is there anything you would like to add?
No, Your Honor.
Thank you very much. Ms. Flynn?
With the court's permission, I'd like to read the impact statement of Lynn Roy, Conrad's mother.
Certainly.
I do not know where to begin. When this became a news story, it completely overwhelmed myself, Conrad's dad, and our daughters. I have been doing my best to gain strength from Conrad's two sisters, and they gained strength watching me with doing my best to put one foot forward each and every day. It has been completely hard to be in certain social situations at times, feeling so broken. I have only been to a few court hearings, not that I didn't want to be there for my son, but I know that it's something that brings me more pain that I could not handle. I still cannot come to terms that another person who knew and described how much they loved my son would want to inflict so much pain on myself, his dad, his sisters, and all who loved him deeply. He is the most amazing human being and would have had a bright future. He should have been navigated into a positive direction. He certainly was with his support from his family. He accomplished more in his short life than some do in a lifetime. I know deep inside my soul, and I think often of my son's soul, and what a beautiful, selfless soul he was, that he would never want us to endure this pain with losing him. But what comes along at his court hearings is that he believed that social media was corrupting his generation. It is unfathomable to believe why someone would want such an amazing, young, caring man and everyone who loved him to carry this throughout the rest of our lives. There is not one day that I do not mourn the loss of my beloved son. Every day I strive to be a better mother to his sisters and a better person for him. I want him to be proud of me and how I am handling everything. I am trying to be there for his sisters in the best way that I can with all of my pain that we will carry with us until eternity. This does not stop after a trial. I pray that his death will save lives someday. I said to myself, in honor of Conrad, I need to handle this in the best, graceful way that I can. Conrad always wanted to help others. I cannot put into words what an honor it has been to be his mother. I am very blessed to have spent 18 years and 10 months with him. Every day I will continue to honor him. I pray that a law comes forth that another mother, so that another mother does not have to endure what I am. I thank everyone that has put their heart and soul into Conrad's life. They have been the voice when I cannot. I do not believe that another can go on to encourage someone to take their life, and it can be okay. My life will never be the same, nor his dad's, nor his sister. Camden and Morgan deserve so much more. Thank you, Your Honor.
Thank you very much, Ms. Flynn. So again, the statute provides any spouse, child, stepchild, sibling, parent, dependent, or legal guardian of Mr. Roy. Is there anyone else who falls within that category that you would like to present?
No, Your Honor.
All right. Are you to argue for the Commonwealth?
Yes, Your Honor.
Then I will hear you.
Thank you. Your Honor, the Commonwealth is asking this court to impose a sentence of not less than 7, nor more than 12 years in state prison. Your Honor, as the evidence proved, the facts in this case are egregious. Your Honor read thousands of text messages and knows how the defendant undertook a deliberate, well-thought-out campaign to cause the death of Conrad Henry Roy, quite simply for her own personal gain and quest for attention. What a travesty. There is no earthly reason why Conrad Henry Roy should not be here today with his loving family, enjoying life, sharing his many gifts with the world, but he is not. And the reason he is not here is the defendant. Michelle Carter, her actions killed Conrad Roy. She ended his life to better her own. Now she has been convicted of a very serious crime, deserving of serious punishment. It is true that rehabilitation must be a part of any sentencing scheme. But in order to be rehabilitated, one must accept responsibility for their actions. To this date, the defendant has not accepted responsibility for Conrad's death. She has blamed it on his fragile mental state, his family situation, her right to free speech, or the medication that she was taking. She has shown no remorse, and in fact, after Conrad's death, it was quite the opposite. She sought attention and sympathy for herself. It wasn't enough that she took Lynn and Conrad Jr.'s only son, or Camden and Morgan Roy's older brother, or Tom Gamble's best friend. In the aftermath of Conrad's death, she continued to use and deceive all of them until she was caught by her own words. And I would submit to the court that had not the Fairhaven Police Department confronted her, she would have continued her charade as the grieving girlfriend, quite possibly forever. And I would ask you to recall one of the text messages she did send to Conrad, where she told him that she felt played and made a fool of by him because he hadn't killed himself yet. But after his death, she became the player. She manipulated and deceived his family into believing she tried her hardest to save him. She lied to the police about her role in his death. She failed to mention anything about what she did to her own parents or to her treating therapist. She duped the town of Plainville and the King Philip Regional High School when she brought Homers for Conrad to their community, collecting money as a way to bring awareness to suicide prevention, when in fact, she was the cause of Conrad's homicide. The defendant is asking this honorable court for probation, and the Commonwealth suggests that is just not a reasonable punishment for the death of Conrad Roy and the tremendous pain and suffering that she has inflicted upon his family, his friends, and the communities that both she and he lived in. Nor would probation serve to help her in any rehabilitation. The Commonwealth is aware that the court has many factors to consider when coming up with a sentence that is appropriate in this case. Some of those, of course, are the nature and circumstances and the seriousness of the offense. What can be more serious than the death of an 18-year-old, such a promising young man who will never walk the face of this earth again? The victim impact statements you heard from the family members of Conrad Roy. These two young girls will never have an older brother. Lynn and Conrad Jr. have lost their only son. She does not have a Board of Probation record. The Commonwealth concedes that. But another factor Your Honor must consider is the probation report, and I again, and the Commonwealth agrees, it was quite a telling report. Certain things that were important for the court to note and that the Commonwealth took note of was that the defendant had an inability to be honest with her therapist, and there was a lack of awareness in her parents about what she was up to, what her treatment was, and what they should do in order to improve in not only her health, but other things that were happening in her life. They simply didn't know. Another factor Your Honor could consider is a lack or a success or lack of past treatment. And again, the records bear out she was not benefiting, nor did she follow through with her treatment. Many times she was recommended to go on to do further things, and when things weren't going her way, she and her parents stopped treatment altogether. This is not someone that can stay in home confinement and get better, or even understand the ramifications of what she's done. And of course, we read through the letters from the defendant's memorandum. And again, the Commonwealth is concerned that her support system just does not get the impact of what she did. And I say that because of the terms that they used in their letters. They say things like, she made a mistake. She showed poor judgment. She didn't comprehend the severity of her situation. She was helping Conrad to achieve his goal. They don't seem to understand it was her plan. She was the one on the other end, goading him, telling him to get back into that car. She was the one that for weeks berated him. She never told any of them that, and even after his death, and even to this day, she says she didn't know how to call an adult for help. Your Honor, another consideration Your Honor would look to is the defendant's age. Now, this is a youthful offender, but she was 3 weeks away from her 18th birthday. We're not talking about some immature 14-year-old girl. We're talking about 17 and 3-week-old young woman who was involved in DECA, who was a very responsible student, who knew how to call the police because she said it to Sam Boardman. All I had to do was call the police, or even simpler than that, all I had to do was tell him that I loved him, and he would have gotten out of the car. But the Commonwealth suggests it's even simpler than that. And as Your Honor suggested and stated in your finding, all she had to do was say, get out of the car, get out of the truck, and none of it. For all of these reasons, Your Honor, the Commonwealth respectfully asks this court to impose our recommendation. Thank you.
Who speaks for the defendant? No. Mr. Cataldo, do you have any evidence to present?
No, Your Honor, other than the submission in the memorandum that you already have.
And I have read those.
Thank you.
Given them the same degree of attention that I did to the probation report. I would just say in passing, although certainly there has been no emotionalism, nor will there be in my determinations in this issue, that all of those letters, the letters of the Roy family, including those that I heard from today, and the other letters attached to Ms. Taylor's report, and the letters of Ms. Carter's family, give this court a fuller understanding of what these two young people were about. Go ahead, Mr. Cataldo.
Thank you very much, Your Honor. Your Honor, the defense is requesting, as you've seen in our sentencing memorandum for your consideration, a period of 5 years of supervised probation with various conditions, including mental health counseling and evaluation, and following the recommendations to be supervised by probation of any and all mental health treatment that the evaluation comes back and recommends to this probation department, as well as having no contact with the Roys except as a pending lawsuit other than in connection with that, Your Honor, and the other conditions, whatever other conditions this court would deem fair and just and reasonable under the circumstances. Based upon the reasons, the background information gathered, and I won't go through the entire report, obviously, of the probation department and the sentencing memorandum submitted by the defense, Your Honor, I will summarize by saying, as this court is well aware, we're guided with the idea in the juvenile justice system that the goal is not punitive, but yet rehabilitative. Ms. Carter was 17 years old at the time. We have a body of law from both the United States Supreme Court as well as the SJC about the adolescent brain development which a court can consider on sentencing. And there is the clear body that says adolescents are not as culpable as full-grown adults. Ms. Carter does not, I suggest to this court, pose a danger to the public. I suggest that this sad, tragic manslaughter that she has now been convicted of was a very unusual set of circumstances unique to these two individuals, Conrad Roy and Michelle Carter, who are both struggling with mental health issues themselves. Ms. Carter, as this court has seen, both from the probation department's report as well as through the course of the trial, had her own issues. She had her own troubles dating back to the year, going back 3 or 4 years to 2011, where she was inpatient and treated for various eating disorders. And she was put on antidepressants back at that time, which she remained on these antidepressants until the year 2015. Ms. Carter grew up in Plainville, Massachusetts, lived her entire life here in Massachusetts in Plainville, went through the public school system, and graduated ultimately from King Philip School. All while this case, and the case was brought in 2015, she was able to graduate. Throughout the course of her history in the public school system, there is no evidence, and probation has verified that there are no records of any kind of disciplinary problems against Ms. Carter whatsoever. There's no criminal history, there's no involvement with the court system, delinquency, there's no involvement with DCF on Ms. Carter's, in her various growing up. She has had no criminal history whatsoever. I suggest, again, Your Honor, that this was so unique, these two sad individuals taking these medications, and you saw the full texting, respecting the court's decision of the conviction, but you saw the entire texting history and the evolution of the history. And I do think, just to touch upon that for a minute, there was an evolution of the history. The text messaging does not show that Michelle Carter just came up with some idea when they first started texting back in 2012 or 2013. Your Honor, Ms. Carter went on after high school. She did get accepted to college. She did not go to college as a result of the publicity connected with this particular prosecution. But during the time, she did further her education with online classes. She then took classes. She hopes to get involved in real estate and get a broker's license. She's been doing that. She was placed on strict conditions of her release back in 2015 when this case was pending. She has not violated any of those conditions of her release. Again, these are reasons why I suggest that she would be a successful candidate for probation and rehabilitative treatment in the community and not incarceration. Ms. Carter will have to live with the consequences of this for the rest of her life, with the publicity that this case has gained. That will be substantial. I think treatment is appropriate in this particular case for Ms. Carter. Your Honor, you have in the various documentation that she's still in counseling, verified by probation, that Ms. Gail Holmes opines that she's not a danger to the public, and specifically, as the court saw, that Ms. Carter does regret what happened. She also sent a letter to the probation department where she accepts responsibility for her actions, her words, her letter. The court has reviewed all this. Your Honor, I suggest that she is not a danger to the public, and in the remedial system, the juvenile system, probation is appropriate. Sadly, Ms. Carter herself was in treatment for nearly 4 or 5 years, but in particular, in considering what the just disposition of this case should be, Your Honor, I ask you to take particular attention to what transpired in June of 2014 to Ms. Carter. She did go back, and you have seen these records, that she did go back into McLean, or she did go into McLean Hospital inpatient, where the texting with Conrad Roy really escalated during this time. She was inpatient for bulimia. She had previously been anorexic. She was under taking SSRIs, taking antidepressant medication during this time. She is released from McLean in this critical time, and she begins counseling with Anchor Counseling. You've seen those records. She tells the counseling at Anchor, you've seen these records, that she was overwhelmed by her Conrad Roy's suicidal ideation. The fact that she did not do what ultimately this court has opined or stated that she should have done. I asked the court, however, to now, even though it did not absolve her from criminal responsibility, to factor that into its disposition, that she was going through some significant mental health issues herself. And during this time, prior to July 12th of 2014, Ms. Carter did get diagnosed with depressive disorder herself through the Anchor Counseling that she was involved in, Your Honor. You've also had the various character letters from many of the people who are here from the Carters, showing that she has a support group. Both family and friends submitted letters giving you the idea that this was out of character for Michelle Carter. This is not who Michelle Carter was. She was struggling at that time. And this is not the kind of behavior that had been exhibited in her prior history, nor is it something ever likely to happen again. She is now still in treatment. She is now off of any kind of medication, but she is treating with Gail Holmes, as you've seen and verified through the submissions that were given to this court. The fact that she has had no history with any juvenile court or any governmental bodies such as DCF, Your Honor, I think is very important in this case. In the totality of the circumstances, I think that she would be a successful candidate for probation, and there's nothing in the history that said that she would not abide by any of the conditions as laid out by this court. I don't think it's at all a long shot to say, well, we may give her a shot on probation, but I don't think she's going to make it. Her history dictates, I suggest to this court, that she would make it on probation with mental health treatment and counseling. For those reasons, Your Honor, we are asking, as I've laid out in detail in the memorandum, to give her an opportunity to show this court and the community as a whole that this was a horrible circumstance that she completely regrets and does, in her letter, take responsibility for, Your Honor. But it was at a point in time in her life, and sadly as well as Conrad Roy, that these two young individuals sadly came together and resulted in the tragic death of Conrad Roy. But I do think, given that this ultimately is a juvenile court, and given the body of science and the case law, that she is the kind of person that should be given a chance on probation to make it. And any and all conditions, as this court were to lay out, you can be sure that she would abide by those conditions. But this is a terrible, terrible tragedy. And she very much regrets this and prays Your Honor's judgment of leniency in this sad circumstance where she herself had mental health issues going on. Thank you very much, Your Honor.
Thank you very much. I'm going to take a recess until 10 minutes of 3 to reflect upon these cogent arguments made by both sides. I will be back at that time to render the decision. All rise.
You may be seated.
Well, a very emotional presentation from the prosecutor, most importantly from the family members here, talking about how devastating this has been for them to have lost their brother, son, child. It's hard to hear. It's hard to listen to. And yet, as a legal matter, the emotional aspect of this isn't supposed to dictate what the sentence ought to be. We heard from prosecutors asking for 7 to 12 years behind bars, with the defense asking for 5 years probation. A big, big difference. The judge saying he wanted to go back and reflect on this for about 10 minutes. We are going to be live as soon as that happens, so we'll do a little bit of analysis in between. But, you know, I was struck, Caroline, by the prosecutor saying she ended his life. And you can believe that she caused his death. I don't know, she ended his life seems a bit of an overstatement to me.
Right.
When we're talking about a case where she wasn't even there.
30 miles away, they had met twice. And Dan, I think you made a really good point off camera that it felt like we were watching victim impact statements of a homicide. We have to remember.
Well, it's still a homicide.
I know.
You mean a murder?
A murder, correct.
Right,
this
yeah.
is a suicide.
Right.
This is a suicide. This young man had tried to commit suicide previously several times. He hatched this plan. He had implored Michelle Carter at one point to sort of engage in this Romeo and Juliet type of plan to both commit suicide. So I think we do have to remember that it was this young man's actual physical actions that led to his death. I agree. This was gut-wrenching testimony. It's hard to hear, and it's very emotional. And I think that it's interesting that the judge decided to take this short recess.
Yeah, what's up with the recess?
Often they don't do that.
As if the judge is really going to start rethinking. I mean, I've got to believe the judge came in today knowing what he was going to present as a sentence. You think he's
that is unusual.
Yeah, I think he's rethinking.
Hang on one sec, hey, Aaron. Hang on one sec, Bill. Aaron, do you think he's rethinking, Aaron?
Boy, I'd be really surprised, but he might be. You know, maybe he just wants to give everybody a little cooling off time as well. Maybe the mood is just so tense in that courtroom that the judge is saying, hey, let's take a breather, and it's only a 10-minute break.
And Bill, you were saying it's very unusual, right, for him to take this kind of break here?
Yeah, yes. He's already read the respective memoranda
Yeah.
from the defense and the comment. He's aware of the facts. He's aware of the memoranda. He's aware of their arguments. There was nothing preventing him from rendering his decision. I think this is just a method to diffuse some tension within the room.
We are waiting for the sentence in the case of Michelle Carter. The judge pronouncing that he'll be back on the bench in about 7 minutes from now to announce what her sentence will be. A huge difference between what prosecutors and the defense in this case are asking for. The defense basically saying she suffered enough, she should get probation. Prosecutors saying 7 to 12 years. I predicted very briefly before we went into the sentencing that I thought she'd get somewhere in the 2-year range. But it seemed that both of my in-studio partners seemed to think she was going to get probation. Did you say probation too, Aaron?
I was hedging it, at least when I heard the words guilty come out of the judge's mouth.
So now, anything changed from listening to the...
Well, the judge shouldn't be changing his mind this late in the game, but I'm really starting to wonder if there's at least going to be some sentence that sticks. Do I think it's going to be 20 years? No. I don't personally think it's going to even be close to what the state is suggesting. If there's a sentence, I think it's going to be maybe...
No, we're not looking...
Hang on one sec, Bill. Bill, hang on one sec. Yep, go ahead.
Yeah, maybe a couple years. That's just my gut read.
Yeah. And what do you think? Anything? You still
Again,
betting on probation?
this 10-minute recess, what I think the judge went in that courtroom today intending on giving a probationary sentence. I think that this 10-minute recess is him reflecting upon these statements and maybe saying, maybe I should give her some jail time.
This is Caroline explaining why she's going to be wrong.
No. We'll never know.
Bill, I'm sorry I interrupted you. Your thoughts on this?
No, that's okay. I think you can take 20 years off the table. You can take 12 years off the table. You can take 7 years off the table. But he may be rethinking some short duration incarceration at this point in time. I wouldn't be surprised to see something along the lines of 2 years. But then again, it's tough to say here. I would have guessed probation, diversion, treatment. But he may be rethinking that based upon the emotion in that courtroom today.
Well, but Bill,
I don't think we're looking at any serious time.
I assume you agree with me that would be astonishing if a judge who has heard all the evidence in this case, has been thinking about this case for months, suddenly comes in, here's the victim impact statements, and as much as we all like to believe that those change the minds of a judge, they almost never do. If this judge is now going back to rethink his sentence, that would be astonishing.
I agree. I think it's more along the lines that he just wanted to diffuse some tension in the room. There's the possibility that these statements have impacted him. These victim impact statements are the impact on the family and the victims. I don't think they've so much impacted him. I think he's just looking to diffuse some tension in the room, perhaps create an environment or an aura that indicates some, reflection on his part. But I think he's probably where he is.
We're 5 minutes away from the judge issuing his sentence. Aaron, thought?
There's something I wanted to jump in here with. One thing judges are careful to do is prevent themselves from being overturned on appeal. One of the things the statute in Massachusetts says is that the judge must consider victim impact statements. Okay, so we like to say that he's not letting it weigh on him that much, but he has to consider it. Well, if this goes up on appeal, he can point and say, I took a 10-minute break to consider that.
That's an interesting point.
Okay, so maybe this is a covering himself on appeal. And I will say, when this judge read the sentence, he was very careful.
You mean the verdict?
Yes, the verdict, excuse me. The sentence is coming up. The verdict. When he read the verdict, he was extremely careful to bulletproof that decision. He was citing all the previous cases, saying, like this case. I mean, he basically did the appeals court's job for them in saying, this is why this should stick.
Yeah. We're about 3 minutes away, again, from, I think Aaron brings up a very good point. I think that very likely could be the reason that we're seeing this pause. So the judge, and look, it's not evil or insidious or wrong on the judge's part to take a 10-minute break here. In order to think about it a little bit more. But if he changed his sentence as a result of hearing arguments, it would be beyond unusual in a case like this. Those of you who are
very
not in
unlikely.
the legal system every day, judges have read now already a brief from each side. They've seen the probation report. There is everything the judge needs to make the decision has already been presented to him. The law, the arguments,
And Aaron-
etc. Go ahead, Bill.
And Aaron, he didn't read those memoranda this morning. You can be sure of that.
Yeah.
Oh, certainly.
Right. So, so we're
I mean,
what?
this has been percolating. This has been percolating a while within him. I mean, he's read these a long time ago. He's had ample time to reflect and think and take a long walk himself.
And you know,
so I think he's looking to bulletproof it.
I thought it was a little bit, I don't want to say it was a cheap shot, but it was a little bit playing with the rules here for the prosecutor to basically lay out all the defense's arguments, right, including their legal arguments in the courts, and say, she's not accepting responsibility. See, she was blaming the First Amendment. It's like, come on. I mean, she's making a legal argument that didn't succeed. That's not taking responsibility. I mean, is there any real argument here that she has accepted responsibility? Do either of you guys think?
Look, as a defense attorney, sentencing is always really tricky in that regard because oftentimes you still have clients that maintain their innocence and, you know, from their perspective, they still want to sort of argue the merits of the case. That is not what sentencing is about. The criminal justice system values, we see it in probation all the time too, acceptance of responsibility is a key component. She really hasn't done that.
I would agree with that assessment.
No, she hasn't.
The acceptance
so much
of responsibility
of the
didn't really come out of her mouth until the tail end of things, which is usually what happens.
But she didn't testify. Like, how would she theoretically accept responsibility at this point if she's not testifying?
Letter to probation.
She wrote a letter to probation.
Right.
Apparently,
Right.
we haven't seen that letter.
Right,
So.
and I would assume that the letter expressed great remorse, right? I mean, maybe it didn't say, I'm a horrible human being. And I guess, Bill, there's an argument that when you read these texts, they are so horrible that anything short of her saying, I am awful, I can't believe I did this, that anything short of that is not good enough.
Yeah. I mean, you know, so much of this is theater, too. If you notice today, she was crying. She had tissue dabbing her eyes, very upset, swollen, crying. You didn't see that really during the trial. I mean, there were a lot of still photos and videos during the trial where the expression on her face was one of, yeah, right. I mean, it was a very combative, very defiant, very, you know, blank you kind of expression on her face during trial. And today, she's all in tears.
We've all had clients as defense attorneys. We've all had clients where you have to tell them over and over again, the jury is watching everything that you do. The Bill Cosby case is a really good example of this. I mean, he was rolling his eyes throughout the testimony of his accusers. It doesn't play well to a jury. So to the extent as a defense attorney you can counsel your clients to really, you know, keep a straight face and really don't show much emotion, that behooves the defense.
But part of this is, you know, and I know that those who want her to go to prison for 20 years don't want to talk about the fact that, you know, she's still relatively young. I'm not going to say she's a kid, because she's not a kid anymore. She's not. At age 20, you are not a kid. But
she was only 3 months from being an adult.
I know. She was 3 months shy of, this has been a big issue. She was 3 months shy of being an adult. I get it. But my point is that when you are 20, and you are accused in this kind of case, meaning didn't pull the trigger, didn't push, did horrible things to encourage sort of boyfriend to go back into a car and kill himself. Horrible. But the sort of the reading of people's body language and facial expressions is dangerous business, I think. And I think it's, you know, particularly when you got a judge. It's one of the reasons to get a judge.
It does fall under demeanor evidence, not in terms of
demeanor evidence from sitting at the counsel table?
No, not from sitting at the counsel table, but it illustrates a certain frame of mind.
Okay, all right, but it's not evidence. I mean, you just made it sound like, it can be considered as demeanor evidence the way she's sitting at the table, which is not the case.
No,
Right.
I meant that in quotes. It somewhat indicates a frame of mind or an attitude, but it is not demeanor. Obviously, it's not demeanor.
We are waiting for the judge to come back and issue the sentence. Welcome to our MSN viewers who are watching us there as well. This is the LawNewz Network covering the Michelle Carter sentencing live. This has been a very divisive case with a verdict that I think surprised many when she was convicted of involuntary manslaughter for sending texts, phone call, most incriminatingly encouraging her friend to get back into his car and finally kill himself after he started having second thoughts about it. This is a complicated case, though. It's just not, the headlines on this case are all about young woman encourages boyfriend to kill himself. This was an ongoing text relationship between these two that was pretty complicated, that involved him starting it by talking about the fact that he wanted to commit suicide, that involved her trying to convince him not to do it for a while, trying to get him help, etc. And then apparently she went to the dark side and really made some what are beyond errors, which are criminal, as the judge has found. And one interesting question, by the way, as we wait for the judge's sentence here, is what is the potential chance of an appeal succeeding here? Meaning, this case has already worked its way up through the Massachusetts courts. The Massachusetts Supreme Court deeming this a case that could move forward. So, Aaron, does that mean that the appeal has sort of little bite?
I've been saying that all along, and I've been saying exactly that. And not only does this appeal have little bite because they've already looked at it once and say, we think it can stick, but if you go back through all of the jurisprudence on this particular charge, the Massachusetts courts tend to let it stick. I think that a federal appeal would have a much better chance. When I wrote for LawNewz earlier today, my thoughts about how the inner workings of the legal mechanism worked here, I said, I don't think a state appeal is going to work in this case because these courts have stuck to this precedent for a long time.
If she has any chance at all, it's not going to be in state court in Massachusetts. It's going to be in federal.
Agreed.
Right.
I think the ACLU will likely file an amicus brief should it get to that point, and I think if she's going to have a lot of supporters.
While we're waiting for the sentence, and again, the judge should be coming back on the bench at any moment now. We're keeping a very close eye. Want to just play again the father of the victim in this case. I mean, really hard to listen to, but important to listen to. Let's listen to that as we wait for the judge. Oh, no, let's not do that. Let's go live. The courtroom is live again. We go back to the bench. Apparently we are not live yet. This is what happens when you're dealing with a live event inside a courtroom. We are all walking on eggshells. We are all sort of nervously awaiting the judge to be back inside that courtroom. We'd gotten an announcement that the judge would be back on the bench, but we're still waiting. In the meantime, I want to go back to that piece of sound. This is from the father of the victim in this case, talking about how much his death has impacted him and the family.
Conrad Roy Jr., R-O-Y.
All right, sir, do you wish to read or do you wish to speak to me directly? What would you like?
I wish to read.
Go right ahead.
I am Conrad Roy Jr. I am Conrad Roy III's father. I cannot begin to describe the despair I feel over the loss of my son. Perhaps I could ask you to imagine the worst emotional pain you have ever experienced and multiply it to an infinite number of times. I am heartbroken. Our family is heartbroken. My son was my best friend. Through the height of his depression, I was by his side trying to build his spirits and to affect his behavior positively, striving to lead him towards the bright future that was before him. As late as July 6th, Coco was my first mate. In our future, I envisioned teaching him more skills and sharing my knowledge with him. Coco was sensitive, loving, intelligent, compassionate. He was a member of a supportive and wonderful family. His sisters adored him, and he was an excellent older brother. Although he did have some psychological troubles, we all felt that he was heading in the right direction and over the worst of it. Time and positive support from family and friends were critical to his emotional well-being. He had such a bright future. Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse. The fact that my son was convinced to kill himself makes his death unimaginable. How could Michelle Carter behave so viciously and encourage my son to end his life? Where was her humanity? In what world is this behavior okay and acceptable? Coco is missed beyond measure. His family misses him, his sisters miss him, his friends miss him, and I miss him. The last words I said to my son was, "I love you." And Coco said, "I love you too." I miss him every moment of every day.
Thank you, sir. Is there anything you would like to add?
No, Your Honor.
Thank you very much.
Keep me updated. All right, so we're having a little bit of a technical snafu on the courtroom. The judge has not issued a ruling yet from the bench, but that moment we were just watching there was a really powerful one, and one that we were talking about whether that could actually be impacting the judge's sentence in this case. Let's go live into that courtroom as the judge is assessing the sentence.
And again, not to be misconstrued as the entire process or deliberative determinations. I have not found that Ms. Carter's age or level of maturity or even her mental illness have any significant impact on her actions. She was a bright young lady, did well in school, and I am satisfied that she was mindful of the actions for which she now stands convicted. So in my deliberations, that has had little weight. On the other hand, as Mr. Cataldo so well pointed out, I am aware of a huge body of law that has developed nationally and within this state, starting primarily with a case in 2012, Miller versus Alabama, and then picked up here in Massachusetts in the matter of Diachenko versus the district attorney, which is found at 466 Mass 655. Although Mr. Cataldo stated one side of it, it is my read of those cases that there is another side. And that is that even if the age and maturity level of the person at the time that they have committed the crime doesn't garner a great deal of significance, the fact that they are still of that young age offers a greater promise of rehabilitation. Now, I know that there has been some significant media coverage of this case. I assure you that I have steadfastly avoided any of that. It would not be proper, nor would I want to color any perceptions of my case by exposing myself to any of that. And I have not done so. But by the end of today, people will wonder why what has happened has happened. People may wonder why all of this has happened. If you really want to understand what we do in the juvenile court and how we come to the decisions that we make, it is all contained in this little pamphlet. This is a remarkable work that was issued by the Administrative Office of the Juvenile Court in April of 2016. It is the Dispositional and Sentencing Best Practices for Delinquent and Youthful Offender Matters. It came together by virtue of a committee that was chaired by an extremely knowledgeable judge, Judge Jay Blitzman, First Justice of Middlesex Juvenile Court, with several other highly knowledgeable juvenile court judges sitting on that same committee, as well as representatives from District Attorney's Office, CPCS, which represents the majority of children in the juvenile court, DYS, and many other agencies. When I first prepared my remarks for today, I took this book out and I started making purple marks on it and things that I would want to present to people to understand the context of what is going on. There were so many purple marks, I said I'm not going to do it. But if you really want to understand the juvenile court, read this document, because then you will understand what we are all about here. And as Mr. Cataldo said, we are the juvenile court, a unique and special aspect of the Massachusetts trial court. That document, Diachenko, Miller versus Alabama, all indicate that this court must and has considered a balancing between rehabilitation, the promise that that rehabilitation would work, and a punishment for the actions that have occurred. And so I have done so. Ms. Carter, please stand. Ms. Carter, a guilty finding having entered on the indictment charging you with the involuntary manslaughter of Conrad Roy III, now sentences you to 2.5 years in the Bristol County House of Correction. 15 months of said sentence shall be deemed a committed sentence, and the balance thereof shall be suspended until August 1st of 2022. You will be on probation, administrative, until you are released from incarceration, supervised thereafter, and the date of probation commences today. While you are on probation, there will be the usual conditions of probation, which include that you will obey all court orders and all local, state, and federal laws. You will report to your probation officer as that individual directs. You will allow the probation officer to visit in your home or school with or without notice. You will notify your probation officer within 48 hours if you change your residence, school, or employment. You will report to your probation officer within 48 hours after you are released from incarceration. You will not leave Massachusetts unless you get permission of your probation officer and sign a travel permit. You are required by virtue of your conviction to submit a DNA sample, and that will be done through the probation department. You will sign all releases as necessary for probation to verify your compliance with its terms, and you will pay all court-ordered fines, costs, and assessments. Those are the general terms. There are, in addition, specific terms. You are to have no contact with any member of the Roy family, excepting only that as may be necessary in conjunction with any civil litigation, including but not limited to the matter of estate of Conrad H. Roy III versus Michelle Carter, docket number 17-0846. You will have no contact, direct or indirect, with any of the civilian witnesses who testified at this trial, excepting only Dr. Bregan. This shall include, but not be limited to, Ms. Samantha Boardman, Ms. Alexandra Eblin, Ms. Ali Ethia, Ms. Olivia Mosoglo, and Thomas Gamble. Upon your release from incarceration, you shall present yourself within 48 hours to the Bristol County Juvenile Court Probation Department, Taunton Division, and thereafter shall follow all regulations as indicated by that probation department as to reporting requirements. When you report to probation, you will arrange through probation to schedule a mental health evaluation, which will be done by our juvenile court clinic. Said evaluation shall be for the purpose of addressing areas of need as to any mental health issues and to make recommendations for the treatment thereof. You will be required, as a condition of your probation, to cooperate with that evaluation and to follow those recommendations. A copy of the evaluation shall be provided to the probation department, but shall not be filed with the clerk's office. You shall also sign releases of information providing for any service provider from whom you are receiving services related to the mental health treatment to probation, allowing probation to receive information as to your attendance, the purpose and goals of your counseling, a general statement as to your cooperation with that service, and progress toward the stated goal. Said mental health services shall continue for as long as deemed necessary while you are on probation by the clinician or individual providing same. This court further orders, and this will be in writing, all of this is in writing, this court further orders that any disclosures made by Ms. Carter during the mental health evaluation or the treatment recommended may not be used in any substantive way at any subsequent evidentiary hearing that may occur relative to this matter to establish any of the elements of any crime, including this indictment, in the event that for whatever reason it is retried. Based upon this court's analysis, that to some degree, and drawing on Dr. Bregan's testimony, that he spoke in terms of behavior of grandiosity, and this court's assessment that for whatever reason, part of the motivation for this activity that led to your conviction was a sense of self-aggrandizement. This court now orders that you are not to profit from the events of which you now stand convicted and the facts surrounding same. For those counsel, I refer you to the case of Commonwealth versus Power, 42010, and the cases that are cited therein from 1995. You, Ms. Carter, your assignees, and any representatives acting on your authority are prohibited from directly or indirectly engaging in any profit or benefit-generating activity relating to the publication of facts or circumstances pertaining to your involvement in the criminal act for which you now stand convicted. This shall include contracting with any person, firm, corporation, partnership, association, or other legal entity with respect to the commission and or the reenactment of the crime by way of a movie, book, magazine article, tape recording, recording of any type, radio, television, or internet presentation, interview, live entertainment of any kind, or from the expression of your thoughts, feelings, opinions, or emotions regarding such crime. Any action taken by you, whether by way of execution of a power of attorney, creation of corporate entities, or like, action to avoid compliance with this condition of probation, shall be considered a violation of the terms and conditions of your probation. As I noted, your probation shall be administrative until you are released from incarceration, and thereafter shall be supervised. The probation supervision fee is waived. A victim witness fee in the amount of $45 is imposed, and that shall be paid on or before September 11th of 2017. And finally, as I noted a moment ago, you will be required and must submit a DNA sample in accordance with General Laws, Chapter 22E. That is the sentence of the court. You may be seated. Mr. Cataldo, do you wish to be heard?
I do, Your Honor. May I approach?
You may. Thank you.
Your Honor, what I have just filed is a motion to stay the execution of the sentence.
All right, let me take a look at it, please.
Okay, thank you.
I'll hear you, sir.
Thank you very much, Your Honor. Your Honor, you have now reviewed the motion to stay the execution of the sentence. Your Honor, the issue is that not whether or not the defense, we need not establish that the appeal is more likely than not to be successful, but only that it presents an issue which is worthy of presentation to an appellate court, one which offers some reasonable possibility of a successful decision on appeal. Your Honor, I have, this is not an exhaustive list by any means, but I refer the court back to the motion for required finding of not guilty for the other issues that we presented during the course of the trial, as well as some issues that have been presented in the court's ultimate decision to find Ms. Carter guilty of involuntary manslaughter. I would argue to the court, and I do argue to the court, that this is a very unique and, despite the court's findings, novel issue involving speech alone, without presence, without physical presence. As the SJC even noted in their decision that went up pre-trial on a probable cause standard, they had never encountered a case where speech alone, where there wasn't physical presence, had come up before. I suggest that this is a fertile ground, a very important legal issue that needs to be pursued in the appellate courts for however long it takes to whatever court needs to address this very issue. There are many different issues involved in the appeal that will be coming. You have the Levesque issue, as the court noted, that she owed Conrad Roy a duty of care by a self-imposed created duty, while the judge yourself said that. We do take exception that the fire, if you will, was not created by Ms. Carter, but was created by Mr. Roy. That's another issue that we would be presenting to an appellate court. This court has already, and I won't go through each and every one of the motion for required finding, but I think this court is, it realizes that there are many issues in this trial and the uniqueness of a manslaughter without a statute for assisting suicide and the implications in the First Amendment that this case will have or could have once an appellate court ultimately rules on the First Amendment. So, Your Honor, the idea that even if the appellate court were to deny it, these are legitimate issues that are worthy of presentation, and it's something that the appellate court will ultimately may not rule on by the time Ms. Carter, if she is ordered to serve her sentence immediately, would already be out, would already be released. So for those reasons, Your Honor, we think that this court should issue a stay of the execution. She would be on probation immediately. She would have to do everything else and begin with all her conditions, but the incarceration portion could never be taken back if the court does not stay that particular issue. Further, Your Honor, as this court knows in issuing whether or not, in deciding whether or not to issue a stay, is whether or not Ms. Carter might be a flight risk. I think that is extraordinarily minimal in this case, that she would be a flight risk. She's always appeared in court for the past 2 years while this case has been pending. She has not defaulted. She obeyed each and every term and condition of her pretrial release. I would suggest that she will go ahead and start with her probationary conditions, but just we're asking to stay the portion of the sentence that would dictate that she be incarcerated immediately, Your Honor. There are a lot of legal precedent, not just in Massachusetts, but from around the country, on the issues of whether or not speech without using true threats can be curtailed without a statute in place. These issues need to be litigated in an appellate court ultimately, and we're asking you, Your Honor, to stay the jail sentence until we can have our day in court in the appellate level of whichever court ultimately it goes to be the final arbiter determiner of the First Amendment, as well as the idea of the duty imposed on Michelle Carter and all the other issues on the motion for required finding of not guilty guilty, some of which, Your Honor, were not presented on Commonwealth v. Carter, the SJC previously issued in 2016. There were some other issues, as this court notes. So for those reasons, I'm asking the court to stay the execution of the jail sentence of this case.
Mr. Cataldo, before you step away from the podium, sir, assuming I was to allow this motion, I have some concerns that extending a stay until the federal appeals are done might create two problems. And the first is that the statute seems to suggest that the stay ends when the rule, pardon me, seems to suggest that the stay ends when the appeals court issues its rescript. So how would I be able to extend a stay beyond the issuance of a rescript by the Massachusetts Appellate or SJC? And then the second issue is, assuming that this wended its way through the federal court system, the date of August 1st, 2022 could have come and gone before Ms. Carter is required to serve her sentence in the event that ultimately my decision is upheld.
First question, Your Honor, on the rescript, I would suggest if a rescript were to come down and it is in Ms. Carter's favor, and secondly, if it came down against Ms. Carter's appeal on all the various issues, I would suggest, depending on which court, we would be asking that court at that time for a further stay.
Which I think begs my question of why, if I am to allow a stay, why should it not just be through the Massachusetts Appellate Court system? And then beyond that, you would have to obtain relief from the appellate level.
Well, I guess let me start by saying that is now my fallback position to this court. But I do think each and every level as we go up, and if it is ultimately denied by the SJC and there is a petition for cert or some other federal relief that we are looking for, then it would be incumbent upon the government move to terminate your stay at that time. But I think that the court should issue the stay and through all appellate procedure, but at least through the SJCs, and then if the court were to put the burden, if you will, for lack of a better word, over to the defense, I'm sure we'd be seeking it in a federal court. But if not, then I suggested it be on the government to then file for a revocation of the motion to stay.
Well, I think under the rule, clearly, once the rescript opinion issues, it is on them. But, and I suppose I should say at this point in time that although I have been very involved in this case, no one should assume that I have taken exclusive jurisdiction of it, all right? Because I don't know how much longer I will be here. So in any event, please feel free to bring whatever concerns you have in front of any juvenile court judge. Thank you, Mr. Cataldo.
Thank you.
Ms. Flynn and Ms. Rayburn, do you wish to be heard?
Yes, Your Honor. Commonwealth vehemently would ask the court to deny the motion. The main issue in this case is that the defendant was convicted of involuntary manslaughter. This is not an assisted suicide case. This is not a First Amendment case. The SJC unanimously said that. There is no basis or likelihood of success for her appeal. This is a case that has been a 3-year ordeal for the Roy family. They deserve to have the sentence that you just handed down imposed today. And so the Commonwealth would suggest that this motion be denied.
All right. Thank you very much. I guess we have all come to know each other a little bit. I anticipated this motion, Mr. Cataldo, and I took some significant time to review the case of Commonwealth versus Hodge, which is found at 380 Mass 851. I note at page 855 of that decision they are talking about the significance of stays, even though the reporter's notes indicate that stays are not generally the practice here in Massachusetts. It does say, however, that the practice of a stay is grounded in rudimentary notions of justice, that a person convicted of a crime who would a short sentence would otherwise be made nugatory in the case of a short sentence and would be impaired in the case of a larger sentence, and says further, citing Commonwealth versus Levin, 7 Mass App Court 501, the conviction may be reversible, but the time spent in prison is not. I am satisfied under the Hodge language that there is an issue worthy of presentation to the appellate court. In fact, this court believes that the wisdom of the appellate court will be of instruction now and going forward. And that's important. And one of the reasons it's important, Ms. Flynn and Ms. Rayburn, as the representatives of the Commonwealth of Massachusetts and specifically the Roy family, is the letter of Mrs. Roy, who said that she hoped that the death of her son would result in law that could prevent this from ever happening again. I don't know what the appeals court will do. I don't know if it goes to the SJC, what the SJC will do. But I am satisfied that a grant of a stay through the Massachusetts court system only is warranted. This order will not encompass anything with respect to the federal system. Now, while Ms. Carter experiences the, apparently I have to file this. I'll give this to probation. I have the notice of the DNA. I will give that to probation to go over with Ms. Carter afterwards. All right, and let me give you that now before I forget. Thank you very much. Ms. Carter is going to be out on the stay, and she is going to be, under Rule 31, I have the authority to issue conditions, and that has been enhanced by the use of Chapter 276, Section, I'm sorry, wait a minute. Section 87. So Ms. Carter will be, although they call it pre-release on the form, it is obviously post-trial, but it applies. And there will be conditions which will track in large measure the conditions of probation. Violation of any of those conditions could result in the immediate revocation of the stay. And I have those written out. I just have to see if I can locate them amongst all my papers. Ms. Carrera, here are the, that's the motion for funds. You can distribute them to the lawyers, and you can give Mr. Cataldo and Mr. Madeira 2 copies so that they have it for the sake of, I believe there are 2 copies there. Okay? All right. I apparently must have left that other form on my desk. Do you have a copy? Is that, it's on my copy, that's all right. I remember most of it. All right, that will be provided to the probation in about 5 minutes, Mr. Cataldo, but basically it is the same existing conditions. No contact with the Roy family, no contact with the witnesses, no application for or obtaining of a passport, no leaving the Commonwealth of Massachusetts, and the language from Commonwealth versus Power are all incorporated in the 27687 order that will enter. And probation will have that in 2 minutes. I must have just inadvertently left it on my desk upstairs. Is there anything further, Mr. Cataldo or Mr. Madeira?
We're all set. Thank you.
Commonwealth.
Your Honor, if I may
Yes.
request, given the court's ruling, if Your Honor could order an expedited assembly of the record. Usually that takes a little time to ask for.
I'm happy to order that. I don't know, do you need a motion?
I may, Your Honor.
All right, if you write it out and give it to the clerk, I'll make sure I endorse it before I leave today.
Welcome back to the Law News Network, everybody. I'm Aaron Keller, along with guest Deborah Blum, local criminal defense attorney, Law News trial analyst. And here's the sentence for Michelle Carter. 2.5 years, 15 months of it was to be served, committed to prison. But right at the end, the judge said, I'm going to stay the sentence pending an appeal. That means she does not go to prison today. Deborah, explain that, break it down a little bit more.
Well, what that means is the judge granted a stay, which is an application the defense attorney made, as we saw. And that application was, please allow my client to stay out of jail pending the determination of the appeal that we're most certainly filing on her behalf. In the state of Massachusetts, there's no law on the books that says that it's a crime to encourage someone to commit suicide. She was found guilty, in my opinion, because when the man who, her boyfriend, committed suicide, the young man who committed suicide, called her, she encouraged him to get back into his car. He had exited his car where he ended his life, ultimately, and she said, no, just go forward and go do it. So that, in my opinion, was what she was convicted of involuntary manslaughter for and received this jail sentence. Most likely, the judge realizes there's a strong probability, since there's no law on the books making what she did a crime. It was based on his decision. So I think that there's a high likelihood of the appeal being granted, and perhaps the judge realized that, and that is why he allowed for this stay.
Well, it's certainly a novel case. The appeals courts have looked at it once before. William Kickham is still on the line with us. He's a Boston criminal defense attorney. William, your reaction to how this all played out with this stay being granted right at the end?
Well, given our analysis today and the spirited discussion we've had, I don't think it's going to be a surprise that I differ with Carolyn. When she characterized the judge as probably having a strong belief that there would be a strong chance of the likelihood of success on appeal here, that is not the language that characterizes the granting or denial of a motion for stay. It is a reasonable possibility, just a possibility, not a strong chance. So I don't think he was thinking that at all. And Carolyn has spoken also, as have other observers, to words only being involved here. There is no requirement in the Massachusetts statute under which this defendant was convicted that any specific actions beyond words be taken. She was convicted under a statute that allows for the conviction under the circumstances that occurred. And I'm quite surprised, actually. I'm very surprised that this judge allowed this stay, because he reasoned that there is just a possibility that the appeal might be likely, just a possibility, and that's what the language in Massachusetts speaks to. I don't see really that. Is it theoretically possible that a state appeal could work in Massachusetts? Yes, it is theoretically possible. Is it likely? No, it is not. Why is it not likely? The SJC has already spoken to this issue. The Supreme Judicial Court in Massachusetts has already addressed this. It is not like this appeal is not likely to succeed on a state level. So why this judge granted this stay, it's surprising to me, because the statute doesn't speak to a strong likelihood or anything along those lines at all. It's just a possibility. If he wants to become theoretical like that, this is the approach he has taken. But it is not likely that this appeal will succeed in Massachusetts under state law. And therefore, had I been the judge, I would have denied the stay.
Okay, so let me ask you, William, about this other language. The judge said 2.5 years, 15 months committed. That means 15 months actually incarcerated. But I thought he said after that the balance would be suspended until 2022. What exactly did that mean?
I really don't know what he's talking about in that regard. His language was somewhat confusing. I mean, the Commonwealth asked for 7 to 12 in state prison. The defense wanted probation only for 5 years. He came back with a House of Correction sentence, which is very different than state prison in Massachusetts. I'll just spend a few seconds on that. In state prison, let me just reduce this to that's where the major offenders are incarcerated. Felony crimes, violent crimes, things like that. A county house of correction is otherwise called in Massachusetts a county jail. Those are where the low-level offenders go, and the maximum incarceration there is 2.5 years or 30 months. He suspended 15 months of that to serve 15 prior to the granting the motion of the stay. He was somewhat confusing as to that.
I agree. I mean, it was a little bit different than how I'm used to hearing sentences, but I've never practiced in Massachusetts. I don't have a law license there. I'm a little bit surprised by some of the language there, but as I took it, it meant that if the sentence were to stick before he stayed it pending appeal, then it would be 15 months in that county house of corrections, and then the remainder of the 2.5 years on appeal. Is that the way I'm supposed to be reading it? Or rather, the remaining 2.5 years on probation?
Normally, when a sentence like this is handed down, for example, let's just take this particular one, 30 months, 15 suspended. So she would serve 15 months and then go out on probation after that.
Yes, this is a little bit different. Is that possibly because we're in youthful offender status here?
In juvenile court, the youthful offender rules apply, so yes.
Well, it's certainly an interesting sentence. I mean, is this about where you thought this would be? I know that we were bouncing it back and forth a little bit before. Or do you think that this was out of step?
I thought he was going to lean towards 2 years or so, and he did impose a sentence of 2.5 years, but then he suspended half of it, which surprised me somewhat. I could see him imposing 30 months and suspending maybe 6 months of that, but not half of it. I'll tell you what I was more surprised at. I was more surprised he allowed this motion to stay. There really is no reasonable, again, is it theoretically possible that her appeal could be allowed at the state level in Massachusetts? Yes, theoretically it is possible. Is it likely, given the treatment of this case so far by the SJC? No.
Yeah, I mean, the SJC has looked at this issue. They've said that the indictment should stick, and in the process of doing so, they basically walked all the way through the elements of the crime and say, well, a jury could find all of this, and if they did, that would be legal. I mean, I know it wasn't... It wasn't precisely on point, because the standard for an appeals court looking at an indictment versus looking at a conviction, they look at it a different way. But still, they've been down this train track before. They know how fast they can go. They know where all the station stops are. We were talking before that a federal appeal would probably have a greater likelihood of success. And
I agree.
That's where the action is going to be in this. So, okay, let's talk about possibilities here. Let's say the state appeal falls flat. Okay, then what happens? Does then she have to report to prison pending a federal appeal, or where does it go from there?
Well, he made it only applicable to the state appellate level. So, in other words, once these appeals begin, once the appellate procedure begins in Massachusetts, let's assume that my opinion is correct, and the future sees that appeal as unsuccessful. It does not work, okay? At that point, she should begin serving her sentence while she appeals it at the federal court.
So if once the state appeals are exhausted, she would have to be incarcerated.
According to this ruling, yes.
Okay, well, William Kickham, I know that you've been kind enough to join us from the Cape Cod region of Massachusetts. You have given up a portion of your time and what I assume is nice weather and enjoyable day, so we want to let you get back to that. William Kickham, criminal defense attorney from the Boston area, we really appreciate you joining us here on the Law News Network. Deborah Blum, still in-house. Okay, so we've got this all broken down. You know, it just seems bizarre that while this goes up the appellate change, if she loses or they don't grant the appeal, then she winds up having to serve her sentence.
Well, the laws on the books don't always make sense. I think at this point her defense attorneys are kicking themselves for deciding to have this matter heard in front of the judge. I think that if you would have had a jury here, and I know that this is all speculation because the trial is now said and done and she is convicted and has her sentence, although she's not going to be in jail until the appeal is determined by the state. But I think that had she been in front of a jury, they might have had more sympathy. I don't mean to be disrespectful of this young woman, but there looks like there could be something off with her. I also think that, you know, her defense team presented evidence that there were issues with her mental health. She had anorexia in the past. She's had various other things. So I think that her defense attorneys would have been better to go with a jury of individuals who would have a greater understanding towards her issues in life, and they might not have found that she was guilty of involuntary manslaughter, which is a very serious crime. And the definition is if it's reckless or wanton behavior. I understand that, you know, telling someone to go back into their car and go through with their suicide is technically reckless. However, there's nothing that says by law that it is. So I think a jury might have done differently.
Well, let's listen to some of the testimony at this sentencing hearing from Conrad Roy Jr., who is the victim's father. And when we come back, Kathy Russin, formerly of Court Chatter, currently of Law News, will be joining us for a little more reaction to this.
Conrad Roy Jr., R-O-Y.
All right, sir, do you wish to read or do you wish to speak to me directly? What would you like?
I wish to read.
Go right ahead.
I am Conrad Roy Jr. I am Conrad Roy III's father. I cannot begin to describe the despair I feel over the loss of my son. Perhaps I could ask you to imagine the worst emotional pain you have ever experienced and multiply it to an infinite number of times. I am heartbroken. Our family is heartbroken. My son was my best friend. Through the height of his depression, I was by his side trying to build his spirits and to affect his behavior positively, striving to lead him towards the bright future that was before him. As late as July 6, 2014, we were towing a fireworks barge back from Falmouth, and Coco drove the tugboat through the hurricane barrier by himself, with only the guide of a proud father watching over him. Coco was my first mate. In our future, I envisioned teaching him more skills and sharing my knowledge with him. Coco was sensitive, loving, intelligent, compassionate. He was a member of a supportive and wonderful family. His sisters adored him, and he was an excellent older brother. Although he did have some psychological troubles, we all felt that he was heading in the right direction and over the worst of it. Time and positive support from family and friends were critical to his emotional well-being. He had such a bright future. Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse. The fact that my son was convinced to kill himself makes his death unimaginable. How could Michelle Carter behave so viciously and encourage my son to end his life? Where was her humanity? In what world is this behavior okay and acceptable? Coco is missed beyond measure. His family misses him, his sisters miss him, his friends miss him, and I miss him. The last words I said to my son was I love you. And Coco said, I love you too. I miss him every moment of every day.
Thank you, sir. Is there anything you would like to add?
No, Your Honor.
Thank you very much.
Horribly sorrowful testimony from the father of the young man who committed suicide in this case. The family is hurting. They're still hurting. They're never going to have Conrad Roy III back. And that's the bottom line in this case. Not surprisingly, the public reaction has been harsh. Kathy Russin, formerly of Court Chatter, currently of LawNewz.com, has her finger on the pulse of those who watch these trials closely. So Kathy, welcome back. It's good to see you again.
Good to see you too, Aaron.
Okay, so look, I mean, I've been looking at Twitter while this was going on, while we were all on the air here together, and look, nobody seems to like Michelle Carter. I've seen one or two people say, well, I don't think a conviction should stick in this case because the person who actually killed himself is dead. Okay, and I wrote that piece on LawNewz.com to explain exactly how it happens legally, that explains the law that allowed the conviction to stick. But a lot of people wanted the max for this young woman.
Yeah, you know, really they were all over the board. What I saw, I'm watching our chat rooms that we have, and I'm on Twitter and Facebook. Absolutely, the dislike for Michelle Carter is high, like sky high. And look, how could anyone like her? I mean, outside of her family, if you're just looking into this case like we are, and read those text messages that she sent to him, she's not likable at all. Now, the viewers have been kind of all over the board. You know, some are like, throw the absolute max at her. Can't believe she did this. Did you read those text messages? She needs to be made an example of. Then there are some who are, right now, I'm actually reading in our chat room right this minute, that are arguing, look, she wasn't even physically there. How can we blame her? And then that question comes up. Anybody that is bullying a child and that child ends up committing suicide, are they then convicted of involuntary manslaughter?
I'd have to go through the
conversations that are being had right now.
I'd have to. Okay, so the answer to it is in the piece that I wrote for LawNewz.com, and I explain exactly how that works. You know, they import some duties from personal injury law into criminal law in this instance in Massachusetts, and they've done it for a long time there. This is pretty well settled in Massachusetts. I know we keep talking about this being a novel case because it's text messaging, but really that's the only novel part of it. This law has been pretty well settled in Massachusetts for a long time, and how they get there, I lay out in this piece. You know, they say, okay, well, even, and you have to look at it from a tort law standpoint of intervening and superseding causes. If, you know, I do something that's going to land me in a personal injury accident and then somebody else does something, then in theory we both caused it. Okay, and just because if somebody does something that's a little bit worse or that results in a greater harm doesn't mean that I wouldn't also be culpable, and that's basically the standard. So, you know, that's the way it works. And in other words, if the secondary act is foreseeable, then the person who set the chain of events in motion is also on the hook legally, okay? And the judge found, and correctly under the law, that because it was foreseeable that he would get back in that truck and die, that her needling him was part of the causation. She wasn't the total cause, but she was part of the cause. It's easier to read it than it is to discuss it. I suggest to people who are confused about that or stuck on it, or maybe just don't like it, are just going to have to read the piece. But I can understand that being part of the debate.
Yeah, well, yes, and I have tweeted out your article and put it in our chat room today because it's important that people understand everything surrounding this case. But I completely agree with the judge. Look, but for her, he had gone back out of the truck. Now, would he have committed suicide on another day? Maybe. Was he suicidal?
We don't know. We don't know, you know, and that's the whole thing. So we've got to go with the facts that are on the hook. And Deborah, I'd like to bring you back into this because look, here's the bottom line. I think the one most critical thing that sunk her in this case wasn't the text message to the victim, wasn't any of those text messages. It was the text message to her friends where she basically memorialized what she said to him in the phone call, that's what really got her in trouble.
Right, absolutely, because he's deceased and we didn't hear from her mouth, or at least I'm not aware that we heard from her mouth what the phone call consisted of. Many people, my clients included, shoot themselves in their foot by putting things in text messages or emails or posting it online because she memorialized what happened. She said, I encouraged him to go back, I believe she said, I encouraged him to go back into the car. No one would have known that but for her text message, which the prosecutor was able to get into evidence.
Yeah, I've got the quote of it up on LawNewz. That's where this really stuck. And she admits the causation element of it coming out of her own words. Even though, yes, he also played an element in it as well. She basically admitted, well, I was the impetus behind it, even though he committed the act. And so that's how it stuck. And it stuck not in a what if, but it stuck with a clear-cut record that the judge in this case could go back and look at and say, okay, that's the evidence that this actually went this way. And when you start to read all of the other involuntary manslaughter cases in Massachusetts to see how they determine these issues, this conviction was not really a surprise. I don't know, Kathy, we're talking about the reaction to it. I always take these things from this perspective and say, hey, look, if people are talking about this and reacting to it, the solution is to dig into the law. And part of the American experiment is that if we don't really like the operation of the law, we have a debate about the root of it. And then in the same breath, it disturbs me when people just want to spout off about the way it operates and complain about the outcome without looking at what causes that outcome.
Well, look, so I'm reporting from maybe the non-legal side of this, and what the public is seeing from the outside in looking into this case and their reaction from this. And you're right, if you don't like the laws, you need to be proactive and do something about it, or at least try to do something about it, or understand this case and understand what the judge needed to do or not needed to do. I think the majority of trial watchers were behind her conviction. She needed to be convicted. I don't think that that's a problem at all. Where the whole span goes is on the level of time that she should be getting. And many think that she got off really, really light today, and they're not happy with that.
Well, the stay at the end of it was the real surprise. I mean, that was the surprise, and we heard some good analysis about that just a couple of minutes ago.
And the judge already had that prepared. Did you hear him say that?
Oh yeah. He was ready for it, but the surprise was that he granted it. Every judge knows, okay, well, this is part of the procedure. I'm going to listen to this thing. And then, okay, well, usually it's not granted. Usually the defendant's carted off to prison, and that's just the way it is.
I've rarely seen it be granted. And I've seen many applications for it, and I've spent thousands, hundreds of thousands of hours in court, and it's very rarely granted.
Yeah, and to see it granted in this case, this is a surprise. But maybe the reason the judge did it is because the judge knows that there's this novel issue of technology, and that might be the sticking point if a state court so finds, because I don't think the state court's going to rewrite the standard in this. The standard's been set in Massachusetts. I mean, they're citing cases in examining her case going back to the 1940s. So we're 60, 70 years in on precedent, and it's stuck time and time and time again what the elements of this charge involve. I don't think the appellate courts in Massachusetts are going to turn around and say, whoops, we need to back off. We can't keep going down this road. I think at a minimum they might say, well, she wasn't physically present for something, and but still the chance of that happening is minuscule in my mind, because I think the action here is going to be in federal court. That's where this might stick, because the Massachusetts courts have been holding on to these standards for a long time, and they've had a lot of chances to change them, and actually they tend to uphold convictions on these involuntary manslaughter counts. One of the cases involves people who knocked over a candle in a warehouse where I think they were squatting as tenants or something like that, and started a fire, and they tried to put it out. They couldn't. They walked away from it. Okay, the place eventually engulfs in all these flames from it. 6 firefighters die. That conviction on involuntary manslaughter stuck because they said, hey, look, you started the fire that they showed up to fight, and therefore you caused their deaths. You should have called 911 to get him in when it was still a small fire. And that's how they do this in Massachusetts. These convictions stick, but I hear what you're saying, Kathy. It's also an issue of the sentence. What is the proper punishment? Now, that one I'd have to do a little bit more research into, because the punishment aspect of this, the 2.5 years, that didn't surprise me. I was thinking light sentence, possibility of just probation, but the stay, that's what gets me, the stay.
He was prepared to do that. So he must think, I don't know, one of a couple things. One, what harm is it going to do to let her be out under, supervision? She's not really a risk to run. She's not a risk to, to do harm to other people. And she has all these restrictions. So he's probably thinking that. And the other thing is just this case is so unusual and so out of the norm that he must have just been like, look, I don't know if she's ever going to really get time after an appeals court looks at this. So let's just, let her out with some restrictions. Now, I also believe that the judge believes that she has some serious mental health problems, and that's where they need to concentrate on helping her.
Yeah, and ultimately the judge correctly noted that that's the standard under this youthful offender law. So, Kathy, we're going to start switching gears here a little bit and head back to the Segura trial in a couple of seconds, but we always appreciate your perspective. We always appreciate the perspective of people in the chat rooms. I've been reading the comments on Twitter. I've been in the chat rooms. Really helps me understand the way people are reacting to things, and I try to answer everybody's questions as best I can. So we appreciate you keeping your finger on the pulse for us. So
people tuning in right now, they do need to stick around and catch this Henry Segura trial because it's fascinating and it just started today.
Yes, this is a new trial for us, so we are standing by to go back there. And Deborah, just really quickly, final thoughts on this Michelle Carter case for now.
Well, I think it's incredibly interesting. I agree with your point that if the people of the state of Massachusetts take issue with what happened and how flimsy the evidence was to convict somebody of involuntary manslaughter, they need to go to their state legislature and talk to them and tell them that we take issue with the law on the books, because many people are being convicted of a very serious crime for very immaterial or, not so serious things, and this is a harsh sentence and a harsh punishment that people face.
And that's another thing I've been saying since the beginning. Ultimately the judge, and I said this all the way through the trial, which we covered here live on LawNewz, that the judge had to kind of pound a square peg into a round hole. There's not a clear statute on the books in Massachusetts that says you can't help someone or encourage someone to commit suicide. And look, this would have been an easier case if that law was on the books, and most other states have that law on the books.
Absolutely. There are other states that discourage this type of behavior because there's a criminalization of it. In this state, they don't have it. And you also don't have a duty to pick up and call 911. There's no Good Samaritan law on the books. So I disagree with the finding here. It's really terrible what happened, and it's very sad that this young man took his life, but I don't see where they should be allowed to find her guilty of involuntary manslaughter, which is why, again, I think they should have gone with a jury trial here. Unless you are basically 100% certain, or maybe 95% certain, that the judge is going to rule in your client's favor, you typically go with a trial by jury.
Well, but Deborah, she was so disliked by so many people that once an average jury saw those text messages, do you really think they would have acquitted her?
I
think the only shot that she would have had was for the judge to say, I don't think the law sticks to this particular set of circumstances. That would have been the only way I would have seen her getting off the hook here. The jury, I think, would have convicted her in 10 seconds, not 3 days.
I think that there's a way to humanize this young woman, and I think that her defense attorneys could have done that. They could have had her testify, had her explain that she has mental health issues, had her explain what was going on. Yes, it's very risky to put your client on the stand, but there would have been ways that they could have done this. And sometimes when you accept to have a trial by a judge, you're really taking a tremendous risk, especially if you don't know who the judge is going to be. I don't know that these defense attorneys knew that it was going to be this judge, or if they just completely rolled the dice and got sent to this judge, who most likely is a strict applicationist of the prior law, and they didn't do so well.
Well, you know, the judge probably didn't want to get overturned. So, you know, look, we could keep debating this from now until the appeals court gets a look at it, but we're going to switch over to the Segura trial now. I know, Deborah, you're going to stick around for the rest of the day. This is a trial that just started. It's a death penalty case out of Florida, in case you're joining us for the first time here on the Law News Network, and it involves a defendant who is accused of 4 first-degree murder counts related to the deaths of his girlfriend, 2 of her children, 6-year-old twins, and 1 of her 3-year-old children. A very sad case. It's a death penalty case, and there's a weird twist. Another inmate in prison claims he's the one that really called for the hit on the woman and that it all involved drugs, and eventually that inmate will be testifying. So let's listen in live to that case out of Florida.
Inventory value from the doors themselves.
Yes, I did.
Okay, and what would that be?
I collected sterile swabs of the door handle to the master bathroom area and the toilet closet door area, the interior and exterior door handles.
Okay, I want to turn your attention to states 44 and 45.
Yes, ma'am.
Do you recognize states 44 and 45?
I do.
And what do you recognize it to be?
These are the swabs of the exterior master bathroom door handle and the toilet closet door handle.
And are they in the same or substantially the same condition as when you impounded them?
Yes, ma'am, they are.
Okay, at this time I'd move 44 and 45 into evidence.
Any objection? No, Your Honor. 44 and 45 will be admitted.
Looking at 43C, what do we see in 43C?
I took a photograph on the side where you can see the countertops in the master bathroom and the items that were located on the countertops.
Did you collect any items of evidence from the faucets there in the master bathroom?
Yes, ma'am, I did. I took a swab of the faucet handle.
Okay, of both faucet handles?
I believe so.
And can I turn your attention
did.
to states 46 and 47?
Yes, ma'am.
Do you recognize 46 and 47?
I do.
And what do you recognize them to be?
These are the swabs of the faucet handles in the master bathroom area.
Are they in the same or substantially the same condition as when you collected them?
Yes, ma'am, they are.
This time I move 46 and 47 into evidence.
Any objection? No, Your Honor. 46 and 47 will be admitted.
What did you collect from the actual countertop?
There was a piece of hair, a piece of a wig that was located on the countertop area there that I photographed and collected as well.
And what did you notice about this piece of hair when you compared it to the hair that was actually on Miss Peters?
It appeared to be the same color, so I collected that because that was the hair that it was similar to what was located on her head.
Okay. And do you recognize states 48?
Yes, ma'am, I do.
What is states 48?
That's the piece of hair from the countertop in the master bathroom.
Is it in the same or substantially the same condition as when you collected it?
Yes, ma'am.
At this time, or I'm sorry, as when you impounded it into evidence?
Yes.
At this time, I move states 48 into evidence.
Any objection? No, Your Honor. 48 will be admitted.
All right, what are we looking at here in 43D?
This was the photograph I took on the actual, the shower area, the frame. It was all glass doors, and the very far left area here, all of that glass was shattered, it was cracked. So there appeared to be a suspected bullet hole that went into the frame, so that's what I was documenting. And there's also glass on the floor, on that towel.
I'm looking at 43E. Is this an up-close view of the towel?
It is.
43F. What do we see here?
Here you can see where there's shards of the glass from the sink, or from the broken glass pieces on the shower. And there's also a projectile that was located right there on the towel.
And then 43H. What are we looking at in this photo?
This is a photograph of the indentation where I believe that the bullet actually hit, and I have a scale marker with the letter H showing the area.
Okay. And looking at 43G.
That's a further out picture where it's showing my evidence markers for the projectile. For both projectiles, there are actually two located in that master bathroom area, and then the scale on the frame.
Okay, so here, this little white marker, that shows where the indentation was, where the bullet hit and then bounced off, and where it's located, where when you found it on the towel with marker 15.
Yes, ma'am.
Okay. And you mentioned that there was another projectile found. Can you show us where that is in this photo?
It is where my evidence marker 16 is, here.
And this is a close-up of the first projectile that was located below the shower, correct?
Yes, ma'am.
Okay. Now I want to talk about the projectile that was found that you marked with 16. And this is 43J. Is this an up-close view of that projectile?
It is.
Okay. And what we're looking at, is it resting on the ground right here?
It is.
So this would be like the molding in the wall?
I believe, yes, that's a baseboard on the bottom of the bathroom.
Okay. What do we see in 43K?
That's after I actually closed the door of the toilet room area, and there's a suspected bullet entry hole right here.
And what do you see in the next photo? Oh, sorry. Let me zoom out for you. Give you a little more perspective.
Okay. That appears to be the inside of that door, of the toilet room door, and that would be the exit hole.
Okay, so what do we see over here on the side of the screen?
That is the master bathroom door to the main bathroom area.
Okay, so that's the outside of the master bedroom door, and this is the inside of the toilet room door.
That's outside of the master bathroom door, and then the inside of the toilet door.
Okay, so this would be the exit hole of that bullet.
Yes, ma'am.
Okay. Is this where you marked with the scale the entry hole of the bullet?
It is, yes, ma'am.
Okay. And in 43N, this would be the exit hole of the bullet?
Yes, ma'am.
What did you do to try to determine the path of this bullet or its trajectory?
I placed trajectory rods in that bullet hole as well.
And in 43O, do we see your trajectory rod?
Yes, ma'am.
And in this photo, we're looking at the outside of the toilet room door, correct?
Yes, the door was closed.
And 43P?
Is a side angle view I took of the trajectory rod, so you can see that it was at a downward angle. It also appeared to have gone from the left side to the right side.
Okay, so the trajectory of this bullet was from left to right and downward.
And downward, yes, ma'am.
In our next photo, 43Q, did you take this photo, I guess, to show the trajectory from inside the master bedroom?
We're just getting further back in angle of it because it was really, it's so tight in that area right there to take the picture, so I came out to an open area so you could actually see from further away the trajectory of it.
Okay. And does this picture show the trajectory rod from both sides?
It does, so that way you can see the downward angle as it goes into the bathroom area, the toilet, I'm sorry.
And 43S, was this from above the toilet looking down at the trajectory rod?
This was.
What do we see in 43U?
Is a photograph before I placed the evidence marker showing the projectile on the floor. right here.
And in 43B, was this after you put down your evidence markers?
It is.
All right. What's there at the bottom of the toilet? Why is there an evidence marker there? Or why is there a scale there?
So when I did the dowel rods, and as you saw when I was standing on top of the toilet area, and you can see it was at a downward angle, I noticed an indentation in the toilet right here, which lined up with the trajectory rod. And I believe that the bullet actually hit the toilet area and bounced off. And that's where it was located here. But I believe it hit there. And so that's what I was documenting, the damage to the toilet.
So it would have come left to right at a downward angle, ricocheted, or bounced off of the bottom of that porcelain toilet and ended up right there at the bottom of the wall.
Yes, ma'am.
What do we see in 43W?
That was the bathroom window. It was kind of tucked away behind those two doors when they're open. So there was a curtain, a red curtain, that was hanging over it that we moved, but it's a photograph showing the window is unlocked.
Okay. Were there any other unlocked windows in the residence?
No.
Did you see any other damage to the inside of the window?
No. No,
What
ma'am.
about the outside of the window?
There's no damage to the outside of the window, but the screen to the window was damaged.
And did you look for latent fingerprints in the bathroom and, well, really in the entire house?
I did process several areas of the home for latent fingerprints. One of them was the master bathroom window. I did the interior and exterior window and the windowsill on the interior for latent fingerprints.
And when we say latent fingerprints, what do we mean?
Essentially, a latent fingerprint is something that's invisible to the naked eye, so it requires some kind of processing in order to see it. So when you touch an item and leave your fingerprints, I process it with different kinds of powders or chemicals or dyes to try to get them to be visible to the naked eye. So when I processed for the invisible fingerprints, essentially, I used bichromatic powder at the home here to look for fingerprints.
Did you find any latent fingerprints in the master bathroom?
I did not.
Is it unusual to not find a latent fingerprint in a room that someone regularly uses every day?
It's not unusual not to find them. I mean, there's several reasons why you wouldn't have latent fingerprints.
Why?
It could be the texture of the surface that you're touching. And like if you touch fabric, clearly you're not going to leave it. Essentially what you leave when you leave a fingerprint, is the sweat and oils from your hands that your hands just naturally produce sweat through your pores. So when you're touching something, if you're touching it onto a surface that's not going to adhere to it, you wouldn't leave fingerprints. If you were wearing gloves, you wouldn't leave fingerprints. If they've been touched over and over and over again, you're kind of just covering over your prints, and after a long time, if it's been cleaned, you wipe it away. I could go on and on. There's several reasons.
Safe to say, though, you don't leave a fingerprint every time you touch something, even if it's a hard surface.
No, ma'am.
All right, and if I touch something and I move my finger, would that necessarily leave a fingerprint that you could compare to anything else?
Not a comparative one necessarily. Yeah, you could smear it, and then it's just a smudge.
Okay. I want to ask you about State's Exhibit 49 and 50.
Yes, ma'am.
Do you recognize 49 and 50?
I do.
And what are 49 and 50?
These are the two projectiles that I located in the master bathroom that I collected.
Do they appear to be in the same or substantially the same condition as when you collected them?
They do, yes, ma'am.
Okay, if you could open them for us. At this time, I would move 49 and 50 into evidence, Judge.
Any objection? 49 and 50 will be admitted.
And permission to publish to the jury. first that states 50, or let me start with this one. Looking first at states 49, this is the projectile that you found below the shower, on top of the tower.
Yes, ma'am.
The other item in here is this a swab of the projectile?
I believe that was taken by FDLE.
I believe it was what?
I'm sorry, taken by FDLE.
All right, so States Exhibit 50 that you have marked in the photos is 16. This is the projectile found on the ground in the toilet room next to the wall.
Yes, ma'am.
If I can approach Judge and retrieve the evidence.
I probably should say, they've been using gloves to handle things. That's just standard process. That's not something special for this case. That's what they do in all cases when the items may contain blood.
All right, Ms. Williams, I want to turn your attention to states 51A through E. Do you recognize states 51A through E?
Yes, ma'am, I do.
And what do you recognize states 51A through E to be?
These are the photographs I took of the twin girls' bedroom.
Do they appear to be true and accurate depictions of the twin girls' bedroom?
Yes, ma'am.
This time I move 51A through E into evidence.
Any objection? No, Your Honor. 51A through E will be admitted.
All right, looking first at 51A, what do we see in this photo?
This is just a photo of me standing in the hallway as you enter into the twin girls' bedroom.
Okay, and then 51B?
It's just a different angle as I'm working my way into the room. You can see the beds for the girls in a TV stand area.
51C?
Is once I'm in the room taking the side angle of the beds for the girls.
51D?
Is from the other side where I'm standing where the window was on the opposite side of the beds and taking a picture of the closet area and the floor.
And then 51E?
Is just showing the TV stand area and the television that was on in the girls' bedroom.
Obviously, you've never been in this room before, but did it appear ransacked or like anything like that?
It didn't appear to be so, no, ma'am.
Did the girls, was there anything of evidentiary value found in the room?
I didn't locate anything of evidentiary value in the girls' room.
So no suspected blood or anything like that?
No, ma'am.
All right, turning your attention next to states 52A through G. Can you tell me if you recognize those items?
Yes, ma'am, I do.
Okay, what do you, or what are those?
These are the photographs I took of Javante Segura's bedroom, the little boy.
And are they true and accurate depictions of Javante Segura's room?
Yes, ma'am.
This time I would move 52A through G into evidence.
Any objection? There you go. Be admitted.
Permission to publish?
You may.
Let's start with 52A. What do we see here?
This is a photograph of the entryway into Javante's bedroom.
And is 52B?
Is a photograph I took. There was a sign with his name on the door there, and I was just documenting what the sign said.
What do we see here in 52C on the bottom of the door?
This is suspected blood spatter that was located on the bottom area of the door to his bedroom.
And in the photos that we saw earlier in the hallway, there was also suspected blood on the side of his room, correct?
Yes, ma'am. The side of his room.
I'm sorry, on the wall right next to his room?
Yes, ma'am.
Okay. And then on the wall in the linen closet on the other side of his room as well?
Yes, ma'am, to the right of his room.
Okay. What did you do with the suspected blood that you found on the bottom of Javante Segura's room door?
I documented the areas and collected swabs of some of the areas on his bedroom door.
And can we see your markers here in 52D?
Yes, ma'am, you can.
Is this one closer view of one of the areas of suspected blood?
Yes, ma'am, it is.
Okay, and that's 52E. All right, so I want to ask you about these two areas. Do you recognize states 53, 54, 55, and 56?
Yes, ma'am, I do.
And what are 53 through 56?
These are swabs that I collected of suspected blood on his bedroom door.
Okay. And you collected swabs total from 4 different areas of suspected blood?
Yes, ma'am.
And was 1 on the door frame and 3 were from the door?
Yes, ma'am.
Do those swabs appear to be in the same or substantially the same condition as when you impounded them?
Yes, ma'am, they do.
This time I would move states 53 through 56 into evidence.
Any objection? No, Your Honor. 53 through 56 will be admitted.
I want to ask you about the suspected blood that you saw on the door. We talked about how there was blood on either side of the door on the wall, but when you all initially entered the home, was this door open or closed?
It was open.
Okay. Would the door is the blood spatter on the door consistent with the door being opened or closed at the time that the blood spatter occurred?
It was consistent with the door being closed.
Why?
Because it was in the hallway. All of the suspected blood area we found was going down through the hallway from the master bedroom. So there was actually, because of the angle and because you can see there's so much of the blood spatter here that's going downward, if it happened with the door open, there should have been blood on the carpet floor in the bedroom there, and it wasn't. It was actually in the hallway on the floor. So I believe the door was closed at the time that the blood was shed onto the door.
Okay, yet it was open when you all entered the home.
Yes.
Was there any items of evidentiary value inside Javante's room? Was there any other suspected blood anywhere in his room?
No, ma'am.
What do we see in 52F?
This is just a photograph inside of Javante's room, and this is the the door frame area right here. So as soon as you walk in, it was the bed area, and I was just documenting all around the bedroom.
And finally, in 52G.
It's another angle of Javante's room.
All right, I want to turn your attention to States 57. It should be in the other notebook up there for you. In the folder. Do you recognize States 57A through G?
Yes, ma'am, I do.
And what do you recognize those to be?
These are the photographs I took of the hallway bathroom.
And are they true and accurate depictions of the hallway bathroom?
Yes, ma'am.
This time I would move States 57A through G into evidence.
Any objection? No, Your To be admitted?
Permission to publish?
You may.
Okay, so we looked at the hallway, we went into the master bedroom, we went into the twins' room, to Javante's room, which is across from the hallway bathroom. And what are we looking at here in 57A?
It's a photograph of the hallway bathroom, looking in from the back of the hallway. The back of the hallway, I'm sorry, in the living room area.
Okay, and in 57B?
This is an area of suspected blood that was on the door frame of that hallway bathroom.
And did you take a swab of that blood?
Yes, ma'am, I did.
I want to turn your attention to States 58. Do you recognize States 58?
Yes, ma'am.
And what do you recognize States 58 to be?
That is the swab of suspected blood that I took from that area.
And is that swab and the packaging in the same or substantially the same condition as when you impounded it?
Yes, ma'am.
This time I'd move 58 into evidence.
Any objection? No, Your Honor. 58 will be admitted.
I also want to ask you about one item that we saw in 57A. I apologize. Looking here at this rug, what do you see on the rug?
There was an area of suspected blood on the rug that I evidence markered and later took a swab of as well.
Okay, and States 59, do you recognize it?
Yes, ma'am, I do.
And what do you recognize it to be?
That's the swab of the suspected blood I took from the rug in that common area bathroom.
And is it in the same or substantially the same condition as when you placed it into evidence?
Yes, ma'am, it is.
This time I'd move 59 into evidence.
Any objection? No, Your Honor. To be admitted.
And this is right across from where you found that lamp, correct?
Yes, ma'am.
All right, what do we see here in the bottom of the photo? Oh, sorry. I can see it, you can't. What do we see here in the bottom of the photo?
That's the pink slipper that was located just outside of the bathroom.
Does that appear to be a child's slipper or a grown woman's slipper?
It was a very small slipper.
Looking in the bathroom, 57C, did you collect any items of evidence from the sink faucet area?
I did.
And what was that?
I collected swabs of the sink faucet itself, and there was also suspected blood located inside the sink.
Okay, and I want to turn your attention to State 61.
Yes, ma'am.
Do you recognize State 61?
I do.
And what do you recognize it to be?
This is a swab of the sink faucet handle that I collected from the bathroom.
And is it in the same or substantially the same condition as when you impounded it?
Yes, ma'am.
This time I move 61 into evidence.
Any objection? No, Your Honor. Did we skip 60?
I'll come back to it.
Okay. Just want to make sure I was. Didn't miss it.
Yes, sir. Oh, and I also wanted to ask you 57C, what position is the toilet in right now?
Both of the seats are up.
Was it in that condition when you found it?
Yes.
All right. Looking at 57D, I want to talk to you about the evidence that you collected from the bathtub itself and from the children.
Okay.
From the child with the white sandals, did you collect any evidence from any clothing on her person?
I collected a swab of her left hand that was sticking out of the bathtub. You can see it on the soap bar there.
Okay. And the hand that we're talking about is right here?
Yes, ma'am.
Okay. And what about any other items that she was wearing?
All of her clothing was collected at autopsy, but there was nothing else that I collected.
Okay.
Off
And
of her.
what about here in the bathtub? Did you collect any other items of evidence from the bathtub?
I did. I swabbed several areas of the bathtub, the faucet, the handle.
Do we see that here?
Yes, ma'am.
Okay, and where else?
There was also the grab bar. I called it a grab bar. I wasn't sure. Here in the bathtub as well.
Okay. And did you take a couple of perspective shots? I don't want to spend up. This is where her hand was resting.
It was.
Okay. And then looking at this portion where the grab bar is, what do we see here?
That was an area of suspected blood that I located just above that grab bar handle that I photographed and documented and collected a swab of as well.
Okay. And in 57G?
That's a picture where I actually put a scale into that area of the suspected blood before I swabbed it.
All right, so I want to first ask you about State's Exhibit 60.
Yes, ma'am.
Do you recognize State's Exhibit 60?
I do.
What is State's Exhibit 60?
This was a swab of the left hand of the young lady I took in the bathtub.
Okay, and did you label that swab as child with white sandals?
I did.
Okay, and is that because the child with white sandals was the child that was on top?
Yes, at the time we didn't know which one of the girls was on top, so we just documented.
Welcome back to the LawNewz Network, everybody. You're listening to coverage of the trial of Henry Segura in Florida. He's a defendant facing the death penalty on 4 first-degree murder counts. And we've got to refresh the feed. It's going a little bit slow right now, so we're sorry about that. Ultimately, a sad case because there are 4 victims here. The defendant's girlfriend, 2 6-year-old twins, and a 3-year-old child. So, you know, we talked about this a little bit before, Deborah, but we've got children involved here, and then you've got this other bizarre twist of another prison inmate saying he's really the one involved. You know, but I'm hearing that we've got it back now, so let's listen back in.
Yes, ma'am.
This time I move 63 into evidence.
Any objection? No, 63 will be admitted.
Okay. And 64, you told us you took a swab of the toilet. What area of the toilet did you swab?
For 64, it was the bottom lip to the toilet seat.
Okay, and is that swab in the same or substantially the same condition as when you impounded it?
Yes, ma'am.
This time I move 64 into evidence.
Any objection? No, you're be admitted.
Did you take any other swabs of the toilet?
I did, of the flush handle where you flush.
Okay, and is that State's Exhibit 65?
Yes, ma'am, it is.
Okay, and is 65 in the same or substantially the same condition as when you impounded it?
It is.
You showed us the suspected blood on the back of the tub, on the wall of the tub. Is 66 that swab?
It is, yes, ma'am.
And is that one in the same or substantially the same condition as when you impounded it?
It is.
I want to go back
So we
to,
have 62, 65, and 66 outstanding.
I'd move 62, 65, and 66 into evidence.
Is there any objection? No. They'll be admitted.
Okay. Moving on to 67. What did you do as far as processing that common bathroom, the door of that bathroom?
I collected sterile swabs of the exterior and interior door handles of that hall bathroom.
Okay, and what about the light switch? Did you take a swab of that as well?
I did.
Okay, and 67, 68, and 69, do you recognize those items?
I do.
And what do you recognize those items to be?
These are the swabs of the exterior and interior door handle and the light switch of the hallway bathroom.
And are they in the same or substantially the same condition as when you impounded them?
Yes, ma'am.
Did you also look for, I moved 67 through 69 into evidence at this
Any
time.
objection? No, Your Honor. They'll be admitted.
Okay. Did you also look for the latent fingerprints we talked about earlier? Did you also look here in the common bathroom for those?
I did.
Okay. Did you find any latent fingerprints?
I did.
Okay. Where were they?
There were several latents located in the bathtub area on the faucet and the wall, that back wall of the bathtub area.
And just because you find a latent fingerprint, I think you talked to us a little bit about, or talked to us about this earlier a little bit, but just because you find a latent fingerprint, does that always mean that it is suitable to compare to known fingerprints of a person?
No.
Why not?
Well, what we do is we collect anything that we see essentially with any kind of ridge detail. All of the fingers and palms and the soles of your feet and your toes contain ridge detail. If you kind of look closely, it's for gripping mechanisms for us as humans. And so we look when we process for fingerprints, we're looking for ridge detail. So I processed the whole scene, and any kind of ridge detail I found was collected, and then you actually take a microscope and look under, or a magnifier glass, to determine whether or not they're of value for comparison. And what that means is sometimes you can have some friction ridge detail, that there's just not enough information for you to come to a determination that it is or isn't somebody. So at the time, I collected anything that I noticed that had any kind of ridge detail or looked anything like a fingerprint. And when we got back to the forensic unit, and they were actually looked at and determined some of them were not of value and some of them were.
Did you find any latent fingerprints of value in the common bathroom?
Yes, ma'am.
Where was it located?
On the faucet in the bathtub.
Okay. Were you able to try to compare that fingerprint to Brandy Peters' fingerprints?
The fingerprint was compared to Brandy Peters' palm.
Okay, and what were the results?
An identification was made, and I verified that identification.
Okay. How did you do the comparison?
It didn't do the comparison.
Oh, I'm sorry. You verified the comparison.
Yes, ma'am.
Okay. And how was the comparison done? By looking at that ridge detail?
Yes, ma'am. You had, in this particular case, we had Brandy Peters standards. So you had Brandy Peters' palms, and you compared the palm. It was a palm. So you had her palm and the latent, and you go back and forth to determine if all of the information in that latent matches the information in her palm, and all of it did.
And fingerprints are unique to each individual person, even twins. They have their own fingerprints, correct?
That's, so far, no one's been able to find two people with the same fingerprint.
Okay. So the only latent fingerprint of value, the only one that you found that could be compared to anyone else, was a match for Brandy Peters, who lived in the home.
The one in the bathtub was, yes, ma'am.
Okay, thank you. All right, I want to move on to states 70A through TTT. If you'd look through those exhibits and let me know if you recognize them.
Why don't we take a short break here? Make sure, keep everybody attentive. Let's take I know 10 minutes is probably about the least we can do, get in and out of the bathroom. So we take 10 minutes. Either side, do you think?
No.
Welcome back to the Law News Network, everybody. Aaron Keller along with you for the remaining time we have this afternoon, along with Deborah Blum, criminal defense attorney, Law News trial analyst. And we're listening to this case out of Florida that we started to talk about a little bit earlier. Sad case because we've got 3 kids as victims, first-degree murder charges, and there's this weird twist that this other inmate in prison claims, oh yeah, I'm the one that set out a hit on the mother because she owed this huge drug debt. The judge said the guy was talking hooey and that it was nothing and didn't even want it to come into trial, but eventually ruled that that testimony gets to come in because the defendant can defend himself.
Well, the jury has a right to hear about it, and then they can make a determination whether they believe that individual, whether he actually ordered the hit. But there are further twists and turns in this case. There's also DNA evidence that was found at the scene of the crime and wasn't told to the defense for over 2 years. So the defense is clearly going to argue that the prosecution here, or that the police botched their investigation and were hiding information from the defendant that potentially could exonerate him from this crime. And that's also going to go to the defense's theory that the prosecution narrowed in on their client and they didn't follow up on viable leads. And in this case, it really does make sense that it could have been somebody else. This woman is a known drug pusher, meaning she moves the drugs. She's a transporter. So she supposedly was skimming drugs from the shipments that she was supposed to be moving, and that really upset the cartel that she was working for. First, it was reported that it was a small amount, and then it became a greater amount. So I work with people that are in this business, and that is something that completely makes sense to me, that if somebody is skimming from the shipment, they could lose their life. So it's totally possible that somebody from the drug cartel ordered a hit on her. And, you know, there's also, I believe I read, that 2 other individuals admitted to perpetrating the crime here. So there's a lot of reasonable doubt. And what we were just hearing, it doesn't sound like to me that this accused defendant, his DNA is going to show up on any of the bodies. The person that just testified to having a positive blood sample for Brandy Peters, but maybe it's going to come tomorrow. I don't know if there is going to be a positive blood identification for Segura or any DNA evidence.
So apparently the trial is on break for a little while, and while we wait for them to come back, I want to listen to some of the prosecutor's opening statements from this morning in case you missed them.
Around 4:30 in the evening. Now we have the undigested food that would have, or that was eaten within the past 3 hours. And then you take another look back at home, and you see over here where somebody was in the process of eating something. So you take all that into context, and you sit down and you think about what it is that normal dinners and things are eaten between the hours of 5, 6, 7, 8 o'clock in the evening. And all that adds up and is being consistent with the murders occurring between those hours that we talked about, between 6:53 and 8:21. So now they've established when they believe the murders occurred. They've established communication at what Brandy's doing. They've gone out and they've done this. And they start looking towards how are we going to apply this. And of course, as we talked about during jury selection, motive. Who had a reason to do this? You're going to hear investigators talk about the training that they have, and one of the main things and some of the things that they look for as it relates to this, as we already talked about, the wounds are very personal. So as it relates to the motive, one of the things they know through their training and experience is that many, many times these things come down to a couple some way, shape, or form is usually connected to these. So they start looking for what that motive would be. What they're also going to look for is means. Who's got the ability to carry out something like this? One you would think you're going to hear from Dr. Flanagan is one of the wounds in the forehead area on Brandy Peters was she was hit so hard it actually crushed the skull. And she was hit repeatedly over and over and over. But because of that hit on your skull, somebody who did it had to have a lot of strength. Had to be really, really strong. The other thing you're going to hear from is Florida Department of Law Enforcement, Jeff Foggy. Jeff Foggy is now an agent. Back then he was a firearm analyst for many years. You heard that we actually recovered projectiles, which are the spent bullets, from the scene. We found one in the bathroom, or actually two in the bathroom, one in the hallway closet. Also, during the autopsy, other projectiles were removed actually from Ms. Peters. She was shot multiple times as well as beaten. The gunshot injuries were not the cause of the death, however. However, they were the cause of death. What you're going to hear is that so they start looking for these questions. And of course, the other thing they do is they look for who had the opportunity to do that. Who had access to the house? Who was there? Remember, there wasn't a forced entry at this home. So who would have been let in? Someone they knew? As I said, you were going to hear from Foggy, Jeff Foggy, that the gun that was utilized, the projectile, were 32 caliber. Now, the interesting thing about 32 caliber is apparently there are two different kinds of bullets that can be used in a 32 caliber pistol. And it's a pistol round, it's not a rifle round. And if you use the wrong one, it actually doesn't work like it's supposed to. What happens is, and he can explain this a lot better, but essentially what happens is the bullet doesn't get the velocity and the energy that is usually you think of when it comes to firearms. And as a result, it doesn't have the power that it's supposed to. And what you're going to hear is with Brandy's injury, that she was actually shot one time in the head and it never pierced her skull. And as I said, none of those injuries, or gunshots, were the cause of her death because they didn't do enough damage. You're actually going to see photographs from the scene that show where a bullet basically bounced off one of those thin rails that are on shower stalls. It hit it, made a small dent, and bounced down to the ground. You're going to see another one where it hit a porcelain toilet and bounced onto the ground. So these were, even though they were gunshots, they didn't have any power behind them for whatever reason. So one of the things law enforcement officers do, of course, they've established that these are the kind of things we need to know in order to figure out where this investigation is going to go. Now what you're going to hear is that one of the first things they do is they're actually notifying Henry Segura of the death of his son. They know that Javante Segura is Henry Segura's son. They haven't heard from him. So law enforcement officers have to notify somebody. Tell them. Your son passed away. And you're going to hear, of course, that law enforcement officers, when they do interviews, and this would apply no matter whether the person's a suspect, just a person that's a witness, or whatnot. And at the time, Mr. Segura was not a suspect in any way, shape, or form. This is for the purposes of letting them know about his child. This is for the purposes of going back and talking to family members, known acquaintances, getting that information they need from Brandy to figure out who might have done this, figure out who Brandy Peters was. That was the purpose behind this. So they're asking them questions. But of course, law enforcement are trained. look for verbal and nonverbal cues. Not only what they say, but how they say it, their posturing, things along those lines that might give an indication about whether the person's truthful or not. They look for whether the person has emotions or lack of emotions when they're telling certain information. They look, of course, for whether they're being deceived. And ultimately, they apply their investigative tools, the education they receive, their common sense, and those tools that they utilize day in and day out. And you're going to have an opportunity to see this initial this interview. And what you're going to see is Mr. Segura has a lack of emotions when he's told about the child. And us. Mr. Segura says, I was at home on the 19th during the time period. Just check my phone records. It'll tell you I'm home. Here's my phone number. 509-8380.
Looks like the judge is just about to go back on the bench in the Segura trial in Florida. Again, this is the first day of the trial. Opening statements were this morning, and we've had a number of witnesses on the stand this afternoon. The one that was on the stand just moments ago, before the court took about a 10-minute break, was talking about blood spatter evidence that was examined in at the crime scene. So again, it's a death penalty case with 4 victims, including the defendant's girlfriend. Let's listen in.
Part of the record, make that part of the court file, please. All right, let's have a jury, please.
Your Honor, beforehand, we anticipate this will be the last witness of the day.
Yeah.
Okay. Your Honor, that record, please. Jury in the courtroom.
Everybody be seated. You may proceed.
This time, I'd ask to publish 70A through FFF. Okay, so moving on from the hallway, moving on from the common bathroom, the hallway bathroom. What do we see here in 70A?
So it's still a picture of the very end of the hallway where the lamp was located, and to the left of it is actually the living room area. So I'm going into the living room.
I'm looking at 70B.
I'm actually standing in the dining room area, so it's showing the couches that's separated into a living and dining area, in that living area.
70C.
Is a different angle where I'm actually standing in the living room and taking a picture towards the hallway.
In 70D.
There's another picture of the side of the living room area facing towards the front door.
Now, were there any items of evidentiary value that were found over here towards where the artificial tree and mirror are?
There were, yes ma'am.
And what was that?
There was a suspected bullet hole, or an indent of a bullet in the wall area. It was a lower wall area here. And a projectile was located on the floor in that rug area over here.
I'm looking at 70E. What do you see here in this photo?
This is a photograph I took of the suspected indent of the bullet right here.
Okay. And can you show us where in 70D or about where that is?
It's in this area over here.
And is this that 70F, is that the indentation from the side angle?
It is. The indentation is actually over here.
And in 70G, is this the indentation after you put an evidence marker on it?
It is.
And the indentation a little closer?
Yes, ma'am.
So the bullet that hit this wall, it didn't go through the drywall. It penetrated it a little bit, ricocheted off.
It appeared to, yes, ma'am, because I found the projectile on the carpet.
Okay, and in 70H, what does this show?
That's showing the evidence marker 38 where I actually located the projectile.
And where was the projectile found?
That's it right there.
Okay. And did you collect the projectile?
I did, yes, ma'am.
Can you find state 71 in your notebook, please?
Yes, ma'am.
And do you recognize state 71?
I do.
Is state 71 in the same or substantially the same condition as when you impounded that package into evidence?
It is, yes, ma'am.
This time I would move 71 into evidence.
Any objection? No. Be admitted.
Okay. And permission to publish 71?
You may.
Could you open 71 for us?
Yes, ma'am.
Looking at 70I. What do we see in 70I?
It's a picture I took of the living room area that's showing part of the foyer and front door area.
And what do you see on the couch?
There were items, children's items, children's books, and there's also a child's shoe on the floor. What I located was a large area of what I appeared to be suspected blood on this middle cushion right here, so I'm working my way into the photographs to show that suspected blood.
In 70J?
Is a different angle of that same couch area that's showing all the children items on the floor and to the side of that cushion.
And the children items looks like a Spider-Man backpack, a slipper, a pencil case, and a book up here.
Yes, ma'am.
What do we see in 70L?
It's a closer up image of the suspected blood area that I found on the cushion. That's that middle cushion in the couch, and this was the area. They took several pictures of it. It was hard with the black leather for it to show, but you can see some of the area there.
And on 70M, what do we see in 70M?
I put a scale onto that couch cushion, and that's a picture of the scale that I put in the photograph.
Okay, and that scale marks where the suspected blood is located on the couch?
Yes, ma'am.
And it's black, it's kind of hard to see.
Yes, ma'am.
And that's the children's book we were talking about right next to it?
Yes, ma'am.
Okay, what about 70O?
It's just another picture where I'm standing in the dining area, taking a picture on the side of the living room, but going towards the foyer.
And the couch that's closest to us right here, that's the couch that you took the swab of suspected blood off the cushion from?
Yes, ma'am.
And where the children's book is located?
Yes, ma'am.
Okay. And where would the projectile be if we're looking at it from this angle?
The projectile, the indent on the wall, the projectile was on the floor here, and the indent on the wall is over here.
Okay. And if we're facing the mirror in this photo, turning to the left, what part of the house are we looking at now?
This is towards the front entry door. This is actually the front entry door to the home, and that's the foyer area.
And this is one of the last areas that you processed in the home?
Yes, ma'am, aside from the kitchen.
All right, looking at the foyer, did you try to take several pictures to try to capture every wall or every part of the foyer?
Oh, I did. Yes, ma'am.
Okay. What do you see here in 70Q?
I'm just documenting the damage to the door, the window area to the door, and all of the blood spatter. Well, trying to get around all the different areas of the foyer area.
Okay. In 70R, trying to get a photo of more of the door, less of the wall in that photo?
Yes, ma'am. Just working my way around that area.
Okay, and the way we see Miss Peters in this photo, that's the way that you found her that day?
I can't see her. I'm sorry.
I'm sorry.
Yes.
All right, in 70S, what do we see in this photo?
It's just a photograph showing that there were items on the floor near her body as well. There appeared to be a tree, a fake plant that was toppled over. There's a shovel in the picture as well, and just her body.
Okay, what do you see next to the shovel?
I believe that appears to be hair. I don't actually know for sure.
Okay. Looking back on some of our items of evidence, can you locate state 72?
Yes, ma'am.
Okay, and what is state 72?
That's a swab of the suspected blood I took from the cushion, the middle cushion on the couch in the living room area.
Okay, and is that swab in the same or substantially the same condition as when you impounded it?
Yes, ma'am.
Right. And that was the suspected blood right here next to the book on the couch?
Yes, ma'am.
All right. This time I move state 62 into evidence.
72.
72 into evidence.
Any objection? No. 72 will be admitted.
All right, and in 70T, what do we see in the foyer now?
The foyer, we have removed Brandy Peters' body, and you can see there's just the suspected blood areas all in the foyer area, and there's also scales that I have laid down of where I was going to collect evidence in these sections.
Okay, and how were her and the children's bodies removed?
The children's bodies, myself and my supervisor, Joanne Maltese, from the bathtub, we started by taking a temperature of the bathtub before we disturbed the bodies at all. So I did a temperature reading of the bathtub. I took a water sample of the bathtub as well, and then individually we took each, for the children, we took the children out one by one and put them in a sterile body bag. And then we moved them into the dining area because it was one of the areas where there didn't seem to be any suspected blood or evidentiary value that we collected. So that's where we photographed them and documented the children. We did the same for Brandy Peters. I took a gunshot residue test kit of her hands while she was in the foyer, but there was extensive damage to her face and her hands, and I wanted to be able to collect swabs of her hands and scrapings of her nails, and we didn't want to disturb the foyer area. So myself and forensic specialist Vernon Henderson moved her body as well. We lifted her and put her in a sterile body bag and moved her into the dining area where I processed her hands.
So we heard that you took a couple of measurements of that tub and of the water from that tub both before and after the children were in it?
Yes, ma'am.
All right. And then you said you also did a gunshot residue test on Ms. Peters on her hands. What is a gunshot residue test or a gunshot residue kit?
It's tubes that they have that the Florida Department of Law Enforcement gives us because they test it for gunshot residue. We don't actually do it at the police department. And so it's 2 little tubules. It's basically just kind of sticky material that we put on the front and the back of each hand, and it's supposed to collect any gunshot residue that should be left over if you fired a gun recently.
Moving on to some of the swabs that you collected from the living room.
Okay.
Looking at State's Exhibit 70U, is this another photo of the ground in the foyer after Mrs. Peters' body was removed?
Yes, ma'am.
All right. And this is kind of when you guys begin trying to swab the different areas of the blood?
Yes.
What do you see here on the wall and in the on the bottom of the door?
Just lots of suspected blood.
Okay. And some glass over here?
Yes, ma'am.
70B, is this the wall and the door?
It is. It's just higher up.
Okay. 70N?
Is going further up because there was suspected blood spatter all the way up into the window area above the door.
What about 70X?
This is a swab of one of the areas of blood that I located on the carpet, and that's just right outside the foyer area. That was near the tree that had fallen down in the living area.
Okay, I want to take you back to State 70S. Can you show us on this picture where the area of blood spatter that you swabbed is?
It's this area.
Okay. And so 70X is kind of an up-close view of that area.
Yes, ma'am.
All right. And this is your marker after you swabbed it?
It is. Prior to swabbing it.
Prior to swabbing, I apologize. All right, so looking at State 73, do you recognize State 73?
I do.
And what do you recognize State 73 to be?
This is a swab that I collected in the photograph that you're looking at.
And is 73 in the same or substantially the same condition as when you impounded it?
It is.
This time I would move 73 into evidence.
Any objection? No, Your Honor. 73 will be admitted.
All right, what do we see in 70Y?
That's another item of suspected blood that I swabbed that was near the foyer area in the hallway, or not the hallway, I'm sorry. It's just the tile here in the foyer, and it's the carpet right outside of the foyer.
And is this area closer to the tile than the previous one was?
It is.
Well, what do you do when you have a crime scene to process in a foyer like this where there's so much blood spatter?
We document it all as best we can. Essentially, there was so much injury to her body, and you handle blood spatter in different ways depending on the crime scene you have. For the most part, we believed that all of this blood came from her. There's different types of scenes where you could have, if you know, like a suspect had shed blood or things like that in different areas where you could tell that it could be a different person. In this particular area, in this particular case, it appeared that all of the spatter and the blood came from Miss Peters.
Because of the extent of her injuries?
Yes, ma'am.
And so I guess, did you just try to get a swab from each area of the foyer?
I did, yes.
All right, so looking at state 70Y, do you have a corresponding swab there in your notebook for this one? If you could turn your attention to state 73.
I do, yes, ma'am.
Okay, and looking at state...
It's 74.
Oh, I apologize, state 74, thank you.
Yes.
And is 74 in the same or substantially the same condition as when you collected it and impounded it in evidence?
It is.
This time I would move 74 in evidence.
Any objection? No, Your Honor. 74 will be admitted.
What do we see in state 70Z?
This is a photograph of one of the several blood areas in the foyer. So it's actually a photograph of the tile in the foyer area after we removed Miss Peters' body. And the scale that I have in there is my evidence marker for a swab that I collected of that generalized blood area.
Okay, and looking at state 75, what do you recognize 75 to be?
That is the swab of the tile that I collected. The swab of suspected blood on the tile.
And is it in the same or substantially the same condition as when you impounded it?
Yes, ma'am.
Move state 76 in evidence and 75 in evidence?
Any objection, 75? No, Your Honor. 75 will be admitted.
Looking at 70 double A, what do you see in this photo?
It's a photograph of me standing in the dining room looking into the foyer area with a shovel in there and the tree as well.
And what did you do with this shovel?
The shovel I collected as evidence, and I also collected a swab of the handle of the shovel.
Okay. And I want to turn your attention to states 77. Do you have 77 there in front of you?
I do.
And what is 77?
It's a swab of the handle of the shovel that I took.
Does the swab of the handle of the shovel appear to be in the same or substantially the same condition as when you impounded it?
Yes, ma'am, it does.
Move 77 in evidence.
Any objection? No, Your Honor. 77 will be admitted.
And I want to now turn your attention to state 76. What is state 76, that large object?
This is the red shovel that I collected from the living room area.
And if you could open it for us, let us know if the packaging and if the shovel itself appears to be the same as it did when you collected and impounded it.
It appears to be in the same condition I found it.
I would move states 76 into evidence. I'm going to say 76 in evidence.
I'm sorry.
I'd move state 76 in evidence.
Any objection? No, Your Honor. 76 will be admitted.
And permission to publish. You mentioned that you swabbed the handle of that shovel. Did you see any suspected blood anywhere on the shovel?
No, I didn't. There didn't appear to be any blood on the shovel at all. We just did it as a precautionary measure before I collected it.
And that's on the handle or on the actual spade, I guess, itself?
It was the handle, the black part that you grabbed was where I swabbed it.
Okay. Did you see any suspected blood anywhere else on the shovel?
Oh, not at all on the shovel.
Okay. Or on the handle?
No, ma'am.
Okay. All right, moving on to state's 70cc. What do we see in this photo?
This is another photograph of the foyer area. It was taken after the foyer was processed with a chemical, leucocrystal violet.
What's the name again?
It's leuco, I believe it's LEUCO.
What is leucocrystal violet? What does it do?
It's a chemical dye stain that reacts to the hemoglobins in your blood. My supervisor, Joanne Maltese, processed that area as well as the exterior of the home, the front exterior of the home with the chemical.
Okay, so she's the one that put the leucocrystal violet on there, but you were present when she did it.
I did, and I documented with the photographs. I'm sorry.
And again, this photo shows the entire ground of the foyer with the reagent as well as the areas that you swabbed?
Yes, ma'am.
Okay. All right, looking at 70DD, what do we see here?
This is after I processed the interior. This is the interior front door area. This is the broken window next to the door, or the broken glass area. So what we're looking at is after I processed that door for latent fingerprints, I was using black powder, bichromatic powder, and these were the results from the door. So, excuse me, I actually collected, I took a lift of this and photographed it ahead of time to show the area that I was lifting.
Okay, and 70EE, is this part of the tile after the reagent was applied?
It is.
Okay. We see that some measurements have been taken in different areas with some type of pattern. And you saw that there on scene that day?
I took the photograph, yes ma'am.
Okay. Could this be from like a shoe that had walked through the scene?
I wasn't quite sure what it was. Originally, you can see just generally from where her body was, a lot of the areas in that foyer were just kind of smudged around, and it was very dark. So there wasn't any kind of pattern area. And this specific area here, I just documented it because there is some kind of pattern, and I didn't know what it was. But once you leave your crime scene, you kind of lose all of that evidence. So we took it. I took the photograph just to document it in case any time later it needed to be processed or try to determine what it was.
Can you say what it is at all?
No, ma'am.
Okay. Looking at 70GG, do you see several of those different patterns throughout the foyer?
I'm sorry, I
Do you
didn't.
see several of those different patterns and spots around the foyer?
There's just little sections, yes ma'am.
Okay. And you guys all processed this after officers came in, discovered her body, cleared the room, came through the foyer, correct?
Yes, we didn't, they did the entry to the house prior to us even being called to the scene.
Okay. I want to move on to state 70HH. What do we see in 70HH?
These are, that's my evidence item marker, 117. This was it's a row of gold teeth that I located on the floor in the foyer area that I believe belonged to Mrs. Peters.
And did you actually impound those teeth?
I did. Yes, ma'am, I collected them.
Okay, I want to turn your attention to 78, state 78.
Yes, ma'am.
What is 78?
These are the metal teeth that were taken from that foyer area.
And are they in the same or substantially the same condition as when you collected and impounded them?
They are.
This time I moved 78 into evidence.
Any objection? 78 will be admitted.
And looking at 70II here, is this an up close of those teeth that you found?
It is, yes. Excuse me.
What do we see here in 70JJ?
So these are two other evidence markers that I put down. And in this particular area, there's a gold tone earring that I found on the floor. And over here was a piece of a acrylic fingernail that I collected as well.
In 70KK, a closer view of the earring?
Yes, ma'am.
Did you actually collect the earring?
I did.
Do you recognize date 79?
I do.
And what is 79?
That's the earring that I collected.
Is it in the same or substantially the same condition as when you collected it?
It is.
This time I moved 79 into evidence.
Any objection? No, Your Honor. 79 will be admitted.
In 70LL, what do we see here by your evidence marker?
This is the acrylic piece of nail that I located and collected that was on the ground in the foyer area.
And did you actually collect the acrylic nail as well?
I did.
The acrylic nail states Exhibit Exhibit 80. Do you recognize it to be in the same or substantially the same condition as when you encountered it?
It does.
This time I move 80 into evidence.
Any objection? No, Your Honor. 80 will be admitted.
What do we see here in 70NN?
This is the side of the foyer wall. If you're inside of the house facing the front door area, it's the right side. And after we did the chemical reagents and collected different areas of the suspected blood, I used yellow measuring tape. It's sticky tape that does measurements to go up along all of the walls in the foyer area in case any kind of blood spatter analysis needed to be done at a later date. So that way we could document the scale of the wall and they could determine how high up and how far over with different lengths. So that's my documentation photograph.
And in 70NN, did you try to do that for every wall and the door?
I did, just because of the massive amount of blood spatter that was in that area. I documented all three of the walls with the scales in all three of the walls.
What type of processing did you do to the front door handle and lock?
I collected swabs of the front door handle.
Can you turn your attention to 81 and 82? What are State's Exhibit 81 and 82?
They are swabs of the interior, the front door handle, and of the deadbolt area.
And are they in the same or substantially the same condition as when you encountered them?
Yes, ma'am, they are.
This time I move 81 and 82 into evidence.
Any objection? No, Your Honor. 81 and 82 will be admitted.
And those swabs were taken from the deadbolt and the handle we see here in this photograph?
Yes, ma'am.
From the interior of that door?
Yes, ma'am.
I want to ask you about 70 SSS. What do we see here?
It appears to be a lot of the suspected blood spatter on the wall. If you're facing the door, it's to the left because of the light switches right here. Okay. And I have a scale that I placed in that area where I took a swab of suspected blood from that section.
So that was the area, that was the swab from this area that you chose to, I'm sorry, that was the suspected blood from this area that you chose to swab?
Yes, ma'am.
Okay, and is this an up-close view of that swab, of that suspected blood?
It is.
And can you turn your attention to 83, State's 83?
Yes, ma'am.
Do you recognize State's 83?
I do.
And what is it?
That is the swab that I collected from the wall in the photograph there.
And it's in the same or substantially the same condition as when you impounded it?
It is.
At this time I move 83 into evidence.
Any objection? No. 83 will be admitted.
What do we see in 70 PP?
That's the front door area, and there's also a scale in that area of the suspected blood that I was taking for the sample.
And is this an up-close view of that marker?
It is.
states 84. Can you tell us what 84 is and whether it's in the same condition as it was when you impounded it?
States 84 is the swab that I collected from that section in the front door, and it is in the same condition. It appears to be in the same, or mostly the same condition.
Move 84 into evidence.
Any objection? No, Your Honor. 84 will be admitted.
All right, and looking at 70RR. What do we see in this photo?
This is the right side wall again, but it's documenting the scale that I put in that shows the area of suspected blood that I swabbed.
Okay. And is 70SS an up close view of that swab?
It's a closer in image, yes ma'am.
Closer. The next one, even closer?
Yes.
Even closer?
Yes.
Okay. And I want to turn your attention to 85. Do you recognize 85?
I do.
And what do you recognize 85 to be?
That is a swab of the photograph on the wall that I collected of the
It's in the
suspected
same
blood.
condition as it was when you impounded it?
It is.
And move 85 into evidence?
Any objection? No, Your Honor. 85 will be admitted.
86 through 88 will be through our next witness. So moving on to 90. Looking at 90, what do you see here?
That's the exterior of the home. That's the front door, the outside of the front door area.
And did you collect any evidence from the front door handle of the home?
I did. I collected a swab of the front door handle.
Can you find State's Exhibit 90?
Yes, ma'am.
And what is State's 90?
That is a swab of the exterior front door handle that I collected.
Is it in the same or substantially the same condition as when you impounded it?
It is.
Move State's 90 into evidence?
Any objection? No, Your Honor. 90 will be admitted.
Okay, 70 VV, another view of the door.
Yes, ma'am.
Was there any suspected blood on the door?
There is. It's kind of a little blurry.
Let's try
I was saying it was a little blurry. I thought you were going to ask me to.
the 70XX, the closer
Okay.
view.
Yes.
And this window that's busted out, did you photograph the glass on the ground?
I did.
Okay. What else is on the ground besides glass?
There appears to be suspected blood as well in the areas here, as well as over here and there.
And did you swab suspected blood both from the front door, the exterior of the front door and on the ground outside the front door?
I did.
All right, looking at 70YY, what is 70YY?
That's the swab of the suspected blood I took on the exterior of the front door.
Okay, can you find State's 91 in your notebook, please?
Yes. That is the swab of blood that I took from the exterior front door.
And is it in the same or substantially the same condition as when you impounded it?
It is.
Move 91 into evidence.
Any objection? No, Your Honor. 91 will be admitted.
Okay, looking at 70ZZ, what do we see here?
That's the scale, or the scale that I put in with the evidence number of the suspected blood swabs that I took, or the swab that I took of the ground outside of the front door area.
Okay, and do you have State's 92 there in front of you?
Yes, ma'am.
And what is State's 92?
It is that swab of the photograph, of the suspected blood in that photograph.
Does it appear to be in the same or substantially the same condition as when you impounded it?
It does.
Okay, looking at 70 AAA.
You wish to offer 92?
Yes, sir, thank you.
Any objection? No, Your Honor. 92 will be admitted.
70 AAA, what's happening here to the front door?
This just appears to be a picture of the front door open with after the leucocrystal violet has been processed with it as well.
And 70 BBB, y'all did the same measurements out here that you did inside the house?
On the foyer area, yes, I used a scale because there's suspected blood spatter on the side of the wall there, so I used the same measuring tape, the sticky measuring tape, to go around that area of the blood spatter.
70 CCC, what do we see here?
There's an evidence marker that I placed on the siding outside of the exterior door where all the suspected blood spatter was, and I collected a swab of the suspected blood.
Okay, so all of the marks we see here, those were all suspected blood?
Yes, ma'am.
Okay. And this is an up-close view in 70 DDD of the suspected blood that you swabbed from that sighting?
Yes, ma'am.
And can you turn your attention to States 93?
Yes.
What is 93?
That's the swab of the suspected blood on the siding right there.
Okay. Is it in the same or substantially the same condition as when you impounded it?
It is.
And I've moved 93 into evidence?
Any objection? No, Your Honor. 93 will be admitted.
I have two last photos for you. In 70 EEE, what do we see here?
This is in the daytime, and this is showing the scale that I placed over the blood spatter areas of the siding there by the front door. The front door is actually to the left of your picture. So when you're walking towards the front door, it's to the right if you're standing facing the doors. Oh, there you go. And so it's showing the scale of the area of the suspected blood that was located on that siding.
Were y'all able to process this entire scene in one day?
No, no ma'am.
Okay, what did y'all do when you left to go home every day to make sure that no one came in until you got back the next day?
The first day that I arrived on scene was earlier in the morning, and we left very, very late that night, and I evidence taped, you can actually see some of it here, every single door and window on the exterior of the home. I put evidence tape and initialed and dated it, and they had officers placed outside of the home overnight when we were gone, so that to make sure nobody else came in or disturbed the scene as well. And when I came back for the second time, I re-photographed all of the seals that were intact to show that nobody had entered the home through any of those areas, and took photo documentation to show that none of those seals were broken.
Okay. And all the seals were intact when you came back to the home?
Yes.
All right. Finally, looking at 70 FFF. So within these scales that show the height and the width of the blood spatter, we see some markings near your evidence marking. Did you make these markings?
I did not.
Okay, who made these markings?
My supervisor at the time, Joanne Maltese.
Okay. And around these markings, that's the blood spatter you talked about earlier?
Yes, ma'am.
And Your Honor, 94 is going to be in through our next witness.
Okay.
Would you like for me to move on to the next room?
Will that cover her testimony?
No, sir, we have a little bit more. I would say maybe about 1 more hour, 45 more minutes.
We're not going to finish her then. Let's hope we can finish her, since I know she's from out of town now. But anyway, maybe this would be a good time to take a break then. Does that suit the state?
Yes, sir.
Defense?
Yes, sir.
Okay. All right. You know what I'm going to say. Don't discuss the case with anyone. Don't read any media accounts. Don't let anybody talk to you about it. Let's keep everything good. 8:30 tomorrow morning. Come up here like you did after lunch. Don't give us a heart attack, and 8:30 no one be here, and we're wondering whether we've messed something up. If you have parking issues, take it up with the clerk. Well, is it a parking issue?
Question.
For the witness? Yeah, we'll take up questions at the end, so just leave it in your notes. And, we can't really do it in between. You got some smart, good attorneys here. By and large, they're going to cover everything, so give them a chance, and then if they've missed something at the end, we'll cover it with them. Okay? Anybody have any questions? What's expected of you? Just leave your notes where they are. They'll seal them up for the night. Have a good evening. was hoping we could finish it.
I think I did too much. Yeah, they didn't book my flight till tomorrow evening. So
What's that?
they didn't book my flight till tomorrow evening.
Oh.
So you got me all day.
Okay. Either side, have anything we need to take up?
No, Your Honor. There you go.
All right, we'll see y'all at 8:30.
You're sort of late. That's fine, yeah, I just don't want to leave them here. Do you want me to leave the pointers? And the scissors? This is trash. Just throw that out. So you want me to do the survey 30 tomorrow? Okay. Okay, and outside court, yeah, perfect. And there's the lamp still here.
Two copies of evidence. And you weren't talking about changing their numbers, are you? Okay. Oh, okay.
But now that I'm seeing sheets, trickle now letters.
So you were talking about the fifth? Okay.
It's the end of the day in the Henry Segura case out of Florida. That defendant facing 4 first-degree murder charges and possible death sentences related to the deaths of his girlfriend and her 3 children, ages 6 and 3. The 2 6-year-olds were twins. That case has been starting early and running late. The judge said he's going to try to wrap things up at 5 o'clock every day, but he did say he would run late because he doesn't want to just chip off testimony in an unnatural point. So we're planning to resume coverage of the Segura case tomorrow morning at 8:30. We also continue to watch the Joshua Gasper case out of Cleveland, Ohio. That defendant is accused of striking and killing an on-duty Ohio State trooper. The defendant says it was an accident. The prosecution there says the defendant was incapacitated, was intoxicated through the use of methadone, although the science doesn't necessarily seem to be supporting the prosecution's premise, at least at this point in the testimony. We here at the Law News Network on standard days are here from 9 until 5, but because of this Segura case, it looks like we'll be on the air early and staying here a little bit late as long as testimony warrants it. We appreciate you joining us today, and we'll see you back here tomorrow morning at 8:30 a.m.